Chapter 12, Part 1 of the Commentaries on the Laws of England, Book 2, by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Of Estates in Severalty, Joint-Tenancy, Coparcenary, and Common. Part 1. We come now to treat of estates with respect to the number and connections of their owners, the tenants who occupy and hold them. And, considered in this view, estates of any quantity or length of duration, and whether they be in actual possession or expectancy, may be held in 4 different ways: in severalty, in joint tenancy, in coparcenary, and in common. 1. He that holds lands or tenements in severalty, or is sole tenant thereof, is he that holds them in his own right only, without any other person being joined or connected with him in point of interest, during his estate therein. This is the most common and usual way of holding an estate, and therefore we make the same observations here that we did upon estates in possession, as contradistinguished from those in expectancy in the preceding chapter. That there is little or nothing peculiar to be remarked concerning it, since all estates are supposed to be of this sort, unless where they are expressly declared to be otherwise, and that, in laying down general rules and doctrines, we usually apply them to such estates as are held in severalty. I shall therefore proceed to consider the other 3 species of estates in which there are always a plurality of tenants. 2. An estate in joint tenancy is where lands or tenements are granted to 2 or more persons to hold in fee simple, fee tail, for life, for years, or at will. In consequence of such grants, the estate is called an estate in joint tenancy, and sometimes an estate in jointure, which word, as well as the other, signifies a union or conjunction of interest, though in common speech the term jointure is now usually confined to that joint estate which, by virtue of the statute 27 Henry VIII c. 10, is frequently vested in the husband and wife before marriage as a full satisfaction and bar of the woman's dower. In unfolding this title, and the 2 remaining ones in the present chapter, we will first inquire how these estates may be created, next, their properties and respective incidents, and lastly, how they may be severed or destroyed. 1. The creation of an estate in joint tenancy depends on the wording of the deed or device by which the tenants claim their title. For this estate can only arise by purchase or grant, that is, by the act of the parties, and never by a mere act of law. Now, if an estate be given to a plurality of persons without adding any restrictive, exclusive, or explanatory words, as if an estate be granted to A and B and their heirs, this makes them immediately joint tenants in fee of the lands. For the law interprets the grant so as to make all parts of it take effect, which can only be done by creating an equal estate in them both. As therefore the grantor has thus united their names, the law gives them a thorough union in all other respects. For 2. The properties of a joint estate are derived from its unity, which is 4-fold: the unity of interest, the unity of title, the unity of time, and the unity of possession. Or, in other words, joint tenants have one and the same interest, accruing by one and the same conveyance, commencing at one and the same time, and held by one and the same undivided possession. First, they must have one and the same interest. One joint tenant cannot be entitled to one period of duration or quantity of interest in the lands, and the other to a different. One cannot be a tenant for life and the other for years. One cannot be a tenant in fee and the other in tail. But if land be limited to A and B for their lives, this makes them joint tenants of the freehold. If to A and B and their heirs, it makes them joint tenants of the inheritance. If land be granted to A and B for their lives and to the heirs of A, here A and B are joint tenants of the freehold during their respective lives, and A has the remainder of the fee in severalty. Or, if land be given to A and B and the heirs of the body of A, here both have a joint estate for life, and A hath a several remainder in tail. Secondly, joint tenants must also have an unity of title. Their estate must be created by one and the same act, whether legal or illegal, as by one and the same grant, or by one and the same season. Joint tenancy cannot arise by descent or act of law, but merely by purchase or acquisition by the act of the party, and, unless that act be one and the same, the two tenants would have different titles, and if they had different titles, one might prove good and the other bad, which would absolutely destroy the jointure. Thirdly, there must also be an unity of time. Their estates must be vested at one and the same period, as well as by one and the same title. As in case of a present estate made to A and B, or remainder in fee to A and B after a particular estate, in either case A and B are joint tenants of this present estate or this vested remainder. But if, after a lease for life, the remainder be limited to the heirs of A and B, and during the continuance of the particular estate A dies, which vests the remainder of one moiety in his heir, and then B dies, whereby the other moiety becomes vested in the heir of B. Now A's heir and B's heir are not joint tenants of this remainder, but tenants in common, or one moiety vested at one time, and the other moiety vested at another. Yet, where a fiefment was made to the use of a man, and such wife as he should afterwards marry, for a term of their lives, and he afterwards married, in this case it seems to have been held that the husband and wife had a joint estate, though vested at different times, because the use of the wife's estate was in abeyance and dormant till the intermarriage, and, being then awakened, had relation back, and took effect from the original time of creation. Lastly, in joint tenancy there must be an unity of possession. Joint tenants are said to be seized per maieta per tu, by the half or moiety, and by all. That is, they each of them have the entire possession, as well of every parcel as of the whole. They have not, one of them a season of one half or moiety, and the other of the other moiety. Neither can one be exclusively seized of one acre and his companion of another, but each has an undivided moiety of the whole, and not the whole of an undivided moiety. Upon these principles of a thorough and intimate union of interest and possession depend many other consequences and incidents to the joint tenant's estate. If two joint tenants let a verbal lease of their land, reserving rent to be paid to one of them, it shall inure to both in respect of the joint reversion. If their lessee surrenders his lease to one of them, it shall also inure to both, because of the privity or relation of their estate. On the same reason, livery of season made to one joint tenant shall inure to both of them, and the entry or re-entry of one joint tenant is as effectual in law as if it were the act of both. In all actions also relating to their joint estate, one joint tenant cannot sue or be sued without joining the other. But if two or more joint tenants be seized of an advowson, and they present different clerks, the bishop may refuse to admit either, because neither joint tenant hath a several right of patronage, but each is seized of the whole. And if they do not both agree within 6 months, the right of presentation shall lapse. But the ordinary may, if he pleases, admit a clerk presented by either, for the good of the church, that divine service may be regularly performed, which is no more than he otherwise would be entitled to do, in case their disagreement continued so as to incur a lapse. And if the clerk of one joint tenant be so admitted, this shall keep up the title in both of them, in respect of the privity and union of their estate. Upon same ground it is held that one joint tenant cannot have action against another for trespass in respect of his land, for each has an equal right to enter on any part of it. But one joint tenant is not capable by himself to do any act which may tend to defeat or injure the estate of the other, as to let leases or grant copyholds. And if any waste be done, which tends to the destruction of the inheritance, one joint tenant may have an action of waste against the other, by construction of the statute Westminster 2, c. 22. So too, though at common law no action of account lay for one joint tenant against another, unless he had constituted him his bailiff or receiver, yet now by the statute 4 Ann. c. 16, joint tenants may have actions of account against each other for receiving more than their due share of the profits of the tenements held in joint tenancy. From the same principle also arises the remaining grand incident of joint estates, viz., the doctrine of survivorship, by which, when 2 or more persons are seized of a joint estate of inheritance for their own lives, or pour auter vie, or are jointly possessed of any chattel interest, the entire tenancy upon the decease of any of them remains to the survivors, and at length to the last survivor. And he shall be entitled to the whole estate, whatever it be, whether an inheritance or a common freehold only, or even a less estate. This is the natural and regular consequence of the union and entirety of their interest. The interest of 2 joint tenants is not only equal or similar, but also is one and the same. One has not originally a distinct moiety from the other, but if by any subsequent act, as by alienation or forfeiture of either, the interest becomes separate and distinct, the joint tenancy instantly ceases. But while it continues, each of the 2 joint tenants has a concurrent interest in the whole, and therefore, on the death of his companion, the sole interest in the whole remains to the survivor. For the interest which the survivor originally had is clearly not divested by the death of his companion, and no other person can now claim to have a joint estate with him, for no one can now have an interest in the whole, accruing by the same title, and taking effect at the same time with his own. Neither can anyone claim a separate interest in any part of the tenements, for that would be to deprive the survivor of the right which he has in all and every part. As therefore the survivor's original interest in the whole still remains, and as no one can now be admitted, either jointly or severally, to any share with him therein, it follows that his own interest must now be entire and several, and that he shall alone be entitled to the whole estate, whatever it be, that was created by the original grant. This right of survivorship is called by our ancient authors the jus accrescendi, because the right, upon the death of one joint tenant, accumulates and increases to the survivors. Or, as they themselves express it, parce illa communis accrescet superstibus, de persona in personam, usque ad ultinum superstitem. And this iusa accrescendi ought to be mutual, which I apprehend to be the reason why neither the king nor any corporation can be a joint tenant with a private person. For here is no mutuality, The private person has not even the remotest chance of being seized of the entirety by benefit of survivorship, for the king and the corporation can never die. 3. We are lastly to inquire how an estate in joint tenancy may be severed and destroyed. And this may be done by destroying any of its constituent unities. 1. That of time, which respects only the original commencement of the joint estate, cannot indeed, being now past, be affected by any subsequent transactions. But 2. The joint tenants' estate may be destroyed without any alienation by merely disuniting their possession. For joint tenants, being seized per maiete pertu, everything that tends to narrow that interest so that they shall not be seized throughout the whole and throughout every part is a severance or destruction of the jointure. And therefore, if two joint tenants agree to part their lands and hold them in severalty, they are no longer joint tenants, for they have now no joint interest in the whole, but only a several interest respectively in the several parts. And for that reason also, the right of survivorship is by such separation destroyed. By common law, all the joint tenants might agree to make partition of the lands, but one of them could not compel the others to do so. For, this being an estate originally created by the act and agreement of the parties, the law would not permit any one or more of them to destroy the united possession without a similar universal consent. But now, by the statutes 31 Henry VIII C1 and 32 Henry VIII C32, joint tenants, either of inheritances or other less estates, are compellable by writ of partition to divide their lands. 3. The jointure may be destroyed by destroying the unity of title. As if one joint tenant aliens and conveys his estate to a third person. Here the joint tenancy is severed and turned into a tenancy in common, for the grantee and the remaining joint tenant hold by different titles, one derived from the original, the other from the subsequent grantor, though, till partition made, the unity of possession continues. But a devise of one's share by will is no severance of the jointure, for no testament takes effect till after the death of the testator, and by such death the right of the survivor, which accrued at the original creation of the estate and has therefore a priority to the other, is already vested. 4. It may also be destroyed by destroying the unity of interest. And therefore, if there be two joint tenants for life, and the inheritance is purchased by or descends upon either, it is a severance of the jointure. Though, if an estate is originally limited to two for life, and after to the heirs of one of them, the freehold shall remain in jointure without merging in the inheritance, because, being created by one and the same conveyance, they are not separate estates, which is requisite in order to a merger, but branches of one entire estate. In like manner, if a joint tenant in fee makes a lease for life of his share, this defeats the jointure, for it destroys the unity both of title and of interest. And whenever, or by whatever means the jointure ceases or is severed, the right of survivorship, or jus accrescendi, the same instant ceases with it. Yet, if one of three joint tenants aliens his share, the two remaining tenants still hold their parts by joint tenancy and survivorship. And if one of the three joint tenants releases his share to one of his companions, though the joint tenancy is destroyed with regard to that part, yet the two remaining parts are still held in jointure, for they still preserve their original constituent unities. But when, by an act or event, different interests are created in the several parts of the estate, or they are held by different titles, or if merely the possession is separated, so that the tenants have no longer these four indispensable properties: the sameness of interest, an undivided possession, a title vesting at one and the same time, and by one and the same act or grant, the jointure is instantly dissolved. In general, it is advantageous for the joint tenants to dissolve the jointure, since thereby the right of survivorship is taken away, and each may transmit his own part to his own heirs. Sometimes, however, it is disadvantageous to dissolve the joint estate, as if there be joint tenants for life, and they make partition, this dissolves the jointure, and, though before they each of them had an estate in the whole for their own lives and the life of their companion, now they have an estate in a moiety only for their own lives merely, and, on the death of either, the reversioner shall enter on his moiety. And therefore, if there be two joint tenants for life, and one grants away his part for the life of his companion, it is a forfeiture. For in the first place, by the severance of the jointure, he has given himself in his own moiety only an estate for his own life, and then he grants the same land for the life of another, which grant, by a tenant for his own life merely, is a forfeiture of his estate, for it is creating an estate which may by possibility last longer than that which he is legally entitled to. End of chapter 12, part 1. Chapter 12, part 2 of the Commentaries on the Laws of England, Book 2, by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Of Estates in Severalty, Joint-Tenancy, Coparcenary, and Common. Part 2. 3. An estate held in coparcenary is where lands of inheritance descend from the ancestor to two or more persons. It arises either by common law or by particular custom. By common law, as where a person seized in fee simple or in fee tail dies, and his next heirs are two or more females, his daughters, sisters, aunts, cousins, or their representatives. In this case, they shall all inherit, as will be more fully shown when we treat of descents hereafter. And these co-heirs are then called coparceners, or, for brevity, parceners only. Parceners by particular custom are where lands descend, as in Gavelkind, to all the males in equal degree, as sons, brothers, uncles, etc. And in either of these cases, all the parceners put together make but one heir and have but one estate among them. The properties of parceners are in some respects like those of joint tenants, they having the same unities of interest, title, and possession. They may sue and be sued jointly for matters related to their own lands, and the entry of one of them shall in some cases inure as the entry of them all. They cannot have action of trespass against each other, but herein they differ from joint tenants, that they are also excluded from maintaining an action of waste. For coparceners could at all times put a stop to any waste by a writ of partition, but till the statute of Henry VIII, joint tenants had no such power. Parceners also differ materially from joint tenants in four other points. 1. They always claim by descent, whereas joint tenants always claim by purchase. Therefore, if two sisters purchase lands, to hold to them and their heirs, they are not parceners, but joint tenants, and hence it likewise follows that no lands can be held in coparcenary, but estates of inheritance, which are of a descendable nature, whereas not only estates in fee and in tail, but for life or years, may be held in joint tenancy. 2. There is no unity of time necessary to an estate in coparcenary. For if a man hath two daughters, to whom his estate descends in coparcenary, and one dies before the other, the surviving daughter and the heir of the other, or, when both are dead, their two heirs, are still parceners, the estates vesting in each of them at different times, though it be the same quantity of interest, and held by the same title. 3. Parceners, though they have a unity, have not an entirety of interest. They are properly entitled each to the whole of a distinct moiety, and of course there is no jus accrescendi, or survivorship between them, for each part descends severally to their respective heirs, though the unity of possession continues. And as long as the lands continue in a course of descent, and united in possession, so long are the tenants thereof, whether male or female, called parceners. But if the possession be once severed by partition, they are no longer parceners, but tenants in severalty. Or, if one parcener aliens her share, though no partition be made, then are the lands no longer held in coparcenary, but in common. Parceners are so called, saith Littleton, because they may be constrained to make partition. And he mentions many methods of making it, four of which are by consent and one by compulsion. The first is where they agree to divide the lands into equal parts in severalty, and that each shall have such a determinate part. The second is when they agree to choose some friend to make partition for them, and then the sisters shall choose each of them her part according to seniority of age, or otherwise as shall be agreed. But this privilege of seniority is then personal, for if the eldest sister be dead, her issue shall not choose first, but the next sister. But if an advowson descend in coparcenary, and the sisters cannot agree in the presentation, the eldest and her issue, nay, her husband, or her assigns, shall present alone before the younger. And the reason given is that the former privilege of priority and choice upon a division arises from an act of her own, the agreement to make partition, and therefore is merely personal. The latter, of presenting to the living, arises from the act of law, and is annexed not only to her person, but to her estate also. A third method of partition is where the eldest divides, and then she shall choose last. For the rule of law is, cujus est divisio, alterius est electio. The fourth method is where the sisters agree to cast lots for their shares. And these are the methods by consent. That by compulsion is where one or more sue out of a writ of partition against the others, whereupon the sheriff shall go to the lands and make partition thereof by the verdict of a jury there impaneled, and assign to each of the parceners her part in severalty. But there are some things which are in their nature impartible. The mansion house, common of estovers, common of piscary uncertain, or any other common without stint, shall not be divided, but the eldest sister, if she pleases, shall have them, and make the others a reasonable satisfaction in other parts of the inheritance, or, if that cannot be, then they shall have the profits of the thing by turns, in the same manner as they take advowson. There is yet another consideration attending the estate in coparcenary, that if one of the daughters has had an estate given with her in frank marriage by her ancestor, which we may remember was a species of estate's tail freely given by a relation for advancement of his kinswoman in marriage, in this case, if lands descend from the same ancestor to her and her sisters in fee simple, she or her heirs shall have no share of them, unless they will agree to divide the lands so given in frank marriage in equal proportion with the rest of the lands descending. This general division was known in the law of the Lombards, which direct the women so preferred in marriage, and claiming her share of the inheritance, mitere in confusum cum sororibus, quantum pater aut frater et dederit, quando ambula verit ad maritum. With us it is denominated bringing those lands into hotchpot, which term I shall explain in the very words of Littleton. It seemeth that this word, hotchpot, is in English a pudding, for in a pudding is not commonly put one thing alone, but one thing with the other things together. By this housewifely metaphor our ancestors meant to inform us that the lands, both those given in frank marriage and those descending in fee simple, should be mixed and blended together, and then divided in equal portions among all the daughters. But this was left to the choice of the donee in frank marriage, and if she did not choose to put her lands in hotchpot, she was presumed to be sufficiently provided for, and the rest of the inheritance was divided among her other sisters. The law of hotchpot took place then only, when the other lands descending from the ancestor were fee simple, for, if they descended in tail, the donee in frank marriage was entitled to her share without bringing her land so given into hotchpot. And the reason is because lands descending in fee simple are distributed by the policy of law for the maintenance of all the daughters, and if one has sufficient provision out of the same inheritance equal to the rest, it is not reasonable that she should have more. But lands descending in tail are not distributed by the operation of law so properly as por formam doni. It matters not, therefore, how unequal this distribution may be. Also, no lands but such are given in frank marriage shall be brought into hotchpot, for no others are looked upon in law as given for the advancement of the women or by way of marriage portion. And therefore, as gifts in frank marriage are fallen into disuse, I should hardly have mentioned the law of hotchpot, had not this method of division been revived and copied by the statute for distribution of personal estates, which we shall hereafter consider at large. The estate in coparcenary may be dissolved, either by partition, which disunites the possession, by alienation of one parsoner, which disunites the title, and may disunite the interest, or by the whole at last descending to and vesting in one single person, which brings it to an estate in severalty. 4. Tenants in common are such as hold by several and distinct titles, but by unity of possession, because none knoweth his own severalty, and therefore they all occupy promiscuously. This tenancy therefore happens where there is an unity of possession merely, but perhaps an entire disunion of interest, of title, and of time. 4. If there be two tenants in common of lands, one may hold his part in fee simple, the other in tail or for life, so that there is no necessary unity of interest. One may hold by descent, the other by purchase, or the one by purchase from A and the other by purchase from B, so that there is no unity of title. One's estate may have been vested 50 years, the other's but yesterday, so there is no unity of time. The only unity there is that of possession, and for this Littleton gives the true reason, because no man can certainly tell which part is his own, otherwise even this would soon be destroyed. Tenancy in common may be created either by the destruction of the two other estates in joint-tenancy and coparcenary, or by special limitation in a deed. By the destruction of the two other estates, I mean such destruction as does not sever the unity of possession, but only the unity of title or interest. As, if one of two joint tenants in fee aliens his estate for the life of the alienee and the other joint tenant are tenants in common, for they now have several titles, the other joint tenant by the original grant, the alienee by the new alienation, and they also have several interests, the former joint tenant in fee simple, the alienee for his own life only. So if one joint tenant give his part to A in tail, and the other gives his to B in tail, the donees are tenants in common, as holding by different titles and conveyances. If one of two parceners aliens, the alienee and the remaining parcener are tenants in common. Because they hold by different titles, the parcener by descent, the alienee by purchase. So likewise, if there be a grant to two men, or two women, and the heirs of their bodies, here the grantees shall be joint tenants of life estate, but they shall have several inheritances, because they cannot possibly have one heir of their two bodies, as might have been the case had the limitation been to a man and a woman, and the heirs of their bodies begotten. And in this and the like cases, their issues shall be tenants in common, because they must claim by different titles, one as heir of A, the other as heir of B, and those two not titles by purchase, but descent. In short, whenever an estate in joint tenancy or coparcenary is dissolved, so that there be no partition made, but the unity of possession continues, it is turned into a tenancy in common. A tenancy in common may also be created by express limitation in a deed, but here care must be taken not to insert words which imply a joint estate. And then, if lands be given to two or more, and it be not joint tenancy, it must be a tenancy in common. But the law is apt in its constructions to favor joint tenancy rather than tenancy in common, because the divisible services issuing from land, as rent, etc., are not divided, nor the entire services, as fealty, multiplied by joint tenancy, as they must necessarily be upon a tenancy in common. Land given to two, to be holden the one moiety to one, and the other moiety to the other, is an estate in common. And if one grants to another half his land, the grantor and grantee are also tenants in common, because, as has been before observed, joint tenants do not take by distinct halves or moieties, and by such grants the division and severalty of the estate is so plainly expressed that it is impossible they should take a joint interest in the whole of the tenements. But a device to two persons to hold jointly and severally is a joint tenancy, because that is implied in the word jointly, even though the word severally seems to imply the direct reverse. And an estate given to A and B equally to be divided between them, though in deeds it hath been said to be a joint tenancy, for it implies no more than the law has annexed to that estate, viz., divisibility, yet in wills it is certainly a tenancy in common, because the divisor may be presumed to have meant what is most beneficial to both the devisees, though his meaning is imperfectly expressed. And this nicety in the wording of grants makes it the most usual as well as the safest way, when a tenancy in common is meant to be created, to add express words of execution as well as description, and limit the estate to A and B to hold as tenants in common, and not as joint tenants. As to the incidents attending a tenancy in common, tenants in common, like joint tenants, are compellable by the statutes of Henry VIII and William III before mentioned to make partition of their lands which they were not at common law. They properly take by distinct moieties and have no entirety of interest, and therefore there is no survivorship between tenants in common. Their other incidents are such as merely arise from the unity of possession, and are therefore the same as appertain to joint tenants merely upon that account, such as being liable to reciprocal actions of waste and of account, by the statutes Westminster 2 c. 22 and 4 and C16. For by the common law, no tenant in common was liable to account to his companion for embezzling the profits of the estate, though, if one actually turns the other out of possession, an action of ejectment will lie against him. But as for other incidents of joint tenants which arise from the privity of title, or the union and entirety of interest, such as joining or being joined in actions, unless in the case where some entire or indivisible thing is to be recovered, these are not applicable to tenants in common, whose interests are distinct, and whose titles are not joint but several. Estates in common can only be dissolved in two ways. One, by uniting all the titles and interests in one tenant by purchase or otherwise, which brings the whole to one severalty. Two, by making partition between the several tenants in common, which gives them all respective severalties. For indeed, tenancies in common differ in nothing from sole estates, but merely in the blending and unity of possession. And this finishes our inquiries with respect to the nature of estates. End of Chapter 12, Part 2. Chapter 13 of the Commentaries on the Laws of England, Book 2, by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Of the title to things real in general. The foregoing chapters have been principally employed in defining the nature of things real, in describing the tenures by which they may be holden, and in distinguishing the several kinds of estate or interest that may be had therein. I come now to consider, lastly, the title to things real, with the manner of acquiring and losing it. A title is thus defined by Sir Edward Coke: Titulus est justa causa possidenti, id quod nostrum est, or it is the means whereby the owner of lands hath the just possession of his property. There are several stages or degrees requisite to form a complete title to lands and tenements. We will consider them in a progressive order. 1. The lowest and most imperfect degree of title consists in the mere naked possession or actual occupation of the estate, without any apparent right, or any shadow of pretense of right, to hold and continue such possession. This may happen when one man invades the possession of another, and by force or surprise turns him out of the occupation of his lands, which is termed a disseisin, being a deprivation of that actual season or corporal freehold of the lands which the tenant before enjoyed. Or it may happen that after the death of the ancestor and before the entry of the heir, or after the death of a particular tenant before the entry of him in remainder or reversion, a stranger may contrive to get possession of the vacant land and hold out him that had a right to enter. In all which cases, and many others that might be here suggested, the wrongdoer has only a mere naked possession, which the rightful owner may put an end to by a variety of legal remedies, as will more fully appear in the third book of these Commentaries. But in the meantime, till some act be done by the rightful owner to divest this possession and assert his title, such actual possession is, prima facie, evidence of legal title in the possessor, and it may, by length of time and negligence of him who hath the right, by degrees ripen into a perfect and indefeasible title. And, at all events, without such actual possession, no title can be completely good. 2. The next step to a good and perfect title is the right of possession, which may reside in one man, while the actual possession is either in himself or another. For if a man be deceased or otherwise kept out of possession by any of the means before mentioned, though the actual possession be lost, yet he still has remaining in him the right of possession, and may exert it whenever he thinks proper by entering upon the deceiser and turning him out of that occupancy which he has so illegally gained. But the right of possession is of two sorts: an apparent right of possession, which may be defeated by proving a better, and an actual right of possession, which will stand the test against all opponents. Thus, if the deceiser or other wrongdoer dies possessed of the land whereof he so became seized by his own unlawful act, and the same descends to his heir, now, by the common law, the heir hath obtained an apparent right, though the actual right of possession resides in the person deceased, and it shall not be lawful for the person deceased to divest this apparent right by mere entry or other act of his own, but only by an action at law. For until the contrary be proved by legal demonstration, the law will rather presume the right to reside in the heir, whose ancestor died seized, than the one who has no such presumptive evidence to urge in his own behalf. Which doctrine in some measure arose from the principles of the feudal law, which, after feuds became hereditary, much favored the right of descent, in order that there might be a person always on the spot to perform the feudal duties and services, and therefore, when a feudatory died in battle, or otherwise, it presumed always that his children were entitled to the feud, till the right was otherwise determined by his fellow soldiers and fellow tenants, the peers of the feudal court. But if he, who has the actual right of possession, puts in his claim and brings his action within a reasonable time, and can prove by what lawful means the ancestor became seized, he will then by sentence of law recover that possession to which he hath such actual right. Yet, if he omits to bring this possessory action within a competent time, his adversary may imperceptibly gain an actual right of possession in consequence of the other's negligence. And by this and certain other means, the party kept out of possession may have nothing left in him but what we are next to speak of, viz. 3. The mere right of property, the jus proprietatis, without either possession or even the right of possession. This is frequently spoken in our books under the name of a mere right, jus merum, and the estate of the owner is, in such cases, said to be totally divested and put to a right. A person in this situation may have the true ultimate property of the lands in himself, but by the intervention of certain circumstances, either by his own negligence, the solemn act of his ancestor, or the determination of a court of justice, the presumptive evidence of that right is strongly in favor of his antagonist, who has thereby obtained an absolute right of possession. As, in the first place, if a person deceased or turned out of possession of his estate neglects to pursue his remedy within the time limited by law, by this means the deceiser or his heirs gain the actual right of possession, for the law presumes that either he had a good right originally, in virtue of which he entered on the lands on question, or that since such his entry he has procured a sufficient title, and therefore, after so long an acquiescence, the law will not suffer his possession to be disturbed without inquiring into the absolute right of property. Yet still, if the person deceased or his heir hath the true right of property remaining in himself, his estate is indeed said to be turned into a mere right, but, by proving such his better right, he may at length recover the lands. Again, if a tenant in tail discontinues his estate tail by alienating the lands to a stranger in fee, and dies, here the issue in tail hath no right of possession independent of the right of property, For the law presumes prima facie that the ancestor would not disinherit, or attempt to disinherit, his heir unless he had the power to do so, and therefore, as the ancestor had in himself the right of possession, and has transferred the same to a stranger, the law will not permit that possession now to be disturbed, unless by showing the absolute right of property to reside in another person. The heir, therefore, in this case, has only a mere right, and must be strictly held to the proof of it in order to recover the lands. Lastly, if by accident, neglect, or otherwise, judgment is given for either party in any possessory action, that is, such wherein the right of possession only, and not that of property, is contested, and the other party hath indeed in himself the right of property, this is now turned to a mere right, and upon proof thereof in a subsequent action, denominated a writ of right, he shall recover his seizin of the lands. Thus, if a decisor turns me out of possession of my lands, he thereby gains a mere naked possession, and I still retain the right of possession and the right of property. If the decisor dies and the lands descend to his son, the son gains an apparent right of possession, but I still retain the actual right both of possession and property. If I acquiesce for 30 years without bringing any action to recover possession of the lands, the son gains the actual right of possession, and I retain nothing but a mere right of property. And even this right of property will fail, or at least it will be without a remedy, unless I pursue it within the space of 60 years. So also, if the father be tenant in tail, and aliens the estate tail to a stranger in fee, the alienee thereby gains the right of possession, and the son hath only a mere right or right of property. And hence it will follow that one man may have the possession, another the right of possession, and a third the right of property. For if a tenant in tail enfiefs A in fee simple and dies, and B disseizes A, now B will have the possession, A the right of possession, and the issue in tail the right of property. A may recover the possession against B, and afterwards the issue in tail may evict A, and unite in himself the possession, the right of possession, and also the right of property, in which union consists 4. A complete title to lands, tenements, and hereditaments. For it is an ancient maxim of the law that no title is completely good unless the right of possession be joined with the right of property, which right is then denominated a double right, jus duplicatum, or droit droit. When to this double right the actual possession is also united, when there is, according to the expression of Plato, juris et caesine conjunctio, then and then only is the title completely legal. End of chapter 13. Chapter 14, Part 1 of the Commentaries on the Laws of England, Book 2, by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Of Title by Descent, Part 1. The several gradations and stages requisite to form a complete title to lands, tenements, and hereditaments having been briefly stated in the preceding chapter, we are next to consider the several manners in which this complete title, and therein principally the right of propriety, may be reciprocally lost and acquired, whereby the dominion of things real is either continued or transferred from one man to another. And here we must first of all observe that, as gain and loss are terms of relation and of a reciprocal nature, by whatever method one man gains in a state, By that same method, or its correlative, some other man has lost it. As where the heir acquires by descent, the ancestor has first lost or abandoned the estate by his death. Where the lord gains land by escheat, the estate of the tenant is first of all lost by the natural or legal extinction of all his hereditary blood. Where a man gains an interest by occupancy, the former owner has previously relinquished his right of possession. Where one man claims by prescription or immemorial usage, another man has either parted with his right by an ancient and now forgotten grant, or has forfeited it by the supineness or neglect of himself and his ancestors for ages. And so, in case of forfeiture, the tenant, by his own misbehavior or neglect, has renounced his interest in the estate, whereupon it devolves to that person who by law may take advantage of such default, and in alienation by common assurances, the two considerations of loss and acquisition are so interwoven and so constantly contemplated together that we never hear of a conveyance without at once receiving the idea as well of the grantor as the grantee. The methods, therefore, of acquiring on the one hand, and of losing on the other, a title to estates and things real, are reduced by our laws to two: descent, where the title is vested in a man by the single operation of law; and purchase, where the title is vested in him by his own act or agreement. Descent, or hereditary succession, is the title whereby a man on the death of his ancestor acquires his estate by right of representation as his heir at law. An heir, therefore, is he upon whom the law calls the estate immediately on the death of the ancestor, and an estate so descending to the heir is in law called the inheritance. The doctrine of descents, or law of inheritance in fee simple, is a point of the highest importance, and is indeed the principal object of the laws of real property in England. All the rules relating to purchases, whereby the legal course of descents is broken and altered, perpetually refer to this settled law of inheritance as a datum or first principle universally known, and upon which their subsequent limitations are to work. Thus, a gift entail, or to a man and the heirs of his body, is a limitation that cannot be perfectly understood without a previous knowledge of the law of descents in fee simple. One may well perceive that this is an estate confined in its descent to such heirs only of the donee as have sprung or shall spring from his body. But who those heirs are, whether all his children both male and female, or the male only, and, among the males, whether the eldest, youngest, or other son alone, or all the sons together, shall be his heir. This is a point that we must result back to the standing law of descents in fee simple to be informed of. In order, therefore, to treat a matter of this universal consequence the more clearly, I shall endeavor to lay aside such matters as will only tend to breed embarrassment and confusion in our inquiries, and shall confine myself entirely to this one object. I shall, therefore, decline considering at present who are and who are not capable of being heirs, reserving that for the chapter of escheats. I shall also pass over the frequent division of descents into those by custom, statute, and common law. For descents by particular custom, as to all the sons in Gavelkind, and the youngest in Borough English, have already often been hinted at, and may also be incidentally touched upon again, but will not make a separate consideration by themselves in a system so general as the present. And descents by statute, or fee tail per formam doni, in pursuance of the statute of Westminster II, have also been already copiously handled, and as it has been seen that the descent entail is restrained and regulated according to the words of the original donation, and does not entirely pursue the common law doctrine of inheritance, which only it will now be our business to explain. And as this depends not a little on the nature of kindred and the several degrees of consanguinity, it will be previously necessary to state, as briefly as possible, the true notion of this kindred or alliance in blood. Consanguinity or kindred is defined by the writers on these subjects to be vinculum personarum ab odem stipiti descendentium, the connection or relation of persons descended from the same stock or common ancestor. This consanguinity is either lineal or collateral. Lineal consanguinity is that which subsists between persons of whom one is descended in direct line from the other, as between John Stiles, the propositus in the table of consanguinity, and his father, grandfather, great-grandfather, and so upwards in the direct ascending line, or between John Stiles and his son, grandson, great-grandson, and so downwards in the direct descending line. Every generation in this lineal direct consanguinity constitutes a different degree, reckoning either upwards or downwards. The father of John Stiles is related to him in the first degree, and so likewise is his son, his grandsire and grandson in the second, his great-grandsire and great-grandson in the third. This is the only natural way of reckoning the degrees in the direct line, and therefore universally obtains as well in the civil and canon as in the common law. The doctrine of lineal consanguinity is sufficiently plain and obvious, but it is at first view astonishing to consider the number of lineal ancestors which every man has, with no very great number of degrees, and so many different bloods is a man said to contain in his veins, as he hath lineal ancestors. Of these he hath two in the first ascending degree, his own parents. He hath four in the second, the parents of his father and the parents of his mother. He hath eight in the third, the parents of his two grandfathers and two grandmothers, and, by the same rule of progression, he hath 128 in the seventh, 1,024 in the 10th, and at the 20th degree, or the distance of 20 generations, every man hath above 1,000,000 of ancestors, as common arithmetic will demonstrate. This lineal consanguinity, we may observe, falls strictly within the definition of vinculum personarum ab odem stipite descendentium, since lineal relations are such as descend from one the other, and both, of course, from the same common ancestor. Collateral kindred answers to the same description. Collateral relations agreeing with the lineal in this, that they descend from the same stock or ancestor, but differing in this, that they do not descend from each other. Collateral kinsmen are such then as lineally spring from one and the same ancestor, who is the stirps or root, the stipes, trunk, or common stock from whence these relations are branched out. As if John Stiles hath two sons, who have each a numerous issue. Both these issues are lineally descended from John Stiles as their common ancestor, and they are collaterally kinsmen to each other, because they are all descended from this common ancestor, and all have a portion of his blood in their veins, which denominates them consanguineos. We must be careful to remember that the very being of collateral consanguinity consists in this descent from one and the same common ancestor. Thus Titius and his brother are related. Why? Because both are derived from one father. Titius and his first cousin are related. Why? Because both descend from the same grandfather. And his second cousin's claim to consanguinity is this, that they both are derived from one and the same great-grandfather. In short, as many ancestors as a man has, so many common stocks he has, from which collateral kinsmen may be derived. And, As we are taught by Holy Writ that there is one couple of ancestors belonging to us all, from whence the whole race of mankind is descended, the obvious and undeniable consequence is that all men are in some degree related to each other. For indeed, if we only suppose each couple of our ancestors to have left, one with another, two children, and each of those children, on an average, to have left two more, and, without such a supposition, the human species must be daily diminishing, we shall find that all of us have now subsisting near 270 millions of kindred in the 15th degree, at the same distance from the several common ancestors as ourselves are, besides those that are one or two descents nearer to or farther from the common stock, who may amount to as many more. And if this calculation should appear incompatible with the number of inhabitants on the earth, it is because, by intermarriages among the several descendants from the same ancestor, 100 or 1,000 modes of consanguinity may be consolidated in one person, or he may be related to us 100 or 1,000 different ways. The method of computing these degrees in the canon law which our law has adopted is as follows. We begin at the common ancestor and reckon downwards. And in whatsoever degree the two persons, or the most remote of them, is distant from the common ancestor, that is the degree in which they are related to each other. Thus Titius and his brother are related in the first degree, for from the father to each of them is counted only one. Titius and his nephew are related in the second degree, for the nephew is 2 degrees removed from the common ancestor, viz., his own grandfather, the father of Titius. Or, to give a more illustrious instance from our English annals, King Henry VII, who slew Richard III in the battle of Bosworth, was related to that prince in the 5th degree. Let the propositus, therefore, in the table of consanguinity represent King Richard III, and the class marked King Henry VII. Now their common stock or ancestor was King Edward III, the abavus in the same table. From him to Edmund, Duke of York, the proavus is 1 degree. To Richard, Earl of Cambridge, the avus, 2. To Richard, Duke of York, the pater, 3. To King Richard III, the propositus, 4. And from King Edward III to John of Gant is 1 degree. To John, Earl of Somerset, 2. To John, Duke of Somerset, 3. To Margaret, Countess of Richmond, 4. To King Henry VII, 5. Which last mentioned prince, being the farthest removed from the common stock, gives the denomination to the degree of kindred in the canon and municipal law. Though, according to the computation of the civilians, who count upwards from either of the persons related to the common stock, and then downwards again to the other, reckoning a degree for each person both ascending and descending, these two princes were related in the 9th degree. For from King Richard III to Richard Duke of York is 1 degree. To Richard Earl of Cambridge, 2. To Edmund Duke of York, 3. To King Edward III, the common ancestor, 4. To John Gant, 5. To John Earl of Somerset, 6. To John Duke of Somerset, 7. To Margaret Countess of Richmond, 8. To King Henry VII, 9. End of chapter 14, part 1. Chapter 14, part 2 of the Commentaries on the Laws of England, Book 2, by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Of Title by Descent, Part 2. The nature and degrees of kindred being thus in some measure explained, I shall next proceed to lay down a series of rules or canons of inheritance, according to which estates are transmitted from the ancestor to the heir, together with an explanatory comment remarking their original and progress, the reasons upon which they are founded, and in some cases their agreement with the laws of other nations. 1. The first rule is that inheritances shall lineally descend to the issue of the person last actually seized in infinitum, but shall never lineally ascend. To explain more clearly both this and the subsequent rules, it must first be observed that by law no inheritance can vest, nor can any person be the actual complete heir of another till the ancestor is previously dead. Nemo est aeres viventis. Before that time, the person who is next in the line of succession is called an heir apparent or heir presumptive. Heirs apparent are such whose right of inheritance is indefeasible, provided they outlive the ancestor, as the eldest son or his issue, who must by the course of the common law be heirs to the father whenever he happens to die. Heirs presumptive are such who, if the ancestor should die immediately, would in the present circumstances of things be his heirs, but whose right of inheritance may be defeated by the contingency of some nearer heir being born, as a brother or nephew whose presumptive succession may be destroyed by the birth of a child, or a daughter whose present hopes may be hereafter cut off by the birth of a son. Nay, even if the estate hath descended, by the death of the owner, to such brother or nephew or daughter, in the former cases the estate shall be divested and taken away by the birth of a posthumous child, and, in the latter, it shall also be totally divested by the birth of a posthumous son. We must also remember that no person can be properly such an ancestor as that an inheritance in lands or tenements can be derived from him, unless he hath had actual seizin of such lands, either by his own entry, or by the possession of his own or his ancestor's lessee for years, or by receiving rent from a lessee of the freehold, or unless he hath had what is equivalent to corporal seizin in hereditaments that are incorporeal, such as the receipt of rent, a presentation to the church in case of an advowson, and the like. But he shall not be accounted an ancestor who hath only a bare right or title to enter or be otherwise seized. And therefore all the cases which will be mentioned in the present chapter are upon the supposition that the deceased, whose inheritance is now claimed, was the last person actually seized thereof. For the law requires this notoriety of possession, as evidence that the ancestor had that property in himself which is now to be transmitted to his heir. Which notoriety hath succeeded in the place of the ancient feudal investiture, whereby, while feuds were precarious, the vassal on the descent of lands was formally admitted in the Lord's court, as is still the practice in Scotland, and there received his seizin, in the nature of a renewal of his ancestor's grant, in the presence of the feudal peers, till at length, when the right of succession became indefeasible, an entry on any part of the lands within the county, which, if disputed, was afterwards to be tried by those peers, or other notorious possession, was admitted as equivalent to the formal grant of seizin, and made the tenant capable of transmitting his estate by descent. The seizin, therefore, of any person, thus understood, makes him the root or stock from which all future inheritance by right of blood must be derived, which is very briefly expressed in this maxim, Caesina facilis depitem. When, therefore, a person dies so seized, the inheritance first goes to his issue, as if there be Geoffrey, John, and Matthew, grandfather, father, and son, and John purchases land and dies, his son Matthew shall succeed him as heir, and not the grandfather Geoffrey, to whom the land shall never ascend, but shall rather escheat to the Lord. This rule, so far as it is affirmative and relates to lineal descent, is almost universally adopted by all nations, and it seems founded on a principle of natural reason, that whenever the right of property transmissible to representatives is admitted, the possessions of the parents should go, upon their decease, in the first place to their children, as those to whom they have given being, and for whom they are therefore bound to provide. But the negative branch, or total exclusion of parents and all lineal ancestors from succeeding to the inheritance of their offspring, is peculiar to our own laws, and such as have been deduced from the same original. For, by the Jewish law, on failure of issue the father succeeded to the son, in exclusion of brethren, unless one of them married the widow and raised up seed to his brother. And, by the laws of Rome, in the first place the children or lineal descendants were preferred, and, on failure of these, the father and mother or lineal ascendants succeeded together with the brethren and the sisters, though by law of the 12 tables the mother was originally, on account of her sex, excluded. Hence this rule of our laws has been censured and declaimed against as absurd and derogating from the maxims of equity and natural justice. Yet that there is nothing unjust or absurd in it, but that on the contrary it is founded upon very good reason, may appear from considering as well the nature of the rule itself as the occasion of introducing it into our laws. We are to reflect, in the first place, that all rules of succession to estates are creatures of the civil polity and juris positivi merely. The right of property, which is gained by occupancy, extends naturally no farther than the life of the present possessor, after which the land, by the law of nature, would again become common, and liable to be seized by the next occupant. But society, to prevent the mischiefs that might ensue from a doctrine so productive of contention, has established conveyances, wills, and successions, whereby the property originally gained by possession is continued and transmitted from one man to another, according to the rules which each state has respectively thought proper to prescribe. There is certainly, therefore, no injustice done to individuals, whatever be the path of descent marked out by the municipal law. If we next consider the time and occasion of introducing this rule into our law, we shall find it to have been grounded upon very substantial reasons. I think there is no doubt to be made but that it was introduced at the same time with, and in consequence of, the feudal tenures. For it was an express rule of the feudal law that successiones feodi talis est natura, quod ascendentes non succedunt, and therefore the same maxim obtains also in the French law to this day. Our Henry I, indeed, among other restorations of the old Saxon laws, restored the right of succession in the ascending line. But this soon fell again into disuse. For so early as Glanville's time, who wrote under Henry II, we find it laid down as established law that aereditas nunquam ascendit, which has remained an invariable maxim ever since. These circumstances evidently show this rule to be a feudal original, and, taken in that light, there are some arguments in its favor besides those which are drawn merely from the reason of the thing. For, if the feud of which the son died seized was really feudum antiquum, or one descended to him from his ancestors, the father could not possibly succeed to it, because it must have passed him in the course of descent, before it could come to the son, unless it were feudum maternum, or one descended from his mother, and then for other reasons, which will appear hereafter, the father could in no wise inherit it. and if it were feudum novum, or one newly acquired by the son, then only the descendants from the body of the feudatory himself could succeed by the known maxim of the early feudal constitutions, which was founded as well upon the personal merit of the vassal, which might be transmitted to his children, but could not ascend to his progenitors, as also upon this consideration of military policy, that the decrepit grandsire of a vigorous vassal would be but indifferently qualified to succeed him in his feudal services. Nay, even if this feudum novum were held by the son ut feudum antiquum, or with all the qualities annexed of a feud descended from his ancestors, such feud must in all respects have descended as if it had really been an ancient feud, and therefore could not go to the father, because, if it had been an ancient feud, the father must have been dead before it could have come to the son. Thus, whether the feud was strictly novum, or strictly antiquum, or whether it was novum held ut antiquum, in none of these cases the father could possibly succeed. These reasons, drawn from the history of the rule itself, seem to be more satisfactory than that quaint one of Bracton, adopted by Sir Edward Coke, which regulates the descent of lands according to the laws of gravitation. 2. A second general rule or canon is, that the male issue shall be admitted before the female. Thus, sons shall be admitted before daughters, or, as our male lawgivers have somewhat uncomplacently expressed it, the worthiest of blood shall be preferred. As if John Stiles hath two sons, Matthew and Gilbert, and two daughters, Margaret and Charlotte, and dies. First Matthew, and in case of his death without issue, then Gilbert, shall be admitted to the succession in preference to both the daughters. This preference of males to females is entirely agreeable to the law of succession among the Jews, and also among the states of Greece, or at least among the Athenians, but was totally unknown to the laws of Rome, such of them, I mean, as are at present extant, wherein brethren and sisters were allowed to succeed to equal portions of the inheritance. I shall not here enter into the comparative merit of the Roman and other constitutions in this particular, nor examine into the greater dignity of blood in the male or female sex, but shall only observe that our present preference of males to females seems to have arisen entirely from the feudal law. For though our British ancestors, the Welsh, appear to have given a preference to males, yet our subsequent Danish predecessors seem to have made no distinction of the sexes, but to have admitted all the children at once to the inheritance. But the feudal law of the Saxons on the continent, which was probably brought over hither, and first altered by the law of King Canute, gives an evident preference of the male to the female sex. Pater aut mater defuncti, filio non filiae haereditatem relinquent, qui defunctus non filios sed filias reliquerit, ad eas omnis hereditas pertinit. It is possible, therefore, that this preference might be a branch of that imperfect system of feuds which obtained here before the conquest, especially as it subsists among the customs of gavelkind, and as, in the charter or laws of King Henry I, it is not, like many Norman innovations, given up, but rather enforced. The true reason of preferring the males must be deduced from feudal principles, for, by the genuine and original policy of that constitution, no female could ever succeed to a proper feud, insomuch as they were incapable of performing those military services for the sake of which that system was established. But our law does not extend to a total exclusion of females, as the Salic law, and others, where feuds were most strictly retained. It only postpones them to males. For, though daughters are excluded by sons, yet they succeed before any collateral relations. Our law, like that of the Saxon feudists before mentioned, thus steering a middle course between the absolute rejection of females and the putting them on a footing with males. 3. A third rule or canon of descent is this, that where there are two or more males in equal degree, the eldest only shall inherit, but the females all together. As if a man hath two sons, Matthew and Gilbert, and two daughters, Margaret and Charlotte, and dies. Matthew, his eldest son, shall alone succeed to his estate, in exclusion of Gilbert, the second son, and both the daughters. But if both the sons die without issue before the father, the daughters Margaret and Charlotte shall both inherit the estate as coparceners. This right of primogeniture in males seems anciently to have obtained among the Jews, in whose constitution the eldest son had a double portion of the inheritance. In the same manner as with us, by the laws of King Henry I, the eldest son had the capital fee or principal feud of his father's possessions, and no other preeminence, and as the eldest daughter had afterwards the principal mansion, when the estate descended in coparcenary. The Greeks, the Romans, the Britons, the Saxons, and even originally the feudists, divided the land equally, some among all the children at large, some among males only. This is certainly the most obvious and natural way, and has the appearance, at least in the opinion of younger brothers, of the greatest impartiality and justice. But when the emperors began to create honorary feuds or titles of nobility, it was found necessary, in order to preserve their dignity, to make them impartible, or, as they styled them, feuda individua, and in consequence descendable to the eldest son alone. This example was farther enforced by the inconveniences that attended the splitting of estates, namely, the division of the military services, the multitude of infant tenants incapable of performing any duty, the consequential weakening of the strength of the kingdom, and the inducing younger sons to take up with the business and idleness of a country life, instead of being serviceable to themselves and the public by engaging in mercantile, in military, in civil, or in ecclesiastical employments. These reasons occasioned an almost total change in the method of feudal inheritances abroad, so that the eldest male began universally to succeed to the whole of the lands in all military tenures, and in this condition the feudal constitution was established in England by William the Conqueror. Yet we find that socage estates frequently descended to all the sons equally, so lately as when Glanville wrote in the reign of Henry II, and it is mentioned in the Mirror as a part of our ancient constitution that knights' fees should descend to the eldest son, and socage fees should be partible among the male children. However, in Henry III's time, we find by Bracton that socage lands, in imitation of lands in chivalry, had almost entirely fallen into the right of succession by primogeniture, as the law now stands, except in Kent, where they gloried in the preservation of their ancient Galvokine tenure, of which a principal branch was the joint inheritance of all the sons, and except in some particular manors and townships, where their local customs continued the descent sometimes to all, sometimes to the youngest son only, or in other more singular methods of succession. As to the females, they are still left as they were by the ancient law, for they were all equally incapable of performing any personal service, and therefore one main reason for preferring the eldest ceasing, such preference would have been injurious to the rest, and the other principal purpose, the prevention of the too minute subdivision of estates, was left to be considered and provided for by the lords, who had the disposal of these female heiresses in marriage. However, the succession by primogeniture, even among females, took place as to the inheritance of the crown, wherein the necessity of a sole and determinate succession is as great in one sex as the other. And the right of sole succession, though not of primogeniture, was also established with respect to female dignities and titles of honor. For if a man holds an earldom to him and the heirs of his body, and dies, leaving only daughters, the eldest shall not, of course, be countess, but the dignity is in suspense or abeyance till the king shall declare his pleasure. For he, being the fountain of honor, may confer it on which of them he pleases. In which disposition is preserved a strong trace of the ancient law of feuds before their descent by primogeniture, even among the males, was established, namely, that the lord might bestow them on which of the sons he thought proper. Progressium estuit ad filios divinerit, in quem scelicit dominus ac velet, beneficium confirmare. End of chapter 14, part 2. Chapter 14, Part 3 of the Commentaries on the Laws of England, Book 2, by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Of Title by Descent, Part 3. 4. A fourth rule or canon of descents is this, that the lineal descendants in infinitum of any person deceased shall represent their ancestor, that is, shall stand in the same place as the person himself would have done had he been living. Thus the child, grandchild, or great-grandchild, either male or female, of the eldest son succeeds before the younger son, and so infinitum. And these representatives shall take neither more nor less, but just so much as their principals would have done. As if there be two sisters, Margaret and Charlotte, and Margaret dies, leaving 6 daughters, and then John Stiles, the father of the 2 sisters, dies without other issue. These 6 daughters shall take among them exactly the same as their mother Margaret would have done, had she been living. That is, a moiety of the lands of John Stiles in Coparcenary, so that, upon partition made, if the land be divided into 12 parts, thereof Charlotte, the surviving sister, shall have 6, and her 6 nieces, the daughters of Margaret, 1 apiece. This taking by representation is called a succession in stirpes, according to the roots, since all the branches inherit the same share that their root, whom they represent, would have done. And in this manner also was the Jewish succession directed, but the Roman somewhat differed from it. In the descending line, the right of representation continued in infinitum, and the inheritance still descended in stirpes. As if one of 3 daughters died, leaving 10 children, then the father died. The 2 surviving daughters had each 1/3 of his effects, and the 10 grandchildren had the remaining third divided between them. And so among collaterals, if any person of equal degree with the persons represented were still subsisting, as if the deceased left 1 brother and 2 nephews the sons of another brother, the succession was still guided by the roots. But if both the brethren were dead leaving issue, then, I apprehend, their representatives in equal degree became themselves principals, and shared the inheritance per capita, that is, share and share alike, they being themselves now the next in degree to the ancestor in their own right, and not by the right of representation. So if the next heirs of Titius be 6 nieces, 3 by one sister, 2 by another, and 1 by a third, his inheritance, by the Roman law, was divided into 6 parts, and 1 given to each of the nieces, whereas the law of England in this case would still divide it only into 3 parts and distribute it per stirpes, thus 1/3 to the 3 children who represent 1 sister, another third to the 2 who represent the second, and the remaining third to the one child who is the sole representative of her mother. This mode of representation is a necessary consequence of the double preference given by our law, first to the male issue, and next to the firstborn among the males, to both which the Roman law is a stranger. For if all the children of the three sisters were in England to claim per capita, in their own rights as next of kin to the ancestor, without any respect to the stocks from whence they sprung, and those children were partly male and partly female, then the eldest male among them would exclude not only his own brethren and sisters, but all the issue of the other two daughters, or else the law in this instance must be inconsistent with itself, and depart from the preference which it constantly gives to the males and the firstborn among persons in equal degree. Whereas, by dividing the inheritance according to the roots or stirpes, the rule of descent is kept uniform and steady. The issue of the eldest son excludes all other pretenders, as the son himself, if living, would have done. But the issue of the two daughters divide the inheritance between them, provided their mothers, if living, would have done the same. And among these several issues, or representatives of the respective roots, the same preference to males and the same right of primogeniture obtain, as would have obtained in the first among the roots themselves, the sons or daughters of the deceased. As if a man hath two sons, A and B, and A dies leaving two sons, and then the grandfather dies. Now the eldest son of A shall succeed to the whole of his grandfather's estate, and if A had left only two daughters, they should have succeeded also to equal moieties of the whole, in exclusion of B and his issue. But if a man hath only three daughters, C, D, and E, and C dies leaving two sons, D leaving two daughters, and E leaving a daughter and a son who is younger than his sister. Here, when the grandfather dies, the eldest son of C shall succeed to one third, in exclusion of the younger, the two daughters of D to another third in partnership, and the son of E to the remaining third, in exclusion of his elder sister. And the same right of representation, guided and restrained by the same rules of descent, prevailed downwards in infinitum. Yet this right does not appear to have been thoroughly established in the time of Henry II, when Glanville wrote. And therefore, in the title to the crown especially, we find frequent contests between the younger but surviving brother and his nephew, being the son and representative of the elder deceased, in regard to the inheritance of their common ancestor, for the uncle is certainly nearer of kin to the common stock by one degree than the nephew, though the nephew, by representing his father, has in him the right of primogeniture. The uncle also was usually better able to perform the services of the fief, and besides had frequently superior interest and strength to back his pretensions and crush the right of his nephew. And even to this day, in Lower Saxony, proximity of blood takes place of representative primogeniture. That is, the younger surviving brother is admitted to the inheritance before the son of an elder deceased, which occasioned the disputes between the two houses of Mecklenburg, Schwerin, and Strelitz in 1692. Yet Glanville, with us, even in the 12th century, seems to declare for the right of the nephew by representation, provided the eldest son had not received a provision in lands from his father, or, as the civil law would call it, had not been fore-assimilated in his lifetime. King John, however, who kept his nephew Arthur from the throne, by disputing this right of representation, did all in his power to abolish it throughout the realm. But in the time of his son, King Henry III, we find the rule indisputably settled in the manner we have here laid it down, and so it has continued ever since. And thus much for lineal descents. 5. A fifth rule is, that on failure of lineal descendants or issue of the person last seized, the inheritance shall descend to the blood of the first purchaser, subject to the three preceding rules. Thus, if Geoffrey Styles purchases land, and it descends to John Styles, his son, and John dies seized thereof without issue, whoever succeeds to this inheritance must be of the blood of Geoffrey, the first purchaser of this family. The first purchaser, perquisitor, is he who first acquired the estate to his family, whether the same was transferred to him by sale, or by gift, or by any other method, except only that of descent. This is a rule almost peculiar to our own laws and those of a familiar original, for it was entirely unknown among the Jews, Greeks, and Romans, none of whose laws looked any farther than the person himself who died seized of the estate, but assigned him an heir without considering by what title he gained it, or from what ancestor he derived it. But the law of Normandy agrees with our law in this respect. Nor indeed is that agreement to be wondered at, since the law of descents in both is of feudal original, and this rule or canon cannot otherwise be accounted for than by recurring to feudal principles. When feuds first began to be hereditary, it was made a necessary qualification of the heir who would succeed to a feud that he should be of the blood of, that is, lineally descended from, the first feudatory or purchaser. In consequence whereof, if a vassal died possessed of a feud of his own acquiring, or feudum novum, it could not descend to any but his own offspring, no, not even to his brother, because he was not descended, nor derived his blood from the first acquirer. But if it was feudum antiquum, that is, one descended to the vassal from his ancestors, then his brother, or such other collateral relation as was descended and derived his blood from the first feudatory, might succeed to such inheritance. To this purpose speaks the following rule: Frater frate, sine legitimo arrede defuncto, in beneficio quod earum patris fuit succedat, sin autem unis e fratibus ad domino feudum acceperet, eo defuncto simo legitimo aered, frater ejus en feudum non succedit. The true feudal reason for which rule was this: that what was given to a man for his personal service and personal merit ought not to descend to any but the heirs of his person. And therefore, as in Estate's tale, which a proper feud very much resembles, so in the feudal donation, nomina redes, in prima investitura expressum, tantum ad descentes ex corpore primi vasili extenditur, ete non ad collaterales, nisi ex corpore primi vassali, sive stipitis descendant. The will of the donor, or original lord, when feuds were turned from life estates into inheritances, not being to make them absolutely hereditary, like the Roman allodium, but hereditary only sub modo, not hereditary to collateral relations or lineal ancestors or husband or wife of the feudatory, but to the issue descended from his body only. However, in process of time, when the feudal rigor was in part abated, a method was invented to let in the collateral relations of the grantee to the inheritance, by granting him a feudum novum to hold ut feudum antiquum, that is, with all the qualities annexed of a feud derived from his ancestors, and then the collateral relations were admitted to succeed even in infinitum, because they might have been the blood of, that is, descended from, the first imaginary purchaser. For since it is not ascertained in such general grants whether this feud shall be held ut feudum paternum or feudum avitum, but ut feudum antiquum merely, as a feud of indefinite antiquity, That is, since it is not ascertained from which of the ancestors of the grantee this feud shall be supposed to have descended, the law will not ascertain it, but will suppose any of his ancestors pro re nata to have been the first purchaser, and therefore it admits any of his collateral kindred who have the other necessary requisites to the inheritance, because every collateral kinsman must be descended from some one of his lineal ancestors. Of this nature are all the grants of fee simple estates of this kingdom. For there is now in the law of England no such thing as a grant of feudum novum to be held ut novum, unless in the case of a fee tail, and there we see that this rule is strictly observed, and none but the lineal descendants of the first donee or purchaser are admitted. But every grant of lands in fee simple is with us a feudum novum, to be held ut antiquum, as a feud whose antiquity is indefinite, and therefore the collateral kindred of the grantee or descendants from any of his lineal ancestors by whom the lands might have possibly been purchased are capable of being called to the inheritance. Yet, when an estate hath really descended in the course of an inheritance to the person last seized, the strict rule of the feudal law is still observed, and none are admitted but the heirs of those through whom the inheritance hath passed. For all others have demonstrably none of the blood of the first purchaser in them, and therefore shall never succeed. As, if lands come to John Stiles by descent from his mother Lucy Baker, no relation of his father as such shall ever be his heir of these lands, and vice versa, if they descended from his father Geoffrey Stiles, no relation of his mother as such shall ever be admitted thereto, for his father's kindred have none of his mother's blood, nor have his mother's relations any share of his father's blood. And so, if the estate descended from his father's father, George Stiles, the relations of his father's mother, Celia Kemp, shall for the same reason never be admitted, but only those of his father's father. This is also the rule of the French law, which is derived from the same feudal fountain. Here we may observe that, so far as the feud is really antiquum, the law traces it back, and will not suffer any to inherit but the blood of those ancestors from whom the feud was conveyed to the late proprietor. But when, through length of time, it can trace no farther, as if it be not known whether his grandfather, George Stiles, inherited it from his father, Walter Stiles, or his mother, Christian Smith, or if it appear that his grandfather was the first grantee, and so took it, by the general law, as a feud of indefinite antiquity. In either of these cases, the law admits the descendants of any ancestor of George Stiles, either paternal or maternal, to be in their due order the heirs to John Stiles of this estate, because in the first case it is really uncertain, and in the second case it is supposed to be uncertain, whether the grandfather derived his title from the part of his father or his mother. This, then, is the great and general principle upon which the law of collateral inheritances depends, that upon failure of issue in the last proprietor, the estate shall descend to the blood of the first purchaser, or that it shall result back to the heirs of the body of that ancestor from whom it either really has, or is supposed by fiction of law to have originally descended. According to this rule laid down in the yearbooks Fitzherbert, Brooke, and Hale, that he who would have been heir to the father of the deceased, and of course to the mother or any other purchasing ancestor, shall also be heir to the son. End of chapter 14, part 3. Chapter 14, part 4 of the Commentaries on the Laws of England, Book 2, by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Of Title by Descent, Part 4. The remaining rules are only rules of evidence calculated to investigate who that purchasing ancestor was, which, in feudis ver antiquus, has in process of time been forgotten, and is supposed so to be in feuds that are held ut antiquus. 6. A sixth rule or canon therefore is, that the collateral heir of the person last seized must be his next collateral kinsman of the whole blood. First, he must be his next collateral kinsman, either personally or jure representationis, which proximity is reckoned according to the canonical degrees of consanguinity before mentioned. Therefore, the brother being in the first degree, he and his descendants shall exclude the uncle and his issue, who is only in the second. And herein consists the true reason of the different methods of computing the degrees of consanguinity in the civil law on the one hand, and in the canon and common laws on the other. The civil law regards consanguinity principally with respect to successions, and therein very naturally considers only the person deceased to whom the relation is claimed. It therefore counts the degrees of kindred according to the number of persons through whom the claim must be derived from him, and make not only his great nephew, but also his first cousin, to be both related to him in the fourth degree, because there are three persons between him and each of them. The canon law regards consanguinity principally with a view to prevent incestuous marriages between those who have a large portion of the same blood running in their respective veins, and therefore looks up to the author of that blood, or the common ancestor, reckoning the degrees from him, so that the great nephew is related in the third canonical degree to the person proposed, and the first cousin in the second, the former being distant 3 degrees from the common ancestor, and therefore deriving only 1/4 of his blood from the same fountain with the propositus, the latter, and also the propositus, being each of them distant only 2 degrees from the common ancestor, and therefore having 1/2 of each of their bloods the same. The common law regards consanguinity principally with respect to descents, and having therein the same object in view as the civil, it may seem as if it ought to proceed according to the civil computation. But it also respects the purchasing ancestor from whom the estate was derived. It therein resembles the canon law, and therefore counts its degrees in the same manner. Indeed, the designation of person, in seeking for the next of kin, will come to exactly the same end, though the degrees will be differently numbered, whichever method the computation we suppose the law of England to use, since the right of representation of the father by the son, etc., is allowed to prevail in infinitum. This allowance was absolutely necessary, else there would have frequently been many claimants in exactly the same degree of kindred, as, for instance, uncles and nephews of the deceased, which multiplicity, though no inconvenience in the Roman law of partible inheritances, yet would have been productive of endless confusion where the right of sole succession, as with us, is established. The issue or descendants, therefore, of John Stiles's brother are all of them in the first degree of kindred with respect to inheritances, as their father also, when living, was, those of his uncle in the second, and so on, and are severally called to the succession in right of such their representative proximity. The right of representation being thus established, the former part of the present rule amounts to this: that on failure of issue of the person last seized, the inheritance shall descend to the issue of his next immediate ancestor. Thus, If John Stiles dies without issue, his estate shall descend to Francis, his brother, who is lineally descended from Geoffrey Stiles, his next immediate ancestor or father. On failure of brethren or sisters and their issue, it shall descend to the uncle of John Stiles, the lineal descendant of his grandfather George, and so on in infinitum. Very similar to which was the law of inheritance among the ancient Germans, our progenitors. Aeres ad successoresque, si cuique lubere in nullum testamentum, si liberi non sunt, proximos grados in possessione, fratres patrui avunculi. Now here it must be observed that the lineal ancestors, though, according to the first rule, incapable themselves of succeeding to the estate, because it is supposed to have already passed them, are yet the common stocks from which the next successor must spring. And therefore, in the Jewish law, which in this respect entirely corresponds with ours, the father or other lineal ancestor is himself said to be the heir, though long since dead, as being represented by the persons of his issue, who are held to succeed not in their own rights as brethren, uncles, etc., but in right of representation as the sons of the father, grandfather, etc., of the deceased. But, though the common ancestor be thus the root of the inheritance, yet with us it is not necessary to name him in making out the pedigree or descent. For the descent between two brothers is held to be an immediate descent, and therefore title may be by one brother or his representatives to or through another, without mentioning their common father. If Geoffrey Stiles hath two sons, John and Francis, Francis may claim as heir to John, without naming their father, Geoffrey, and to the son of Francis may claim as cousin and heir to Matthew, the son of John, without naming the grandfather, viz., as son of Francis, who was the brother of John, who was the father of Matthew. But though the common ancestors are not named in deducing the pedigree, yet the law still respects them as the fountains of inheritable blood. And therefore, in order to ascertain the collateral heir of John Stiles, it is in the first place necessary to recur to his ancestors in the first degree. And if they have left any other issue besides John, that issue will be his heir. On default of such, we must ascend one step higher to the ancestors in the second degree, and then to those in the third and fourth, and so upwards in infinitum, till some ancestors be found who have other issue descending from them besides the deceased in a parallel or collateral line. From these ancestors, the heir of John Stiles must derive his descent, and in such derivation the same rules must be observed with regard to sex, primogeniture, and representation that have just been laid down with regard to lineal descents from the person of the last proprietor. But secondly, the heir need not be the nearest kinsman absolutely, but only sub modo, that is, he must be the nearest kinsman of the whole blood. For, if there be a much nearer kinsman of the half-blood, a distant kinsman of the whole blood shall be admitted, and the other entirely excluded. A kinsman of the whole blood is he that is derived not only from the same ancestor, but from the same couple of ancestors. For as every man's own blood is compounded with the bloods of his respective ancestors, he only is properly of the whole or entire blood with another, who hath, so far as the distance of degrees will permit, all the same ingredients in the composition of his blood that the other hath. Thus, the blood of John Stiles, being composed of those of Geoffrey Stiles his father, and Lucy Baker his mother, therefore his brother Francis, being descended from both the same parents, hath entirely the same blood with John Stiles, or he is his brother of the whole blood. But if, after the death of Geoffrey, Lucy Baker, the mother, marries a second husband, Louis Gay, and hath issue by him, the blood of this issue being compounded of the blood of Lucy Baker, it is true, on the one part, but of that of Louis Gay instead of Geoffrey Styles on the other part, it hath therefore only half the same ingredients with that of John Styles, so that he is only his brother of the half-blood, and for that reason they shall never inherit to each other. So also, if the father has two sons, A and B, by different venters or wives, now these brethren are not brethren of the whole blood, and therefore shall never inherit to each other, but the estate shall rather escheat to the Lord. Nay, even if the father dies, and his lands descend to his eldest son A, who enters thereon, and dies seized without issue, still B shall not be heir to this estate, because he is only of the half-blood to A, the person last seized. But had A died without entry, then B might have inherited, not as heir to A, his half-brother, but as heir to their common father, who was the person last actually seized. This total exclusion of the half-blood from the inheritance, being almost peculiar to our own law, is looked upon as a strange hardship by such as are unacquainted with the reasons on which it is grounded. But these censures arise from a misapprehension of the rule, which is not so much to be considered in the light of a rule of descent, as a rule of evidence, an auxiliary rule to carry the former into execution. And here we must again remember that the great and most universal principle of collateral inheritances being this, that an heir to a feudum antiquum must be of the blood of the first feudatory or purchaser, that is, derived in a lineal descent from him. It was originally requisite, as upon gifts in tail it still is, to make out the pedigree of the heir from the first donee or purchaser, and to show that such heir was his lineal representative. But when, by length of time and a long course of descents, it came, in those rude and unlettered ages, to be forgotten who was really the first feudatory or purchaser, and thereby the proof of an actual descent from him became impossible, then the law substituted what Sir Martin Wright calls a reasonable in the stead of an impossible proof, for it remits the proof of an actual descent from the first purchaser, and only requires, in lieu of it, that the claimant be next of the whole blood to the person last in possession, or derived from the same couple of ancestors, which will probably answer to the same end as if he could trace his pedigree in direct line from the first purchaser. For he who is my kinsman of the whole blood can have no ancestors beyond or higher than the common stock, but what are equally my ancestors also, and mine are vice versa his. He therefore is very likely to be derived from that unknown ancestor of mine, from whom the inheritance descended. But a kinsman of the half-blood has but one half of his ancestors above the common stock the same as mine, and therefore there is not the same probability of that standing requisite in the law that he be derived from the blood of the first purchaser. To illustrate this by example, let there be John Styles and Francis, brothers by the same father and mother, and another son of the same mother by Louis Gay, a second husband. Now, if John dies seized of lands, but it is uncertain whether they descended to him from his father or mother, in this case his brother Francis, of the whole blood, is qualified to be his heir, for he is sure to be in the line of descent from the first purchaser, whether it were the line of the father or the mother. But if Francis should die before John without issue, the mother's son by Louis Gay, or brother of the half-blood, is utterly incapable of being heir, for he cannot prove his descent from the first purchaser, who is unknown, nor has he that fair probability which the law admits as presumptive evidence, since he is to the full as likely not to be descended from the line of the first purchaser as to be descended, and therefore the inheritance shall go to the nearest relation possessed of this presumptive proof, the whole blood. And, as this is the case in feudus antiquus, where there really did once exist a purchasing ancestor who is forgotten, it is also the case in feudus novus, held ut antiquus, where the purchasing ancestor is merely ideal and never existed, but only in fiction of law. Of this nature are all grants of lands in fee simple at this day, which are inheritable as if they descended from some uncertain indefinite ancestor, and therefore any of the collateral kindred of the real modern purchaser, and not his own offspring only, may inherit them, provided they be of whole blood, for all such are, in judgment of law, likely enough to be derived from this indefinite ancestor. But those of the half-blood are excluded for want of the same probability. Nor should this be thought hard, that a brother of the purchaser, though only of the half-blood, must thus be disinherited, and a more remote relation of the whole blood admitted, merely upon a supposition and fiction of law, since it is only upon like supposition and fiction that the brethren of purchasers, whether of the whole or half-blood, are entitled to inherit at all. For we have seen that in feodus stricte novus neither brethren nor any other collaterals were admitted. As therefore in feodus antiquus we have seen the reasonableness of excluding the half-blood, if by a fiction of law a feudum novum be made descendable to collaterals as if it were feudum antiquum, it is just and equitable that it should be subject to the same restrictions as well as the same latitude of descent. End of chapter 14, part 4. Chapter 14, part 5 of the Commentaries on the Laws of England, Book 2, by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Of Title by Descent, Part 5. Perhaps by this time the exclusion of the half-blood does not appear altogether so unreasonable as at first sight it is apt to do. It is certainly a very fine-spun and subtle nicety, but, considering the principles upon which our law is founded, it is neither an injustice nor a hardship, since even the succession of the whole blood was originally a beneficial indulgence, rather than the strict right of collaterals, and, though that indulgence is not extended to the demi-kindred, yet they are rarely abridged of any right which they could possibly have enjoyed before. The doctrine of whole blood was calculated to supply the frequent impossibility of proving a descent from the first purchaser without some proof of which, according to our fundamental maxim, there can be no inheritance allowed of. And this purpose it answers, for the most part, effectively enough. I speak with these restrictions because it does not, neither can any other method, answer this purpose entirely. For, though all the ancestors of John Stiles above the common stock are also the ancestors of his collateral kinsmen of the whole blood, yet, unless that common stock be in the first degree, that is, unless they have the same father and mother, there will be intermediate ancestors below the common stock that may belong to either of them respectively, from which the other is not descended, and therefore can have none of their blood. Thus, though John Stiles and his brother of the whole blood can each have no other ancestors than what are in common to them both, yet, with regard to his uncle, where the common stock is removed one degree higher, that is, the grandfather and grandmother, one half of John's ancestors will not be the ancestors of his uncle. His patrus, or father's brother, derives not his descent from John's maternal ancestors, nor his avunculus, or mother's brother, from those in the paternal line. Here, then, the supply of proof is deficient, and by no means amounts to a certainty, and the higher the common stock is removed, the more will even the probability decrease. But it must be observed that, upon the same principles of calculation, the half-blood have always a much less chance to be descended from an unknown indefinite ancestor of the deceased than the whole blood in the same degree. As, in the first degree, the whole brother of John Stiles is sure to be descended from that unknown ancestor. His half-brother has only an even chance, for half of John's ancestors are not his. So, in the second degree, John's uncle of the whole blood has an even chance, but the chances are 3-to-1 against his uncle of the half-blood, for 3/4 of John's ancestors are not his. In like manner, in the third degree, the chances are only 3-to-1 against John's great uncle of the whole blood, but they are 7-to-1 against his great uncle of the half blood, for 7/8 of John's ancestors have no connection in blood with him. Therefore, the much less probability of the half blood's descent from the first purchaser, compared with that of the whole blood, in the several degrees, has occasioned a general exclusion of the half-blood in all. But, while I thus illustrate the reason of excluding the half-blood in general, I must be impartial enough to own that in some instances the practice is carried farther than the principle upon which it goes will warrant. Particularly when a man has 2 sons by different venters, and the estate on his death descends from him to the eldest, who enters and dies without issue. Now the younger son cannot inherit this estate, because he is not the whole blood to the last proprietor. This, it must be owned, carries a hardship with it, even upon feudal principles. For the rule was introduced only to supply the proof of a descent from the first purchaser. But here, as this estate notoriously descended from the father, and as both the brothers confessedly sprung from him, it is demonstrable that the half-brother must be of the blood of the first purchaser, who was either the father or some of the father's ancestors. When, therefore, there is actual demonstration of the thing to be proved, it is hard to exclude a man by a rule substituted to supply that proof when deficient. So far as the inheritance can be evidently traced back, there seems no need of calling in this presumptive proof, this rule of probability, to investigate what is already certain. Had the elder brother indeed been a purchaser, there would have been no hardship at all, for the reasons already given. Or had the frater uternus only, or brother by the mother's side, been excluded from an inheritance which descended from the father, it had been highly reasonable. Indeed, it is this very instance of excluding a frater consanguineus, or brother by the father's side, from an inheritance which descended a pater, that Craig has singled out on which to ground his strictures on the English law of half-blood. And it really should seem as if the custom of excluding half the blood in Normandy extended only to a frater uterineus, when the inheritance descended a pater, and vice versa. As even with us it remained a doubt in the time of Braxton and of Fleda, whether the half-blood on the father's side were excluded from the inheritance which originally descended from the common father, or only from such as descended from their respective mothers and from newly purchased lands. And the rule of law, as laid down by our Fortescue, extends no farther than this: frater fratri uterino non seget in heredate paterna. It is moreover worthy of observation, that by our law, as it now stands, the crown, which is the highest inheritance in the nation, may descend to the half-blood of the preceding sovereign, so as it be the blood of the first monarch, purchaser, or, in the feudal language, conqueror of the reigning family. Thus, it actually did descend from King Edward VI to Queen Mary, and from her to Queen Elizabeth, who were respectively of the half-blood to each other. For the royal pedigree being always a matter of sufficient notoriety, there is no occasion to call in the aid of this presumptive rule of evidence to render probable the descent from the royal stock, which was formerly King William the Norman, and is now, by Act of Parliament, the Princess Sophia of Hanover. Hence also it is, that in the state's tale, where the pedigree from the first donee must be strictly proved, half-blood is no impediment to the descent, because, when the lineage is clearly made out, there is no need of this auxiliary proof. How far it might be desirable for the legislature to give relief by amending the law of descents in this single instance, and ordaining that the half-blood might inherit, where the estate notoriously descended from its proper ancestor, but not otherwise; or how far a private inconvenience should be submitted to, rather than a long-established rule should be shaken, is not for me to determine. The rule, then, together with its illustration, amounts to this: that, in order to keep the estate of John Stiles as nearly as possible in the line of his purchasing ancestor, it must descend to the issue of the nearest couple of ancestors that have left descendants behind them, because the descendants of one ancestor only are not so likely to be in the line of that purchasing ancestor as those who are descended from two. But here another difficulty arises. In the second, third, fourth, and every superior degree, every man has many couples of ancestors, increasing according to the distance in a geometrical progression upwards, the descendants of all which respective couples are, representatively, related to him in the same degree. Thus, in the second degree, the issue of George and Celia Stiles, and of Andrew and Esther Baker, the two grandsires and grandmothers of John Stiles, are each in the same degree of propinquity. In the third degree, the respective issues of Walter and Christian Stiles, of Luke and Francis Kemp, of Herbert and Hannah Baker, and of James and Emma Thorpe, are, upon extinction of the two inferior degrees, all equally entitled to call themselves the next kindred of the whole blood to John Stiles. To which, therefore, of these ancestors must we first resort, in order to find out descendants to be preferably called to the inheritance? In answer to this, and to avoid the confusion and uncertainty that must arise between the several stocks wherein the purchasing ancestor may be fought for, 7. The seventh and last rule or canon is, that in collateral inheritances the male stock shall be preferred to the female; that is, kindred derived from the blood of the male ancestors shall be admitted before those from the blood of the female, unless where the lands have, in fact, descended from a female. Thus, the relations on the father's side are admitted in infinitum before those on the mother's side are admitted at all, and the relations of the father's father before those of the father's mother, and so on. And in this the English law is not singular, but warranted by the examples of the Hebrew and Athenian laws, as stated by Selden and Pettit, though among the Greeks, in the time of Hesiod, when a man died without wife or children, all his kindred, without any distinction, divided his estate among them. It is likewise warranted by the example of the Roman law, wherein the agnati, or relations of the father, were preferred to the cognati, or relations by the mother, till the edict of the Emperor Justinian abolished all distinction between them. It is also conformable to the customary law of Normandy, which indeed, in most respects, agrees with our law of inheritance. However, I am inclined to think that this rule of our laws does not owe its immediate original to any view of conformity to those which I have just now mentioned, but was established in order to effectuate and carry into execution the fifth rule or canon before laid down, that every heir must be of the blood of the first purchaser. For, When such first purchaser was not easily to be discovered after a long course of descents, the lawyers not only endeavored to investigate him by taking the next relation of the whole blood to the person last in possession, but also, considering that a preference had been given to males by virtue of the second canon, through the whole course of lineal descent from the first purchaser to the present time, they judged it more likely that the land should have descended to the last tenant from his male than from his female ancestors, from the father, for instance, rather than from the mother, from the father's father rather than the father's mother, and therefore they hunted back the inheritance, if I may be allowed the expression, through the male line, and gave it to the next relations on the side of the father's father, and so upwards, imagining with reason that this was the most probable way of continuing it in the line of the first purchaser. A conduct much more rational than the preference of the agnati by the Roman laws, which, as they gave no advantage to the males in the first instance or direct lineal succession, had no reason for preferring them in the transverse collateral one, upon which account this preference was wisely abolished by Justinian. That this was the true foundation of the preference of the agnati or male stocks in our law will further appear if we consider that whenever the lands have notoriously descended to a man from his mother's side, this rule is totally reversed, and no relation of his by the father's side as such can ever be admitted to them, because he cannot possibly be of the blood of the first purchaser. And so, a converso, if the lands descended from the father's side, no relation of the mother as such shall ever inherit. So also, if they in fact descended to John Stiles from his father's mother, Celia Kemp, not only the blood of Lucy Baker, his mother, but also of George Stiles, his father's father, is perpetually excluded. And, in like manner, if they be known to have descended from Frances Holland, the mother of Celia Kemp, the line not only of Lucy Baker and of George Stiles, but also of Luke Kemp, the father of Celia, is excluded. Whereas, when the side from which they descended is forgotten, or never known, as in the case of an estate newly purchased to be holden ut feudum antiquum, here the right of inheritance first runs up all the father's side, with a preference to the male stocks in every instance, and, if it finds no heirs there, it then, and only then, resorts to the mother's side, leaving no place untried in order to find heirs that may possibly be derived from the original purchaser. The greatest probability of finding such was among those descended from the male ancestors, but upon failure of issue there, they may possibly be found among those derived from the females. This I take to be the true reason of the constant preference of the agnatic succession, or issue derived from the male ancestors through all the stages of collateral inheritance, as the ability for personal service was the reason for preferring the males at first in the direct lineal succession. We see clearly that if males had been perpetually admitted, in utter exclusion of females, the tracing the inheritance back through the male line of ancestors must at last have inevitably brought us up to the first purchaser. But, as males have not been perpetually admitted, but only generally preferred, as females have not been utterly excluded, but only generally postponed to males, the tracing the inheritance up through the male stocks will not give us absolute demonstration, but only a strong probability of arriving at the first purchaser, which, joined with the other probability of the wholeness or entirety of blood, will fall short of a certainty. Before we conclude this branch of our inquiries, it may not be amiss to exemplify these rules by a short sketch of the manner in which we must search for the heir of a person, as John Stiles, who dies seized of land which he acquired, and which therefore he held as a feud of indefinite antiquity. In the first place succeeds the eldest son, Matthew Stiles, or his issue, number 1. If his line be extinct, then Gilbert Stiles and the other sons respectively in order of birth or their issue, number 2. In default of these, all the daughters together, Margaret and Charlotte Styles or their issue, number 3. On failure of the descendants of John Styles himself, the issue of Geoffrey and Lucy Styles, his parents, is called in, viz. First, Francis Styles, the eldest brother of the whole blood, or his issue, number 4. Then Oliver Styles and the other whole brothers, respectively, in order of birth, or their issue, number 5. Then the sisters of the whole blood, all together, Bridget and Alice Styles, or their issue, number 6. In defect of these, the issue of George and Celia Styles, his father's parents, respect being still had to their age and sex, number 7. Then the issue of Walter and Christian Styles, the parents of his paternal grandfather, number 8. Then the issue of Richard and Anne Styles, the parents of his paternal grandfather's father, number 9, and so on in the paternal grandfather's paternal line, or blood of Walter Styles in infinitum. In defect of these, the issue of William and Jane Smith, the parents of his paternal grandfather's mother, number 10, and so on in the paternal grandfather's maternal line, or blood of Christian Smith in infinitum, till both the immediate bloods of George Styles, the paternal grandfather, are spent. Then we must resort to the issue of Luke and Francis Kemp, the parents of John Styles's paternal grandmother, number 11. Then to the issue of Thomas and Sarah Kemp, the parents of his paternal grandmother's father, number 12. And so on in the paternal grandmother paternal line, or the blood of Luke Kemp in infinitum. In default of which, we must call in the issue of Charles and Mary Holland, the parents of his paternal grandmother's mother, number 13, and so on in the paternal grandmother's line, or blood of Francis Holland in infinitum, till both the immediate bloods of Celia Kemp, the paternal grandmother, are also spent, whereby the paternal blood of John Styles entirely failing, recourse must then, and not before, be had to his maternal relations, or the blood of the Bakers, number 14, 15, 16, Willises, number 17, Thorpes, numbers 18 and 19, and the Whites, number 20, in the same regular successive order as in the paternal line. The student should, however, be informed that the class, number 10, would be postponed to number 11 in consequence of the doctrine laid down arguendo by Justice Manwood in the case of Clare and Brooke, from whence it is adopted by Lord Bacon and Sir Matthew Hale. And yet, notwithstanding these respectable authorities, the compiler of this table has ventured to give the preference therein to number 10 before number 11 for the following reasons. 1. Because this point was not the principal question in the case of Clare and Brooke, but the law concerning it is delivered obiter only, and in the course of argument by Justice Manwood, though afterwards said to be confirmed by the 3 other justices in separate extrajudicial conferences with the reporter. 2. Because the Chief Justice, Sir James Dyer, in reporting the resolution of the court in what seems to be the same case, takes no notice of this doctrine. 3. Because it appears from Plowden's report that very many gentlemen of the law were dissatisfied with this position of Justice Manwood. 4. Because the position itself destroys the otherwise entire and regular symmetry of our legal course of descents, as is manifest by inspecting the table, and destroys also that constant preference of the male stocks in law of inheritance, for which an additional reason is before given, besides the mere dignity of blood. 5. Because it introduces all that uncertainty and contradiction which is pointed out by an ingenious author, and establishes a collateral doctrine incompatible with the principal point resolved in the case of Clare and Brooke, viz. The preference of number 11 to number 14. And though that learned writer, proposes to rescind the principal point then resolved. In order to clear this difficulty, it is apprehended that the difficulty may be better cleared by rejecting the collateral doctrine which was never yet resolved at all. 6. Because the reason that is given for this doctrine in Plowden, Bacon, and Hale, viz., that in any degree paramount the first, the law respects proximity and not dignity of blood. Number 18 also ought to be preferred to number 16, which is directly contrary to the eighth rule laid down by Hale himself. 7. Because this position seems to contradict the allowed doctrine of Sir Edward Coke, who lays it down under different names that the blood of the Kemps, alias Sandys, shall not inherit till the blood of the Styles, alias Fairfields, fail. Now the blood of the Styles does certainly not fail till both 9 and 10 are extinct. Wherefore, number 11, being the blood of the Kemps, ought not to inherit till then. 8. Because in the case of Mitch 12, Edward IV 14, much relied on in that of Clare and Brooke, it is laid down as a rule that Cestui, coetuit inherita al pere, doit inherita al fils. And so Sir Matthew Hale says that though the law excludes the father from inheriting, yet it substitutes and directs the descent as it should have been had the father inherited. Now it is settled by the resolution in Clare and Brooke that number 10 should have inherited to Geoffrey Styles, the father, before number 11, and therefore number 10 ought also to be preferred in inheriting to John Styles, the son. In case John Styles was not himself the purchaser, but the estate in fact came to him by descent from his father, mother, or any higher ancestor, there is this difference, that the blood of that line of ancestors from which it did not descend can never inherit. Thus, if it descended from Geoffrey Styles, the father, the blood of Lucy Baker, the mother, is perpetually excluded, and so, vice versa, if it is descended from Lucy Baker, it cannot descend to the blood of Geoffrey Styles. This, in either case, cuts off one half of the table from any possible succession. And farther, if it can be shown to have descended from George Styles, this cuts off 3/4, for now the blood, not only of Lucy Baker, but also of Celia Kemp, is excluded. If, lastly, it descended from Walter Styles, this narrows the succession still more and cuts off 7/8 of the table, for now neither the blood of Lucy Baker, nor Celia Kemp, nor Christian Smith can ever succeed to the inheritance. And the like rule will hold upon descents from any other ancestors. The student should bear in mind that, during this whole process, John Styles is the person supposed to have been last actually seized of the estate. For if it ever comes to vest in any other person as heir to John Styles, a new order of succession must be observed upon the death of such heir, since he, by his own season, now becomes himself an ancestor or stipes and must be put in the place of John Styles. The figures therefore denote the order in which the several classes would succeed to John Styles and not to each other. And before we search for an heir in any of the higher figures, as number 8, we must be first assured that all the lower classes, from number 1 to number 7, were extinct at John Styles's decease. End of chapter 14, part 5. Chapter 15, part 1 of the Commentaries on the Laws of England, Book 2, by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Of Title by Purchase and First by Escheat, Part 1. Purchase, perquisitio, taken in its largest and most extensive sense, is thus defined by Littleton: the possession of lands and tenements, which a man hath by his own act or agreement, and not by descent from any of his ancestors or kindred. In this sense it is contradistinguished from acquisition by right of blood, and includes every other method of coming to an estate, but merely that by inheritance, wherein the title is vested in a person, not by his own act or agreement, but by the single operation of law. Purchase, indeed, in its vulgar and confined acceptation, is applied only to such acquisitions of land as are obtained by way of bargain and sale for money or some other valuable consideration. But this falls far short of the legal idea of purchase, for if I give land freely to another, he is, in the eye of the law, a purchaser, and falls within Littleton's definition, for he comes to the estate by his own agreement, that is, he consents to the gift. A man who has his father's estate settled upon him in tail before he is born is also a purchaser, for he takes quite another estate than the law of descents would have given him. Nay, even if the ancestor devises his estate to his heir at law by will, with other limitations or in any other shape than the course of descents would direct, such heir shall take by purchase. But if a man seized in fee devises his whole estate to his heir at law, so that the heir takes neither a greater nor less estate by the device than he would have done without it, he shall be adjudged to take by descent, even though it be charged with encumbrances, for the benefit of creditors and others who have demands on the estate of the ancestor. If a remainder be limited to the heirs of Sempronius, here Sempronius himself takes nothing, but if he dies during the continuance of the particular estate, his heirs shall take as purchasers. But if an estate be made to A for life, remainder to his right heirs in fee, his heirs shall take by descent, for it is an ancient rule of law that wherever the ancestor takes an estate for life, the heir cannot by the same conveyance take an estate in fee by purchase, but only by descent. And if A dies before entry, still his heir shall take by descent, and not by purchase. For where the heir takes anything that might have been vested in the ancestor, he takes by way of descent. The ancestor during his life beareth in himself all his heirs, and therefore, once he is or might have been seized of the land, the inheritance so limited to his heirs vests in the ancestor himself, and the word heirs in this case is not esteemed a word of purchase, but a word of limitation, inuring so as to increase the estate of the ancestor from a tenancy for life to a fee simple. And, had it been otherwise, had the heir, who was uncertain till the death of the ancestor, been allowed to take as a purchaser originally nominated in the deed, as must have been the case if the remainder had been expressly limited to Matthew or Thomas by name, then, in the times of strict feudal tenure, the lord would have been defrauded by such a limitation of the fruits of his seigneury arising from a descent to the heir. What we call purchase, perquisitio, the feudists call conquest, conquestos, conquisitio, both denoting any means of acquiring an estate out of the common course of inheritance. And this is still the proper phrase in the law of Scotland, as it was among the Norman jurists, who styled the first purchaser, that is, he who first brought the estate into the family which at present owns it, the conqueror, or conquerere, which seems to be all that was meant by the appellation which was given to William the Norman when his manner of ascending the throne of England was, in his own and his successors' charters, and by the historians of the times, entitled Conquestos, and himself Conquestor, Conquistador, signifying that he was the first of his family who acquired the crown of England, and from whom, therefore, all future claims of descent must be derived, though now, From our disuse of the feudal sense of the word, together with the reflection on his forcible method of acquisition, we are apt to annex the idea of victory to his name of conquest or conquisition, a title which, however just with regard to the crown, the conqueror never pretended with regard to the realm of England, nor in fact ever had. The difference in effect between acquisition of an estate by descent and purchase consists principally in these 2 points. One, that by purchase the estate acquires a new inheritable quality and is descendable to the owner's blood in general, and not the blood of some particular ancestor. For when a man takes an estate by purchase, he takes it not ut feodum paternum or maternum, which would descend only to the heirs by the father or the mother's side, but he takes it ut feodum antiquum, as a feud of indefinite antiquity, whereby it becomes inheritable to his heirs general, first of the paternal and then of the maternal line. 2. An estate taken by purchase will not make the heir answerable for the acts of the ancestor as an estate by descent will. For if the ancestor by any deed, obligation, covenant, or the like, bindeth himself and his heirs, and dieth, this deed, obligation, or covenant shall be binding upon the heir so far forth only as he had any estate of inheritance vested in him or in some other trust for him by descent from that ancestor sufficient to answer the charge. Whether he remains in possession or hath aliened it before the action brought, which sufficient estate is in law called assets, from the French word assez, enough. Therefore, if a man covenants for himself and his heirs to keep my house in repair, I can then, and then only, compel his heirs to perform this covenant when he has an estate sufficient for this purpose, or assets, by descent from the covenantor. For though the covenant descends to the heir, whether he inherits any estate or no, it lies dormant and is not compulsory until he has assets by descent. This is the legal signification of the word perquisito, or purchase, and in this sense it includes the 5 following methods of acquiring title to estates. 1. Escheat. 2. Occupancy. 3. Prescription. 4. Forfeiture. 5. Alienation. Of these, in their order. 1. Escheat, we may remember, was one of the fruits and consequences of feudal tenure. The word itself is originally French or Norman, in which language it signifies chance or accident, and with us denotes an obstruction of the course of descent and a consequent determination of the tenure by some unforeseen contingency, in which case the land naturally results back by a kind of reversion to the original grantor or lord of the fee. Escheat, therefore, being a title frequently vested in the lord by inheritance, as being the fruit of a signary to which he is entitled by descent, for which reason the lands escheating shall attend the signary and be inheritable by such only of his heirs as are capable of inheriting the other, it may seem in such cases to fall more properly under the former general head of acquiring title to estates, viz., by descent, being vested in him by act of law, and not by his own act or agreement, than under the present by purchase. But it must be remembered that in order to complete this title by escheat, it is necessary that the lord perform an act of his own, by entering on the lands and tenements so escheated, or suing out a writ of escheat, on failure of which, or by doing any act that amounts to an implied waiver of his right, as by accepting homage or rent of a stranger who usurps the possession, his title by escheat is barred. It is therefore, in some respect, a title acquired by his own act, as well as by act of law. Indeed, this may also be said of descents themselves, in which an entry or other season is required in order to make a complete title. and therefore this distribution by our legal writers seems in this respect rather inaccurate, for, as escheats must follow the nature of the signary to which they belong, they may vest by purchase or descent according as the signary is vested. And, though Sir Edward Coke considers the lord by escheat as in some respects the assignee of the last tenant, and therefore taking by purchase, yet, on the other hand, the lord is more frequently considered as being ultimus aeres, and therefore taking by descent in a kind of caducary succession. The law of escheats is founded upon this single principle, that the blood of the person last seized in fee simple is, by some means or other, utterly extinct and gone, and since none can inherit his estate but such as are of his blood and consanguinity, it follows as a regular consequence that when such blood is extinct, the inheritance itself must fail. The land must become what the feudal writers denominate feodus epertum, and must result back again to the lord of the fee, by whom, or by those whose estate he hath, it was given. Escheats are frequently divided into those propter defectum sanguinis, and those proper delectum tenitis, the one sort if the tenant dies without heirs, the other if his blood be attainted. But both these species may well be comprehended under the first denomination only, for he that is attainted suffers an extinction of his blood, as well as he that dies without relations. The inheritable quality is expunged in one instance and expires in the other, or, as the doctrine of escheats is very fully expressed in Fleta, Dominus capitales feode local aeredes abetor, quotis per defectum vel delictum extinguitur sanguis tenentis. Escheats, therefore, arising merely upon the deficiency of the blood, whereby the descent is impeded, their doctrine will be better illustrated by considering the several cases wherein hereditary blood may be deficient than by any other method whatsoever. 1, 2, 3. The first three cases, wherein inheritable blood is wanting, may be collected from the rules of descent laid down and explained in the preceding chapter, and therefore will need very little illustration or comment. First, when the tenant dies without any relations on the part of any of his ancestors. Secondly, when he dies without any relations on the part of those ancestors from whom his estate descended. Thirdly, when he dies without any relations of the whole blood. In two of these cases, the blood of the first purchaser is certainly, in the other it is probably, at an end. And therefore, in all of them, the law directs that the land shall escheat to the lord of the fee, for the lord would be manifestly prejudiced if, contrary to the inherent condition tacitly annexed to all feuds, any person should be suffered to succeed to lands who is not of the blood of the first feudatory, to whom for his personal merit the estate is supposed to have been granted. 4. A monster which hath not the shape of mankind, but in any part evidently bears the resemblance of the brute creation, hath no inheritable blood, and cannot be heir to any land, albeit brought forth in marriage. But although it hath deformity in any part of its body, yet if it hath human shape, it may be heir. This is a very ancient rule in the law of England, and its reason is too obvious and too shocking to bear in minute discussion. The Roman law agrees with our own in excluding such births from succession, yet accounts them, however, children in some respects, where the parents, or at least the father, could reap any advantage thereby, as the jus trium liberum and the like, esteeming them the misfortune rather than the fault of that parent. But our law will not admit a birth of this kind to be such an issue as shall entitle the husband to be tenant by the courtesy, because it is not capable of inheriting, and therefore, if there appears no other heir than such a prodigious birth, the land shall escheat to the lord. 5. Bastards are incapable of being heirs. Bastards, by our laws, are such children as are not born either in lawful wedlock or within a competent time after its determination. Such are held to be nullius filii, the sons of nobody, for the maxim of law is qui ex domnato coitu nascuntur, inter liberos non compuntantur. Being thus the sons of nobody, they have no blood in them, at least no inheritable blood, consequently none of the blood of the first purchaser, and therefore, if there be no other claimant than such illegitimate children, the land shall escheat to the lord. The civil law differs from ours in this point, and allows a bastard to succeed to an inheritance if after its birth the mother was married to the father, and also if the father had no lawful wife or child, then, even if the concubine was never married to the father, yet she and her bastard son were admitted each to 1/12 of the inheritance, and a bastard was likewise capable of succeeding to the whole of his mother's estate, although she was never married, the mother being sufficiently certain, though the father is not. But our law, in favor of marriage, is much less indulgent to bastards. There is indeed one instance in which our law has shown them some little regard, and that is usually termed the case of bastard aine and mulier puisne. This happens when a man has a bastard son and afterwards marries the mother, and by her has a legitimate son, who in the language of the law is called mulier, or as Glanville expresses it in his Latin, filius mulieratus, the woman before marriage being concubina and afterwards mulier. Now here the eldest son is a bastard, or bastard aine, and the younger son is legitimate, or mulier puisne. If then the father dies, and the bastard aine enters upon the land, and enjoys it to his death, and dies seized thereof, whereby the inheritance descends to his issue, in this case the mulier puisne and all his heirs, though minors, fem coverts, or under any incapacity whatsoever, are totally barred of their right. And this, 1. As a punishment on the mulier for his negligence for not entering during the bastard's life and evicting him. 2. Because the Lord will not suffer a man to be bastardized after his death, who entered as heir and died seized, and so passed for legitimate in his lifetime. 3. Because the canon law, following the civil, did allow such bastard aine to be legitimate on the subsequent marriage of his mother, and therefore the laws of England, though they would not admit either the civil or canon law to rule in inheritances of this kingdom, yet paid such a regard to a person thus particularly circumstanced, that after the land had descended to his issue, they would not unravel the matter again, and suffer his estate to be shaken. But this indulgence was shown to no other kind of bastard, for if the mother was never married to the father, such bastard could have no colorable title at all. As bastards cannot be heirs themselves, so neither can they have any heirs but those of their own bodies. For, as collateral kindred consists in being derived from the same common ancestor, and as a bastard has no legal ancestors, he can have no collateral kindred, and consequently can have no legal heirs but such as claim by a lineal descent from himself. And therefore, if a bastard purchases land, and dies seized thereof without issue and intestate, the land shall escheat to the lord of the fee. 6. Aliens also are incapable of taking by descent or inheriting, for they are not allowed to have any inheritable blood in them. Rather, indeed, upon a principle of national or civil policy than upon reasons strictly feudal. Though, if lands had been suffered to fall into the hands who owe no allegiance to the crown of England, the design of introducing our feuds, the defense of the kingdom, would have been defeated. Wherefore, if a man leaves no other relations but aliens, his land shall escheat to the Lord. As aliens cannot inherit, so far they are on a level with bastards, but as they are also disabled to hold by purchase, they are under still greater disabilities. And as they can neither hold by purchase nor by inheritance, it is almost superfluous to say that they can have no heirs, since they can have nothing for an heir to inherit. But so it is expressly holden, because they have not in them any inheritable blood. And farther, if an alien be made a denizen by the king's letters patent, and then purchases lands, which the law allows such a one to do, his son, born before his denization, shall not, by the common law, inherit those lands, but a son born afterwards may, even though his elder brother be living. For the father, before denization, had no inheritable blood to communicate to his eldest son. But by denization it acquires an hereditary quality which will be transmitted to his subsequent posterity. Yet, if he had been naturalized by act of Parliament, such eldest son might then have inherited, for that cancels all defects and is allowed to have a retrospective energy which simple denization has not. End of chapter 15, part 1. Chapter 15, Part 2 of the Commentaries on the Laws of England by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Of Title by Purchase and First by Escheat. Part 2. Sir Edward Coke also holds that if an alien cometh into England, and there hath issue two sons, who are thereby natural born subjects, and one of them purchases land, and dies, yet neither of these brethren can be heir to the other. For the commune vinculum, or common stock of their consanguinity, is their father. And as he had no inheritable blood in him, he could communicate none to his sons. And when the sons can by no possibility be heirs to the father, the one of them shall not be heir to the other. And this opinion of his seems founded upon solid principles of the ancient law, not only from the rule before cited, that cestue, que duit inheriter al pere, doit inheritere al fils, but also because we have seen that the only feudal foundation upon which newly purchased land can possibly descend to a brother is the supposition and fiction of law that it descended from some one of his ancestors. But in this case, as the immediate ancestor was an alien, from whom it could by no possibility descend, this should destroy the supposition and impede the descent, and the land should be inherited ut feudum stricte novum, that is, by none but the lineal descendants of the purchasing brother, and on failure of them should escheat to the lord of the fee. But this opinion hath been since overruled, and it is now held for the law that the sons of an alien born here may inherit to each other. And reasonably enough upon the whole, for, as in common purchases, the whole of the supposed descent from indefinite ancestors is but fictitious, the law may as well suppose the requisite ancestor as suppose the requisite descent. It is also enacted by the statute 11 and 12 William III c. 6 that all persons being natural born subjects of the king may inherit and make their titles by descent from any of their ancestors, lineal or collateral, although their father or mother or other ancestor, by, from, through, or under whom they derived their pedigrees, were born out of the king's allegiance. but inconveniences were afterwards apprehended, in case persons should thereby gain a future capacity to inherit, who did not exist at the death of the person last seized. As, if Francis, the elder brother of John Styles, be an alien, and Oliver, the younger, be a natural born subject, upon John's death, without issue, his lands will descend to Oliver, the younger brother. Now, if afterwards Francis hath a child, it was feared that, under the statute of King William, this newborn child might defeat the estate of his uncle Oliver. Wherefore it is provided by the statute 25 George II, c. 39, that no right of inheritance shall accrue by virtue of the former statute to any persons whatsoever, unless they are in being and capable to take as heirs at the death of the person last seized. With an exception, however, to the case where lands shall descend to the daughter of an alien, which daughter shall resign such inheritance to her afterborn brother, or divide it with her afterborn sisters, according to the usual rule of descents by the common law. 7. By attainder also, for treason or other felony, the blood of the person attainted is so corrupted as to be rendered no longer inheritable. Great care must be taken to distinguish between forfeiture of lands to the king and this species of escheat to the lord, which, by reason of their similitude in some circumstances, and because the crown is very frequently the immediate lord of the fee, and therefore entitled to both, have been often confounded together. Forfeiture of lands, and whatever else the offender possessed, was the doctrine of the old Saxon law as part of the punishment for the offense, and does not at all relate to the feudal system, nor is the consequence of any seigniory or lordship paramount, but being a prerogative vested in the crown, was neither superseded nor diminished by the introduction of the Norman tenures, a fruit and consequence of which escheat must undoubtedly be reckoned. Escheat, therefore, operates in subordination to this more ancient and superior law of forfeiture. The doctrine of escheat upon attainder, taking singly, is this, that the blood of the tenant, by the commission of any felony, under which denomination all treasons were formerly comprised, is corrupted and stained, and the original donation of the feud is thereby determined, it being always granted to the vassal on the implied condition of dum bene se gesseret. Upon the thorough demonstration of which guilt by legal attainder, the feudal covenant and mutual bond of fealty are held to be broken, the estate instantly falls back from the offender to the lord of the fee, and the inheritable quality of his blood is extinguished and blotted out forever. In this situation, the law of feudal escheat was brought into England at the Conquest, and in general superadded to the ancient law of forfeiture. In consequence of which corruption and extinction of hereditary blood, the land of all felons would immediately invest in the lord, but the superior law of forfeiture intervenes and intercepts in its passage, in case of treason, forever, in case of other felony, for only a year and a day, after which time it goes to the lord in a regular course of escheat, as it would have done to the heir of the felon in case the feudal tenures had never been introduced. And that this is the true operation and genuine history of escheats will most evidently appear from this incident to Gavelkind lands, which seem to be the old Saxon tenure, that they are in no case subject to escheat for felony, though they are liable to forfeiture for treason. As a consequence of this doctrine of escheat, all lands of inheritance immediately revesting in the lord, the wife of the felon was liable to lose her dower, till the statute 1 Edward VI, c. 12, enacted, that albeit any person be attainted for misprision of treason, murder, or felony, yet his wife shall enjoy her dower. But she has not this indulgence where the ancient law of forfeiture operates, For it is expressly provided by the statute 5 and 6 Edward VI, c. 11, that the wife of one attaint of high treason shall not be endowed at all. Hitherto we have only spoken of estates vested in the offender at the time of his offense or attainder, and here the law of forfeiture stops, but the law of Escheats pursues the matter still farther. For, the blood of the tenant being utterly corrupted and extinguished, it follows not only that all he now has should escheat from him, but also that he should be incapable of inheriting anything for the future. This may farther illustrate the distinction between forfeiture and escheat. If, therefore, a father be seized in fee, and the son commits treason and is attainted, and then the father dies, here the land shall escheat to the lord, because the son, by the corruption of his blood, is incapable to be heir, and there can be no other heir during his life. But nothing shall be forfeited to the king, for the son never had any interest in the lands to forfeit. In this case, the escheat operates, and not the forfeiture, but in the following instance the forfeiture works, and not the escheat. As where a new felony is created by act of Parliament, and is provided, as is frequently the case, that it shall not extend to the corruption of blood. Here the lands of the felon shall not escheat to the lord, but yet the profits of them shall be forfeited to the king so long as the offender lives. There is yet a farther consequence of the corruption and extinction of hereditary blood, which is this, that the person attainted shall not only be incapable himself of inheriting or transmitting his own property by heirship, but shall also obstruct the descent of lands or tenements to his posterity in all cases where they are obliged to derive their title through him from any remoter ancestor. This channel, which conveyed the hereditary blood from his ancestor to him, is not only exhausted for the present, but totally dammed up and rendered impervious for the future. This is a refinement upon the ancient law of feuds, which allowed that the grandson might be heir to his grandfather, though the son in the intermediate generation was guilty of felony. But by the law of England, a man's blood is so universally corrupted by attainder that his sons can neither inherit to him nor to any other ancestor, at least on the part of their attainted father. This corruption of blood cannot be absolutely removed by authority of Parliament. The king may excuse the public punishment of an offender, but cannot abolish the private right which has accrued or may accrue to individuals as a consequence of the criminal's attainder. He may remit a forfeiture in which the interest of the crown alone is concerned, but he cannot wipe away the corruption of blood, for therein a third person hath an interest, the lord who claims by escheat. If therefore a man hath a son, and is attainted, and afterwards pardoned by the king, this son can never inherit to his father, or the father's ancestors, because his paternal blood, being once thoroughly corrupted by his father's attainder, must continue so. But if his son had been born after the pardon, he might inherit, because by the pardon the father is made a new man, and may convey new inheritable blood to his after-born children. Herein there is, however, a difference between aliens and persons attainted. Of aliens who could never by any possibility be heirs, the law takes no notice, and therefore we have seen that an alien elder brother shall not impede the descent to a natural-born younger brother. But in attainters it is otherwise. For if a man hath issue a son, and is attainted, and afterwards pardoned, then he hath issue a second son, and dies. Here the corruption of blood is not removed from the eldest, and therefore he cannot be heir. Neither can the youngest be heir, for he hath an elder brother living, of whom the law takes notice, as he once had a possibility of being heir. And therefore the younger brother shall not inherit, but the land shall escheat to the lord. Though, Had the elder died without issue in the life of the father, the younger son born after the pardon might well have inherited, for he hath no corruption of blood. So if a man hath issue two sons, and the elder in the lifetime of the father hath issue, and then is attainted and executed, and afterwards the father dies, the lands of the father shall not descend to the younger son, for the issue of the elder, which had once a possibility to inherit, shall impede the descent to the younger, and the land shall escheat to the Lord. Sir Edward Coke in this case allows that if the ancestor be attainted, his sons born before the attainder may be heirs to each other, and distinguishes it from the case of sons of an alien, because in this case the blood was inheritable when imparted to them from the father. But he makes a doubt upon the same principles which are now overruled, whether the sons, born after the attainder, can inherit to each other, for they never had any inheritable blood in them. Upon the whole, it appears that a person attainted is neither allowed to retain his former estate, nor to inherit any future one, nor to transmit any inheritance to his issue, either immediately from himself, or immediately through himself from any remoter ancestor, for his inheritable blood, which is necessary either to hold, to take, or to transmit any feudal property, is blotted out, corrupted, and extinguished forever, the consequence of which is that estates, thus impeded in their descent, result back and escheat to the Lord. This corruption of blood, thus arising from feudal principles, but perhaps extended farther than even those principles will warrant, has been long looked upon as a peculiar hardship, because, the oppressive parts of the feudal tenures being now in general abolished, it seems unreasonable to reserve one of their most inequitable consequences, namely, that the children should not only be reduced to present poverty, which, however severe, is sufficiently justified upon reasons of public policy, but also be laid under future difficulties of inheritance on account of the guilt of their ancestors. And therefore, in most, if not all, of the new felonies created by Parliament since the reign of Henry VIII, it is declared that they shall not extend to any corruption of blood, and by the statute 7 Ann c. 21, the operation of which is postponed by the statute 17 George II. c. 39, it is enacted that, after the death of the pretender and his sons, no attainder for treason shall extend to the disinheriting any heir, nor the prejudice of any person other than the offender himself, which provisions have indeed carried the remedy farther than was required by the hardship above complained of, which is only the future obstruction of descents, where the pedigree happens to be deduced through the blood of an attainted ancestor. Before I conclude this head of Escheat, I must mention one singular instance in which lands held in fee simple are not liable to escheat to the Lord, even when their owner is no more and hath left no heirs to inherit them. And this is the case of a corporation. For if that comes by any accident to be dissolved, the donor or his heirs shall have the land again in reversion, and not the lord by escheat, which is perhaps the only instance where a reversion can be expectant on a grant in fee simple absolute. But the law, we are told, doth tacitly annex a condition to every such gift or grant, that if the corporation be dissolved, the donor or grantor shall re-enter, for the cause of the gift or grant faileth. This is indeed founded upon the self-same principle as the law of Escheat, the heirs of the donor being only substituted instead of the chief lord of the fee, which was formerly very frequently the case in sub-infeudations or alienations of land by a vassal to beholden as of himself, till that practice was restrained by the statute of Quia Emptoris, 18 Edward I, section 1, to which this very singular instance still in some degree remains an exception. There is one more incapacity of taking by descent, which, not being productive of any escheat, is not properly reducible to this head, and yet must not be passed over in silence. It is enacted by the statute 11 and 12 William III, c. 4, that every papist who shall not abjure the errors of his religion by taking the oaths to the government, and making the declaration against transubstantiation within 6 months after he has attained the age of 18 years, shall be incapable of inheriting or taking by descent as well as purchase any real estates whatsoever, and his next of kin, being a Protestant, shall hold them to his own use till such time as he complies with the terms imposed by the Act. This incapacity is merely personal. It affects himself only, and does not destroy the inheritable quality of his blood so as to impede the descent to others of his kindred. In like manner as, even in the times of popery, one who entered into religion and became a monk professed was incapable of inheriting lands, both in our own and the feudal law. Eo quod desit esse maius seculi, qui factos est de maius Christi, nete beneficium pertinet ad ueme, qui non debet terere officium. But yet he was accounted only civiliter mortus. He did not impede the descent to others, but the next heir was entitled to his or his ancestors' estate. These are the several deficiencies of hereditary blood recognized by the law of England, which so often as they happen, occasion lands to escheat to the original proprietary or lord. End of chapter 15, part 2. Chapter 16 of the Commentaries on the Laws of England, Book 2, by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Of title by occupancy. Occupancy is the taking possession of those things which before belonged to nobody. This, as we have seen, is the true ground and foundation of all property, or of holding those things in severalty, which by the law of nature, unqualified by that of society, were common to all mankind. But when once it was agreed that everything capable of ownership should have an owner, natural reason suggested that he who could first declare his intention of appropriating anything to his own use, and, in consequence of such intention, actually took it into possession, should thereby gain the absolute property of it, according to that rule of the law of nations, recognized by the laws of Rome, quod nullius est, id ratione naturale occupante conceditor. This right of occupancy, so far as it concerns real property, for of personal chattels I am not in this place to speak, hath been confined by the laws of England within a very narrow compass, and was extended only to a single instance, namely, where a man was tenant pour arte vie, or had an estate granted to himself only, without mentioning his heirs, for the life of another man, and died during the life of cestui que vie, or him by whose life it was holden. In this case he, that could first enter on the land, might lawfully retain the possession so long as cestui que vie lived by right of occupancy. This seems to have been recurring to first principles, and calling in the law of nature to ascertain the property of the land when left without a legal owner. For it did not revert to the grantor, who had parted with all his interest so long as cestui que vie lived. It did not escheat to the lord of the fee, for all escheats must be of the absolute entire fee, and not of any particular estate carved out of it, much less of so minute a remnant as this. It did not belong to the grantee, for he was dead. It did not descend to his heirs, for there were no words of inheritance in the grant. Nor could it vest in his executors, for no executors could succeed to a freehold. Belonging therefore to nobody, like the arreditas dain of the Romans, the law left it open to be seized and appropriated by the first person that could enter upon it during the life of cestuicavi under the name of an occupant. But there was no right of occupancy allowed where the king had the reversion of the lands. For the reversioner hath an equal right with any other man to enter upon the vacant possession, and where the king's title and his subjects concur, the king shall always be preferred. Against the king, therefore, there could be no prior occupant, because nullum tempus occurret regi. And, even in the case of a subject, had the estate pour auter vi been granted to a man and his heirs during the life of cestuicavi, there the heir might, and still may, enter and hold possession, and is called in law a special occupant, as having a special exclusive right, by the terms of the original grant, to enter upon and occupy this arreditas gescens during the residue of the estate granted, though some have thought him so called with no very great propriety, and that such an estate is rather a descendable freehold. But the title of common occupancy is now reduced almost to nothing by two statutes. The one, 29 Charles II, c. 3, which enacts that where there is no special occupant in whom the estate may vest, the tenant pour auter vi may devise it by will, or it shall go to the executors and be assets in their hands for payment of debts. The other, that of 14 George II, c. 20, which enacts that it shall vest not only in the executors, but, in case the tenant dies intestate, in the administrators also, and go in a course of distribution like a chattel interest. By these two statutes the title of common occupancy is utterly extinct and abolished, though that of special occupancy, by the heir at law, continues to this day. Such heir being held to succeed to the ancestor's estate, not by descent, for then he must take an estate of inheritance, but as an occupant, specially marked out and appointed by the original grant. The doctrine of common occupancy may, however, be usefully remembered on the following account among others, that, as by the common law no occupancy could be of incorporeal hereditaments, as of rents, tithes, advowsons, commons, or the like, because with respect to them there could be no actual entry made or corporal season had, and therefore by the death of the grantee pour auter vi, a grant of such hereditaments was entirely determined. So now, I apprehend, notwithstanding these statutes, such grant would be determined likewise, and the hereditaments would not be divisible, nor vest in the executors, nor go in a course of distribution. For the statutes must not be construed so as to create any new estate, or to keep that alive which by common law was determined, and thereby to defer the grantor's reversion, but merely to dispose of an interest in being, to which by law there was no owner, and which therefore was left open to the first occupant. When there is a residue left, the statutes give it to the executors, etc., instead of the first occupant, but they will not create a residue on purpose to give it to the executors. They only meant to provide an appointed instead of a casual, a certain instead of uncertain owner of lands which before were nobodies, and thereby to supply this casus omissus, and render the disposition of law in all respects entirely uniform, this being the only instance wherein a title to real estate could ever be acquired by occupancy. This, I say, was the only instance, for I think there can be no other case devised wherein there is not some owner of the land appointed by the law. In the case of a sole corporation, as a parson of a church, when he dies or resigns, though there is no actual owner of the land till a successor be appointed, yet there is a legal potential ownership subsisting in contemplation of law. And when the successor is appointed, his appointment shall have a retrospect and relation backwards, so as to entitle him to all the profits from the instant that the vacancy commenced. And in all other instances where the tenant dies intestate, and no other owner of the lands is to be found in the common course of descents, there the law vests an ownership in the king or in the subordinate lord of the fee by escheat. So also in some cases, where the laws of other nations give a right by occupancy, as in lands newly created, by the rising of an island in a river, or by the alluvium or dereliction of the sea, in these instances the law of England assigns them an immediate owner. For Blackstone tells us that if an island arise in the middle of a river, it belongs in common to those who have lands on each side thereof. But if it be nearer to one bank than the other, it belongs only to him who is proprietor of the nearest shore, which is agreeable to, and probably copied from, the civil law. Yet this seems only to be reasonable, where the soil of the river is equally divided between the owners of the opposite shores. For if the whole soil is the freehold of any one man, as it must be whenever a several fishery is claimed, there it seems just, and so is the usual practice, that the eyots or little islands arising in any part of the river shall be the property of him who owneth the piscary and the soil. However, in case a new island rise in the sea, though the civil law gives it to the first occupant, yet ours gives it to the king. And as to lands gained from the sea, either by alluvion, by the washing up of land and earth, so as in time to make terra firma, or by dereliction, as when the sea shrinks back below the usual watermark, in these cases the law is held to be that if this gain be by little and little, by small and imperceptible degrees, it shall go to the owner of the land adjoining. For de minimis non curat lex. And besides, these owners, being often losers by the breaking in of the sea, or at charges to keep it out, this possible gain is therefore a reciprocal consideration for such possible charge or loss. But if the alluvion or dereliction be sudden or considerable, in this case it belongs to the king. For, as the king is lord of the sea, and so owner of the soil while it is covered with water, it is but reasonable he should have the soil when the water has left it dry. So that the quantity of ground gained, and the time during which it is gaining, are what make it either the king's or the subject's property. In the same manner, if a river, running between two lordships, by degrees gains upon the one, and thereby leaves the other dry, the owner, who loses his ground thus imperceptibly, has no remedy. But if the course of the river be changed by a sudden and violent flood, or other hasty means, and thereby a man loses his ground, he shall have what the river has left in any other place, as a recompense for this sudden loss. And this law of alluvions and derelictions, with regard to rivers, is nearly the same in the imperial law, from whence, indeed, those our determinations seem to have been drawn and adopted. But we ourselves, as islanders, have applied them to marine increases, and have given our sovereign the prerogative he enjoys, as well upon the particular reasons before mentioned, as upon this other general ground of prerogative, which was formerly remarked, that whatever hath no other owner is vested by law in the king. End of chapter 16. Chapter 17 of the Commentaries on the Laws of England, Book 2, by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Of title by prescription. A third method of acquiring real property by purchase is that by prescription, as when a man can show no other title to what he claims than that he and those under whom he claims have immemorially used to enjoy it. Concerning customs or immemorial usages in general, with the several requisites and rules to be observed in order to prove their existence and validity, we inquired at large in the preceding part of these commentaries. At present, therefore, I shall only first distinguish between custom strictly taken and prescription, and then show what sort of things may be prescribed for. And first, the distinction between custom and prescription is this, that custom is properly a local usage, and not annexed to any person, such as a custom in the manner of Dale that lands shall descend to the youngest son. Prescription is merely a personal usage, as that Sempronius and his ancestors, or those whose estate he hath, have used time out of mind to have such an advantage or privilege. As, for example, if there be a usage in the parish of Dale that all the inhabitants of that parish may dance on a certain close at all times for their recreation, which is held to be a lawful usage, this is strictly a custom, for it is applied to the place in general and not to any particular persons. But if the tenant, who is seized of the manor of Dale in fee, alleges that he and his ancestors, or all those whose estate he hath in said manor, have used time out of mind to have common of pasture in such a close, this is properly called a prescription, for this is a usage annexed to the person of the owner of this estate. All prescription must be either in a man and his ancestors, or in a man and those whose estate he hath, which last is called prescribing in a que estate. And formerly a man might, by the common law, have prescribed for a right which had been enjoyed by his ancestors or predecessors at any distance of time, though his or their enjoyment of it be suspended for an indefinite series of years. But by the statute of limitations, 32 Henry VIII, c. 2, it is enacted that no person shall make any prescription by the season or possession of his ancestor or predecessor, unless such season or possession hath been within 80 years next before such prescription made. Secondly, as to the several species of things which may or may not be prescribed for, we may in the first place observe that nothing but incorporeal hereditaments can be claimed by prescription, as a right of way, a common, etc., but that no prescription can give a title to lands and other corporeal substances, of which more certain evidence may be had. For no man can be said to prescribe that he and his ancestors have immemorially used to hold the castle of Arundel, for this is clearly another sort of title, a title by corporal season and inheritance, which is more permanent and therefore more capable of proof than that of prescription. But as to a right of way, a common, or the like, a man may be allowed to prescribe, for of these there is no corporal season. The enjoyment will be frequently by intervals, and therefore the right to enjoy them can depend on nothing else but immemorial usage. 2. A prescription must always be laid in him that is a tenant of the fee. A tenant for life 4 years at will or a copyholder cannot prescribe by reason of the imbecility of their estates. For as prescription is usage beyond time of memory, it is absurd that they should pretend to prescribe whose estates commenced with the remembrance of man. And therefore the copyholder must prescribe under cover of his lord's estate, and the tenant for life under cover of the tenant in fee simple. As, if the tenant for life of a manor would prescribe for a right of common as appurtenant to the same, he must prescribe under cover of the tenant in fee simple, and must plead that John Stiles and his ancestors had immemorially used to have this right of common appurtenant to the said manor, and that John Stiles demised the said manor with its appurtenances to him the said tenant for life. 3. A prescription cannot be for a thing which cannot be raised by grant. For the law allows prescription only in supply of the loss of a grant, and therefore every prescription presupposes a grant to have existed. Thus, a lord of a manor cannot prescribe to raise a tax or toll upon strangers, for, as such claim could never have been good by any grant, it shall not be good by prescription. 4. A fourth rule is, that what is to arise by matter of record cannot be prescribed for, but must be claimed by grant entered on record, such as, for instance, the royal franchises of deodans, felons' goods, and the like. These, not being forfeited till the matter on which they arise is found by the inquisition of a jury, and so made a matter of record, the forfeiture itself cannot be claimed by any inferior title. But the franchises of treasure trove, waifs, estrays, and the like, may be claimed by prescription, for they arise from private contingencies and not from any matter of record. 5. Among things incorporeal which may be claimed by prescription, a distinction must be made with regard to the manner of prescribing. That is, whether a man shall prescribe in que estate or in himself and his ancestors. For if a man prescribes in que estate, that is, in himself and those whose estate he holds, nothing is claimable by this prescription but such things as are incident, appendant, or appurtenant to the lands. For it would be absurd to claim anything as the consequence or appendix of an estate with which the thing claimed has no connection, but if he prescribes in himself and his ancestors, he may prescribe for anything whatsoever that lies in grant, not only things that are appurtenant, but also such as may be in gross. Therefore, a man may prescribe that he and those whose estate he hath in the manor of Dale have used to hold the avowson of Dale as appendant to that manor. But if the avowson be a distinct inheritance and not appendant, then he can only prescribe in his ancestors. So also a man may prescribe in a que estate for a common appurtenant to a manor. But if he would prescribe for a common in gross, he must prescribe in himself and his ancestors. 6. Lastly, we may observe that estates gained by prescription are not, of course, descendable to the heirs general like other purchased estates, but are an exception to the rule. For, properly speaking, the prescription is rather to be considered as an evidence of a former acquisition than as an acquisition de novo, and therefore, if a man prescribes for a right of way in himself and his ancestors, it will descend only to the blood of that line of ancestors in whom he so prescribes, the prescription in this case being indeed a species of descent. But if he prescribes for it in que estate, it will follow the nature of that estate in which the prescription is laid, and be inheritable in the same manner, whether that was acquired by descent or purchase, for every accessory followeth the nature of its principle. End of chapter 17. Chapter 18, Part 1 of the Commentaries on the Laws of England, Book 2, by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Of title by Forfeiture. Part 1. Forfeiture is a punishment annexed by law to some illegal act or negligence in the owner of lands, tenements, or hereditaments, whereby he loses all his interest therein, and they go to the party injured as a recompense for the wrong which either he alone or the public together with himself hath sustained. Lands, tenements, and hereditaments may be forfeited in various degrees and by various means. 1. By crimes and misdemeanors. 2. By alienation contrary to law. 3. By non-presentation to a benefice when the forfeiture is denominated a lapse. 4. By simony. 5. By non-performance of conditions. 6. By waste. 7. By breach of copyhold customs. 8. By bankruptcy. 1. The foundation and justice of forfeitures for crimes and misdemeanors, and the several degrees of those forfeitures proportioned to the several offenses, have been hinted at in the preceding volume, but will be more properly considered and more at large in the fourth book of these commentaries. At present I shall only observe in general that the offenses which induce a forfeiture of lands and tenements to the Crown are principally the following six: 1. Treason. 2. Felony. 3. Misprision of treason. 4. Praemunire. 5. Drawing a weapon on a judge or striking anyone in the presence of the king's principal courts of justice. 6. Popish recusancy, or non-observance of certain laws enacted in restraint of papists. But at what time they severally commence, how far they extend, and how long they endure, will with greater propriety be reserved as the object of our future enquiries. 2. Lands and tenements may be forfeited by alienation or conveying them to another contrary to law. This is either alienation in mortmain, alienation to an alien, or alienation by particular tenants. In two of the former of which cases the forfeiture arises from the incapacity of the alienee to take, in the latter from the incapacity of the alienor to grant. 1. Alienation in mortmain, in mortua manu, is alienation of lands or tenements to any corporation, sole or aggregate, ecclesiastical or temporal. But these purchases have been chiefly made by religious houses, in consequence whereof the lands became perpetually inherent in one dead hand. This hath occasioned the general appellation of mortmain to be applied to such alienations, and the religious houses themselves to be principally considered in forming the statutes of mortmain. In deducing the history of which statutes, it will be a matter of curiosity to observe the great address and subtle contrivance of the old ecclesiastics in eluding from time to time the laws in being, and the zeal with which successive parliaments have pursued them through all their finesses. How new remedies were still the parents of new evasions, till the legislature at last, though with difficulty, hath obtained a decisive victory. By the common law, any man might dispose of his lands to any other private man at his own discretion, especially when the feudal restraints of alienation were worn away. Yet, in consequence of these, it was always, and is still necessary, for corporations to have a license of mortmain from the crown, to enable them to purchase lands. For as the king is the ultimate lord of every fee, he ought not, unless by his own consent, to lose his privilege of escheats and other feudal profits by the vesting of lands in tenements that can never be attainted or die. And such licenses of mortmain seem to have been necessary among the Saxons above 60 years before the Norman conquest. But, besides this general license from the king, as lord paramount of the kingdom, it was also requisite, whenever there was a mean or intermediate lord between the king and the alienor, to obtain his license also, upon the same feudal principles, for the alienation of the specific land. And if no such license was obtained, the king or other lord might respectively enter on the lands so aliened in mortmain as a forfeiture. The necessity of this license from the Crown was acknowledged by the constitutions of Clarendon in respect of advowsons, which the monks always greatly coveted as being the groundwork of subsequent appropriations. Yet such were the influence and ingenuity of the clergy that, notwithstanding this fundamental principle, we find that the largest and most considerable dotations of religious houses happened within less than 2 centuries after the Conquest. And, when a license could not be obtained, their contrivance seems to have been this: that as the forfeitures for such alienations accrued in the first place to the immediate lord of the fee, the tenant who meant to alienate first conveyed his lands to the religious house, and instantly took them back again to hold as tenant to the monastery, which kind of instantaneous seizin was probably held not to occasion any forfeiture, and then, by pretext of some other forfeiture, surrender, or escheat, the society entered into those lands in right of such their newly acquired seigniory as immediate lords of the fee. But when these dotations began to grow numerous, it was observed that the feudal services ordained for the defense of the kingdom were every day visibly withdrawn, that the circulation of landed property from man to man began to stagnate, and that the lords were curtailed of the fruits of their seigniories, their escheats, wardships, reliefs, and the like, and therefore, in order to prevent this, it was ordained by the second of King Henry III's great charters, and afterwards by that printed in our common statute books, that all such attempts should be void, and the land forfeited to the lord of the fee. But, as this prohibition extended only to religious houses, bishops and other sole corporations were not included therein, and the aggregate ecclesiastical bodies, who, Sir Edward Coke observes, in this were to be commended that they ever had of their council the best learned men they could get, found many means to creep out of this statute by buying in lands that were bona fide holden of themselves as lord of the fee, and thereby evading the forfeiture; or by taking long leases for years, which first introduced those extensive terms for 1,000 or more years, which are now so frequent in conveyances. This produced the statute De Religiosis, 7 Edward I, which provided that no person, religious or other whatsoever, should buy or sell or receive under pretense of gift or term of years or any other title whatsoever, nor should any art or ingenuity appropriate to himself any lands or tenements in mortmain, upon pain that the immediate lord of the fee, or, on his default for 1 year, the lords paramount, and, in default of all of them, the king, might enter thereon as a forfeiture. This seemed to be a sufficient security against all alienations in mortmain. But, as these statutes extended only to gifts and conveyances between the parties, the religious houses now began to set up a fictitious title to the land, which it was intended they should have, to bring an action to recover it against the tenant, who, by fraud and collusion, made no defense, and thereby judgment was given for the religious house, which then recovered the land by sentence of law upon a supposed prior title. And thus they had the honor of inventing those fictitious adjudications of right, which are since become the great assurance of the kingdom, under the name of common recoveries. But upon this statute of Westminster II, 13 Edward I, c. 32 enacted, that in such cases a jury shall try the true right of the demandants or plaintiffs to the land, and if the religious house or corporation be found to have it, they shall still recover seizin; otherwise it shall be forfeited to the immediate lord of the fee, or else to the next lord, and finally to the king, upon the immediate or other lord's default. And the like provision was made by the succeeding chapter, in case the tenants set up crosses upon their lands, the badges of Knights Templars and Hospitallers, in order to protect them from the feudal demands of their lords by virtue of the privileges of those religious and military orders. And so careful was this provident prince to prevent any future evasions that when the statute of Quia Emptores, 18 Edward I, abolished all sub-infeudations and gave liberty for all men to alienate their lands to beholden of the next immediate lord, a proviso was inserted that this should not extend to authorize any kind of alienation in mortmain. And when afterwards the method of obtaining the king's license by writ of ad corda damnum was marked out by the statute 27 Edward I c. 2, it was farther provided by the statute 34 Edward I c. 3 that no such license should be effectual without the consent of the mean or intermediate lords. Yet still it was found difficult to set bounds to ecclesiastical ingenuity, for when they were driven out of all their former holds, they devised a new method of conveyance, by which the lands were granted not to themselves directly, but to nominal fees to the use of the religious houses, thus distinguishing between the possession and the use, and receiving the actual profits, while the season of the land remained in the nominal fee, who was held by the courts of equity, then under the direction of the clergy, to be bound in conscience to account to his chestway que use for the rents and emoluments of the estate. And it is to these inventions that our practisers are indebted for the introduction of uses and trusts, the foundation of modern conveyancing. But unfortunately for the inventors themselves, they did not long enjoy the advantage of their new device, for the statute 15 Richard II c. 5 enacts that the lands which had been so purchased to uses should be amortified by license from the crown, or else be sold to private persons, and that, for the future, uses shall be subject to the statutes of mortmain and forfeitable like the lands themselves. And whereas the statutes had been eluded by purchasing large tracts of land adjoining to churches and consecrating them by the name of churchyards, such subtle imagination is also declared to be within the compass of the statutes of mortmain. And civil or lay corporations, as well as ecclesiastical, are also declared to be within the mischief, and of course within the remedy provided by those statutory laws. And, lastly, as during the times of popery lands were frequently given to superstitious uses, though not to any corporate bodies, or were made liable in the hands of heirs and devasees to the charge of obits, chaunteries, and the like, which were equally pernicious in a well-governed state as actual alienations in mortmain. Therefore, at the dawn of the Reformation, the statute 23 Henry VIII c. 10 declares that all future grants of lands for any of the purposes aforesaid, if granted for any longer term than 20 years, shall be void. But during all this time it was in the power of the Crown, by granting a license of mortmain, to remit the forfeiture so far as related to its own rights, and to enable any spiritual or other corporation to purchase and hold any lands or tenements in perpetuity, which prerogative is declared and confirmed by the statute 18 Edward III ft. 3 c. 3. But as doubts were conceived at the time of the Revolution how far such license was valid, since the king had no power to dispense with the statutes of mortmain by a clause of non obstante, which was the usual course, though it seems to have been unnecessary, and as the gradual declination of mean seigniories, through the long operation of the statute of Quia Emptores, the rights of intermediate lords were reduced to a very small compass. It was therefore provided by the statutes 7 and 8 William III c. 37 that the Crown for the future, at its own discretion, may grant licenses to alien or take in mortmain of whomever the tenements may be holden. After the dissolution of monasteries under Henry VIII, though the policy of the next popish successor affected to grant a security to the possessors of abbey lands, yet, in order to regain so much of them as either the zeal or timidity of their owners might induce them to part with, the statutes of mortmain were suspended for 20 years by the statute 1 and 2 P and M C 8, and during that time any lands or tenements were allowed to be granted to any spiritual corporation without any license whatsoever. And, long afterwards, for a much better purpose, the augmentation of poor livings, it was enacted by the statute 17 Charles II C. 3 that appropriators may annex the great tithes to the vicarages, and that all benefices under £100 per annum may be augmented by the purchase of lands without license of mortmain in either case, and the like provision hath been since made in favor of the governors of Queen Anne's bounty. It hath also been held that the statute 23 Henry VIII before mentioned did not extend to anything but superstitious uses, and that therefore a man may give lands for the maintenance of a school and hospital and other charitable uses. But as it was apprehended from recent experience that persons on their deathbeds might make large and improvident dispositions even for these good purposes, and defeat the political ends of the statutes of mortmain, it is therefore enacted by the statute 9 George II C. 36 that no lands or tenements or money to be laid out thereon shall be given for or charged with any charitable uses whatsoever, unless by deed indented, executed in the presence of 2 witnesses 12 calendar months before the death of the donor, and enrolled in the Court of Chancery within 6 months after its execution, except stocks in the public funds, which may be transferred within 6 months previous to the donor's death, and unless such gift be made to take effect immediately, and be without power of revocation, and that all other gifts shall be void. The 2 universities, their colleges, and the scholars upon the foundation of colleges of Eton, Winchester, and Westminster are excepted out of this act, but such exemption was granted with this proviso, that no college shall be at liberty to purchase more advowsons than are equal in number to 1 moiety of the fellows or students upon the respective foundations. 2. Secondly, alienation to an alien is also a cause of forfeiture to the Crown of lands so alienated, not only on account of his incapacity to hold them, which occasions him to be passed in descents of lands, but likewise on account of his presumption in attempting, by an act of his own, to acquire any real property, as was observed in the preceding volume. 3. Lastly, alienations by particular tenants, when they are greater than the law entitles them to make, and divest remainder or reversion, are also forfeitures to him whose right is attacked thereby. As, if a tenant for his own life aliens by fiefment or fine for the life of another, or in tail, or in fee, these being estates which either must or may last longer than his own, the creating them is not only beyond his power and inconsistent with the nature of his interest, but also a forfeiture of his own particular estate to him in remainder or reversion. For which there seem to be 2 reasons. First, because such alienation amounts to a renunciation of the feudal connection and dependence. It implies a refusal to perform the due renders and services to the lord of the fee, of which fealty is constantly one, and it tends in its consequence to defeat and divest the remainder or reversion expectant. As therefore that is put in jeopardy by such act of the particular tenant, it is but just that, upon discovery, the particular estate should be forfeited and taken from him who has shown so manifest an inclination to make an improper use of it. The other reason is, because the particular tenant, by granting a larger estate than his own, has by his own act determined and put an entire end to his own original interest, and on such determination the next taker is entitled to enter regularly as in his remainder or reversion. The same law, which is thus laid down with regard to tenants for life, holds also with respect to all tenants of the mere freehold or of chattel interest. But if the tenant entail aliens in fee, this is no immediate forfeiture to the remainder man, but a mere discontinuance, as it is called, of the estate tail, which the issue may afterwards avoid by due course of law. For he in remainder or reversion hath only a very remote and barely possible interest therein, until the issue in tail is extinct. But in case of such forfeitures by particular tenants, all legal estates by them before created, as if tenant for 20 years grants a lease for 15, and all charges by him lawfully made on the lands, shall be good and available in law. For the law will not hurt an innocent lessee for the fault of his lessor, nor permit the lessor, after he has granted a good and lawful estate, by his own act to avoid it, and defeat the interest which he himself has created. Equivalent both in its nature and its consequences to an illegal alienation by the particular tenant is the civil crime of disclaimer, as where a tenant who holds of any lord neglects to render him the due services, and, upon an action brought to recover them, disclaims to hold of his lord. Which disclaimer of tenure in any court of record is a forfeiture of the lands to the lord, upon reasons most apparently feudal. And so likewise, if in any court of record the particular tenant does any act which amounts to a virtual disclaimer, if he claims any greater estate than was granted him at the first infeudation, or takes upon himself those rights which belong only to tenants of a superior class, if he affirms the reversion to be in a stranger, by accepting his fine, attorney as his tenant, collusive pleading, and the like, such behavior amounts to a forfeiture of his particular estate. End of Chapter 18, Part 1. Chapter 18, Part 2 of the Commentaries on the Laws of England, Book 2, by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Of Title by Forfeiture, Part 2. 3. Lapse is a species of forfeiture whereby the right of presentation to a church accrues to the ordinary by neglect of the patron to present, to the metropolitan by neglect of the ordinary, and to the king by neglect of the metropolitan. For it being for the interest of religion and the good of the public that the church should be provided with an officiating minister, the law has therefore given this right of lapse in order to quicken the patron, who might otherwise, by suffering the church to remain vacant, avoid paying his ecclesiastical dues and frustrate the pious intentions of his ancestors. This right of lapse was first established about the time, though not by the authority, of the Council of Lateran, which was in the reign of our Henry II, when the bishops first began to exercise universally the right of institution to churches. And therefore, where there is no right of institution, there is no right of lapse, so that no donative can lapse to the ordinary unless it hath been augmented by a queen's bounty. But no right of lapse can accrue when the original presentation is in the crown. The term in which the title to present by lapse accrues from one to the other successively is 6 calendar months, following in this case the computation of the church and not of the usual one of the common law, and this exclusive of the day of avoidance. But if the bishop be both patron and ordinary, he shall not have a double time allowed to him to collate in, For the forfeiture accrues by law whenever the negligence has continued 6 months in the same person. And also, if the bishop doth not collate his own clerk immediately to the living, and the patron presents, though after the 6 months are lapsed, yet his presentation is good, and the bishop is bound to institute the patron's clerk. For as the law only gives the bishop this title by lapse to punish the patron's negligence, there is no reason that, if the bishop himself be guilty of equal or greater negligence, the patron should be deprived of his turn. If the bishop suffer the presentation to lapse to the metropolitan, the patron also has the same advantage if he presents before the archbishop has filled up the benefice, and that for the same reason. Yet the ordinary cannot, after lapse to the metropolitan, collate his own clerk to the prejudice of the archbishop. For he had no permanent right and interest in the advowson, as the patron hath, but merely a temporary one, which having neglected to make use of during the time, he cannot afterwards retrieve it. But if the presentation lapses to the king, prerogative here intervenes and makes a difference, and the patron shall never recover his right till the king has satisfied his turn by presentation. For nullum tempus occurret regi, and therefore it may seem as if the church might continue void forever, unless the king shall be pleased to present, and a patron thereby be absolutely defeated of his advowson. But to prevent this inconvenience, the law has lodged a power in the patron's hands of as it were compelling the king to present. For if, during the delay of the crown, the patron himself presents, and the clerk is instituted, the king indeed, by presenting another, may turn out the patron's clerk, but if he does not, the patron's clerk dies incumbent, or is canonically deprived, the king hath lost his right, which was only to the next or first presentation. In case the benefice becomes void by death, the succession through plurality of benefices, there the patron is bound to take notice of the vacancy at his own peril. For these are matters of equal notoriety to the patron and ordinary. But in case of a vacancy by resignation or canonical deprivation, or if a clerk presented be refused for insufficiency, these being matters of which the bishop alone is presumed to be cognizant, here the law requires him to give notice thereof to the patron, otherwise he can take no advantage by way of lapse. Neither shall any lapse thereby accrue to the metropolitan or to the king, for it is universally true that neither the archbishop or the king shall ever present by lapse, but where the immediate ordinary might have collated by lapse within the 6 months, and hath exceeded his time. For the first step or beginning faileth, et quode non habet principium, non habet finem. If the bishop refuse or neglect to examine and admit the patron's clerk, without good reason assigned or notice given, he is styled a disturber by the law, and shall not have any title to present by lapse, for no man shall take advantage of his own wrong. Also, if the right of presentation be litigious or contested, and an action be brought against the bishop to try the title, no lapse shall incur until the question of right be decided. 4. By simony, the right of presentation to a living is forfeited and vested pro hoc vice in the crown. Simony is the corrupt presentation of anyone to an ecclesiastical benefice for money, gift, or reward. It is so called from the resemblance it is said to bear to the sin of Simon Magus, though the purchasing of holy orders seems to approach nearer to his offense. It was by the canon law a very grievous crime, and is so much the more odious because, as Sir Edward Coke observes, it is ever accompanied with perjury, for the presentee is sworn to have committed no simony. However, it is not an offense punishable in a criminal way at the common law. it being thought sufficient to leave the clerk to ecclesiastical censures. But as these did not affect the simonical patron, nor were efficacious enough to repel the notorious practice of the thing, diverse acts of Parliament have been made to restrain it by means of civil forfeitures, which the modern prevailing usage, with regard to spiritual preferments, calls aloud to be put in execution. I shall briefly consider them in this place, because they divest the corrupt patron of the right of presentation, and vest a new right in the crown. By the statute 31 Elizabeth c. 6, it is for avoiding of simony enacted, that if any patron for any corrupt consideration, by gift or promise, directly or indirectly, shall present or collate any person to an ecclesiastical benefice or dignity, such presentation shall be void, and the presentee be rendered incapable of ever enjoying the same benefice, and the crown shall present to it for that turn only. Also, by the statute 12 and ft2 c12, if any person for money or profit shall procure, in his own name or the name of any other, the next presentation to any living ecclesiastical, and shall be presented thereupon, this is declared to be a simonical contract, and the party is subjected to all the ecclesiastical penalties of simony, is disabled from holding the benefice, and the presentation devolves to the crown. Upon these statutes many questions have arisen with regard to what is and what is not simony, and among others these points seem to be clearly settled. 1. That to purchase a presentation, the living being actually vacant, is open and notorious simony, this being expressly in the face of the statute. 2. That for a clerk to bargain for the next presentation, the incumbent being sick and about to die, was simony, even before the statute of Queen Anne, and now, by that statute, to purchase, either in his own name or another's, the next presentation, and be thereupon presented at any future time to the living, is direct and palpable simony. But 3. It is held that for a father to purchase such a presentation in order to provide for his son is not simony, for the son is not concerned in the bargain, and the father is by nature bound to make a provision for him. 4. That if a simonical contract be made with the patron, the clerk not being privy thereto, the presentation for that turn shall indeed devolve to the crown, as a punishment of the guilty patron, but the clerk, who is innocent, does not incur any disability or forfeiture. 5. That bonds given to pay money to charitable uses, on receiving a presentation to a living, are not simonical, provided the patron or his relations be not benefited thereby, for this is no corrupt consideration moving to the patron. 6. That bonds of resignation, in case of non-residence or taking any other living, are not simonical, there being no corrupt consideration herein, but such only as is for the good of the public. So also, bonds to resign, when the patron's son comes to canonical age, are legal, upon the reason before given, that the father is bound to provide for his son. 7. Lastly, general bonds to resign at the patron's request are held to be legal, for they may possibly be given for one of the legal considerations before mentioned, and, where there is a possibility that a transaction may be fair, the law will not suppose it iniquitous without proof. But if the party can prove the contract to have been a corrupt one, such proof will be admitted in order to show the bond simonical and therefore void. Neither will the patron be suffered to make an ill use of such a general bond of resignation, as by extorting a composition for tithes, procuring an annuity for his relation, or by demanding a resignation wantonly and without good cause, such as is approved by the law, as for the benefit of his own son, or on account of non-residence, plurality of livings, or gross immorality in the incumbent. 5. The next kind of forfeitures are those by breach or non-performance of a condition annexed to the estate, either expressly by deed at its original creation or impliedly by law from a principle of natural reason, both of which we considered at large in a former chapter. 6. I therefore now proceed to another species of forfeiture, viz. by waste. Waste, vastum, is a spoil or destruction in houses, gardens, trees, or other corporeal hereditament to the disherition of him that hath the remainder or reversion in fee simple or fee tail. Waste is either voluntary, which is a crime of commission, as by pulling down a house, or it is permissive, which is a matter of omission only, as by suffering it to fall for want of necessary reparations. Whatever does a lasting damage to the freehold or inheritance is waste. Therefore, removing wainscot, floors, or other things once fixed to the freehold of a house is waste. If a house be destroyed by tempest, lightning, or the like, this is an act of providence, and is no waste. But otherwise, if the house be burnt by the carelessness or negligence of the lessee, though now, by the statute 6 and C31, no action will lie against the tenant for an accident of this kind. Waste may also be committed in ponds, dove houses, warrens, and the like, by so reducing the number of creatures therein, that there will not be sufficient for the reversioner when he comes to the inheritance. Timber is also part of the inheritance. Such are oak, ash, and elm in all places, and in some particular countries, by local custom, where other trees are generally used for building, they are thereupon considered as timber, and to cut down such trees, or top them, or do any other act whereby the timber may decay, is waste. But underwood the tenant may cut down at any seasonable time that he pleases, and may take sufficient estovers of common right for houseboat and cartboat, unless restrained, which is usual, by particular covenants or exceptions. The conversion of land from one species to another is waste. To convert wood, meadow, or pasture into arable, to turn arable, meadow, or pasture into woodland, or to turn arable or woodland into meadow or pasture, are all of them waste. For as Sir Edward Coke observes, it not only changes the course of husbandry, but the evidence of the estate, when such a close, which is conveyed and described as pasture, is found to be arable, and a converso. And the same rule is observed, for the same reason, with regard to converting one species of edifice into another, even though it is improved in its value. To open the land to search for mines of metal, coal, etc., is waste, for that is a detriment to the inheritance. But if the pits or mines were open before, it is no waste for the tenant to continue digging them for his own use, for it is now become the mere annual profit of the land. These three are the general heads of waste, viz., in houses, in timber, and in land. Though, as was before said, whatever tends to the destruction or depreciating the value of the inheritance is considered by the law as waste. Let us next see who are liable to be punished for committing waste. And by the feudal law, feuds being originally granted for life only, we find that the rule was general for all vassals or feudatories. Si vassalis feudum disi peverit, aut insigne detrimento, deterius feceret privabitur. But in our ancient common law, the rule was by no means so large, for not only he that was seized of an estate of inheritance might do as he pleased with it, but also waste was not punishable in any tenant save only three persons, guardian in chivalry, tenant in dower, and tenant by the courtesy, and not in tenant for life or years. And the reason for the diversity was that the estate of the three former was created by the act of law itself, which therefore gave a remedy against them. But tenant for life or for years came in by the demise and lease of the owner of the fee, and therefore he might have provided against the committing of waste by his lessee, and if he did not, it was by his own default. But in favor of the owners of the inheritance, the statutes of Marlbridge and Gloucester provided that the writ of waste shall not only lie against tenants by the law of England or courtesy, and those in dower, but against any farmer or other that holds in any manner for life or years. So that for above 500 years past, all tenants for life or for any less estate have been punishable or liable to be impeached for waste, both voluntary and permissive, unless their leases be made, as sometimes they are, without impeachment of waste, absque impetitione vasti, that is, with a provision or protection that no man shall impetere or sue him for waste committed. The punishment for waste committed was, by common law and the statute of Marlbridge, only single damages, except in the case of a guardian who also forfeited his wardship by the provisions of the Great Charter. But the statute of Gloucester directs that the other four species of tenants shall lose and forfeit the place wherein the waste is committed, and also treble damages to him that hath the inheritance. The expression of the statute is, he shall forfeit the thing which he hath wasted, and it hath been determined that under these words the place is also included. And if the waste be done sparsum, or here or there, all over a wood, the whole wood shall be recovered. Or, if in several rooms of a house, the whole house shall be forfeited, because it is impracticable for the reversioner to enjoy only the identical places wasted, when lying interspersed with each other. But if the waste be done only in one end of a wood, or perhaps in one room of a house, if that can be conveniently separated from the rest, that part only is the locus vastus, or thing wasted, and that only shall be forfeited to the reversioner. 7. A seventh species of forfeiture is that of copyhold estates by breach of the customs of the manor. Copyhold estates are not only liable to the same forfeitures as those which are held in soccage for treason, felony, alienation, and waste, whereupon the lord may seize them without any presentment by the homage, but also to particular forfeitures annexed to this species of tenure, which are incurred by the breach of either the general customs of all copyholds or the particular local customs of certain particular manors. And we may observe that, as these tenements were originally holden by the lowest and most abject vassals, the marks of feudal dominion continue much the strongest upon this mode of property. Most of the offences which occasioned a resumption of the fief by the feudal law, and were denominated feloniae per quas vassales ammeteret feudum, still continue to be causes of forfeiture in many of our modern copyholds, as by subtraction of suit and service, se dominum disavere nulluerit, by disclaiming to hold of the lord, or swearing himself not his copyholder, se dominum adjuravit, i.e., negavit se ad domino feudum abere, by neglect to be admitted tenant within a year and a day, si per annum et diem cessaveret in petenta investitura, by contumacy in not appearing in court after 3 proclamations, si ad domino tertiatus non compuerit, or by refusing, when sworn of the homage, to present the truth according to his oath, si pares veritatem neverent, et dedicant se nescire, cum sciant. In these, and a variety of other cases, which it is impossible here to enumerate, the forfeiture does not accrue to the Lord till after the offences are presented by the homage or jury of the Lord's court baron, per laudamentum parium suorum, or, as it is more fully expressed in another place, nemo malis addimatur de possessione sui beneficii, nisi convicta culpa, quae sit ludanda per judicium parum suorum. 8. The eighth and last method whereby lands and tenements may become forfeited is that of bankruptcy, or the act of becoming a bankrupt, which unfortunate person may, from the several descriptions given of him in our statute law, be thus defined: a trader who secrets himself, or does certain other acts tending to defraud his creditors. Who shall be such a trader, or what acts are sufficient to denominate him a bankrupt, with the several connected consequences resulting from that unhappy situation, will be better considered in a subsequent chapter, when we shall endeavor more fully to explain its nature, as it most immediately relates to personal goods and chattels. I shall only here observe the manner in which the property of lands and tenements are transferred, upon the supposition that the owner of them is clearly and indisputably a bankrupt, and that a commission of bankrupt is awarded and issued against him. By the statute 13 Elizabeth C7, the commissioners for that purpose, when a man is declared a bankrupt, shall have full power to dispose of all his lands and tenements, which he had in his own right at the time when he became a bankrupt, or which shall descend or come to him at any time afterwards, before his debts are satisfied or agreed for, and all the lands and tenements which were purchased by him jointly with his wife or children to his own use, or such interest therein as he may lawfully part with, or purchased with any other person upon secret trust for his own use, and to cause them to be appraised to their full value, and to sell the same by deed indented and enrolled, to divide them proportionally among the creditors. The statute expressly includes not only free but copyhold lands, but did not extend to estate's tail farther than for the bankrupt's life, nor to equities of redemption on a mortgaged estate, where the bankrupt has no legal interest, but only an equitable reversion. Whereupon the statute 21 Jacobus 1 C19 enacts that the commissioners shall be empowered to sell or convey, by deed indented and enrolled, any lands or tenements of the bankrupt, wherein he shall be seized of an estate tail in possession, remainder, or reversion, unless the remainder or reversion thereof shall be in the crown, and that such sale shall be good against all such issues in tail, remaindermen, and reversioners, whom the bankrupt himself might have barred by a common recovery or other means, and that all equities of redemption upon mortgaged estates shall be at the disposal of the commissioners, for they shall have power to redeem the same, as the bankrupt himself might have done after the redemption fell to them. And also, by this and a former act, all fraudulent conveyances to defeat the intent of these statutes are declared void, but that no purchaser bona fide for a good or valuable consideration shall be affected by the bankrupt laws, unless the commission be sued forth within 5 years after the act of bankruptcy committed. By virtue of these statutes, a bankrupt may lose all his real estates, which may at once be transferred by his commissioners to their assignees without his participation or consent. End of Chapter 18, Part 2. Chapter 19 of the Commentaries on the Laws of England, Book 2, by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Of title by Alienation. The most usual and universal method of acquiring title to real estates is that of alienation, conveyance, or purchase in its limited sense, under which may be comprised any method wherein estates are voluntarily resigned by one man and accepted by another, whether that be effected by sale, gift, marriage settlement, device, or other transmission of property by the mutual consent of the parties. This means of taking estates by alienation is not of equal antiquity in the law of England with that of taking them by descent. For we may remember that, by the feudal law, a pure and genuine feud could not be transferred from one feudatory to another without the consent of the lord, lest thereby a feeble or suspicious tenant might have been substituted and imposed upon him to perform the feudal services instead of one on whose abilities and fidelity he could depend. Neither could the feudatory then subject the land to his debts, for if he might, the feudal restraint of alienation would have been easily frustrated and evaded. And, as he could not alienate it in his lifetime, so neither could he by will defeat the succession, by devising his feud to another family, nor even alter the course of it, by imposing particular limitations or prescribing an unusual path of descent. Nor, in short, could he alien the estate, even with the consent of the lord, unless he had also obtained the consent of his own next apparent or presumptive heir. And therefore it was very usual in ancient fiefments to express that the alienation was made by consent of the heirs of the feoffeur, and sometimes for the heir apparent himself to join with the feoffeur in the grant. And, on the other hand, as the feudal obligation was looked upon to be reciprocal, the lord could not alien or transfer his seigniory without the consent of his vassal, for it was esteemed unreasonable to subject a feudatory to a new superior with whom he might have a deadly enmity without his own approbation, or even to transfer his fealty without his being thoroughly apprised of it, that he might know with certainty to whom his renders and services were due, and be able to distinguish a lawful distress for rent from a hostile seizing of his cattle by the lord of a neighboring clan. This consent of the vassal was expressed by what was called a turning, or professing to become the tenant of the new lord, which doctrine of attornment was afterwards extended to all lessees for life or years. For if one bought an estate with any lease for life or years standing out thereon, and the lessee or tenant refused to return to the purchaser, and to become his tenant, the grant or contract was in most cases void, or at least incomplete, which was also an additional clog upon alienations. But by degrees this feudal severity is worn off, and experience hath shown that property best answers the purposes of civil life, especially in commercial countries, when its transfer and circulation are totally free and unrestrained. The road was cleared in the first place by a law of King Henry I, which allowed a man to sell and dispose of lands which he himself had purchased, for over these he was thought to have a more extensive power than over what had been transmitted to him in a course of descent from his ancestors, a doctrine which is countenanced by the feudal constitutions themselves. But he was not allowed to sell the whole of his own acquirements so as totally to disinherit his children, any more than he was at liberty to alien his paternal estate. Afterwards, a man seems to have been at liberty to part with all his own acquisitions if he had previously purchased to him and his assigns by name. But if his assigns were not specified in the purchase deed, he was not empowered to alien, and also he might part with 1/4 of the inheritance of his ancestors without the consent of his heir. By the great charter of Henry III, no subinfeudation was permitted of part of the land, unless sufficient was left to answer the services due to the superior lord, which sufficiency was probably interpreted to be one half or moiety of the land. But these restrictions were in general removed by the statute of quia emptores, whereby all persons except the king's tenants in capite were left at liberty to alien all or any part of their lands at their own discretion. And even these tenants in capite were by the statute 1 Edward III c. 12 permitted to alien on paying a fine to the king. By the temporary statutes 2 Henry VII c. 3 and 3 Henry VIII c. 4, all persons attending the king in his wars were allowed to alien their lands without license and were relieved from other feudal burdens. And, lastly, these very fines for alienations were, in all cases of freehold tenure, entirely abolished by the statute 12 Charles II c. 24. As to the power of charging lands with the debts of the owner, this was introduced so early as Statute Westminster II, which subjected a moiety of the tenant's lands to executions for debts recovered by law, as the whole of them was likewise subjected to be pawned in the Statute Merchant by the Statute De Mercatabis, made the same year, and in the Statute Staple by Statute 27 Edward III c. 9, and in other similar recognizances by Statute 23 Henry VIII c. 6. And now the whole of them is not only subject to be pawned for the debts of the owner, but likewise to be absolutely sold for the benefit of trade and commerce by the several statutes of bankruptcy. The restraint of devising lands by will, except in some places by particular custom, lasted longer, that not being totally removed till the abolition of the military tenures. The doctrine of attornments continued still later than any of the rest, and became extremely troublesome, though many methods were invented to evade them, till at last they were made no longer necessary by statutes 4 and 5 and c. 16 and 2 George II c. 19. In examining the nature of alienation, let us first inquire briefly who may alien and to whom, and then, more largely, how a man may alien or the several modes of conveyance. 1. Who may alien and to whom? Or, in other words, who is capable of conveying and who of purchasing. And herein we must consider rather the incapacity than capacity of the several parties. For all persons in possession are, prima facie, capable of conveying and purchasing, unless the law has laid them under any particular disabilities. But if a man has only in him the right of either possession or property, he cannot convey it to any other, lest pretended titles might be granted to great men, whereby justice might be trodden down and the weak oppressed. Yet reversions and vested remainders may be granted, because the possession of the particular tenant is the possession of him in reversion or remainder. But contingencies and mere possibilities, though they may be released or devised by will, or may pass to the heir or executor, yet cannot, it hath been said, be assigned to a stranger unless coupled with some present interest. Persons attainted of treason, felony, and praemunire are incapable of conveying, from the time of the offense committed, provided the attainder follows, for such conveyance by them may tend to defeat the king of his forfeiture or the lord of his escheat. But they may purchase for the benefit of the crown, or the lord of the fee, though they are disabled to hold, the land so purchased, if after attainder, being subject to immediate forfeiture, if before, to escheat as well as forfeiture, according to the nature of the crime. So also corporations, religious or others, may purchase lands, yet, unless they have a license to hold in mortmain, they cannot retain such purchase, but shall be forfeited to the lord of the fee. Idiots and persons of non-sane memory, infants, and persons under duress are not totally disabled either to convey or purchase, but sub modo only. For their conveyances and purchases are voidable, but not actually void. The king indeed, on behalf of an idiot, may avoid his grants or other acts. But it hath been said that a man non compos himself, though he be afterwards brought to a right mind, shall not be permitted to allege his own insanity in order to avoid such grant, for that no man shall be allowed to stultify himself or plead his own disability. The progress of this notion is somewhat curious. In the time of Edward I, non compos was a sufficient plea to avoid a man's own bond, and there is a writ in the register for the alienor himself to recover lands aliened by him during his insanity. Dum fuit non compos mentis suae ut dicit, etc. But under Edward III a scruple began to arise, whether a man should be permitted to blemish himself by pleading his own insanity, and afterwards a defendant in assize having pleaded a release by the plaintiff since the last continuance, to which the plaintiff replied, ore tenus, as the manner then was, that he was out of his mind when he gave it, the court adjourned the assize, doubting whether, as the plaintiff was sane both then and at the commencement of the suit, he should be permitted to plead an intermediate deprivation of reason. And the question was asked, how he came to remember the release, if out of his senses when he gave it. Under Henry VI, this way of reasoning, that a man shall not be allowed to disable himself by pleading his own incapacity because he cannot know what he did under such a situation, was seriously adopted by the judges in argument, upon a question whether the heir was barred of his right of entry by the fiefment of his insane ancestor. And from these loose authorities, which Fitzherbert does not scruple to reject as being contrary to reason, the maxim that a man shall not stultify himself hath been handed down as settled law, though later opinions, feeling the inconvenience of the rule, have in many points endeavored to restrain it. And, clearly, the next heir, or other person interested, may, after the death of the idiot or non compos, take advantage of his incapacity and avoid the grant. And so, too, if he purchases under this disability, and does not afterwards, upon recovering his senses, agree to the purchase, his heir may either waive or accept the estate at his option. In like manner, an infant may waive such purchase or conveyance when he comes to full age, or, if he does not then actually agree to it, his heirs may waive it after him. Persons also who purchase or convey under duress may affirm or avoid such transaction whenever the duress is ceased. For all these are under the protection of the law, which will not suffer them to be imposed upon through the imbecility of their present condition, so that their acts are only binding in case they be afterwards agreed to when such imbecility ceases. The case of a femme covert is somewhat different. She may purchase an estate without the consent of her husband, and the conveyance is good during the coverture, till he avoids it by some act declaring his descent. And, though he does nothing to avoid it, even if he actually consents, the femme covert herself may, after the death of her husband, waive or disagree to the same. Nay, even her heirs may waive it after her if she dies before her husband, or if in her widowhood she does nothing to express her consent or agreement. But the conveyance or other contract of a femme covert, except by some matter of record, is absolutely void and not merely voidable, and therefore cannot be affirmed or made good by any subsequent agreement. The case of an alien born is also peculiar, for he may purchase anything, but after purchase can hold nothing, except a lease for years of a house for convenience of merchandise, in case he be an alien friend, all other purchases, when found by an inquest of office, being immediately forfeited to the king. Papists, lastly, and persons professing the popish religion, are by statute 11 and 12 William III, c. 4, disabled to purchase any lands, rents, or hereditaments, and all estates made to their use, or in trust for them, are void. But this statute is construed to extend only to Papists above the age of 18, such only being absolutely disabled to purchase. Yet the next Protestant heir of the Papist under 18 shall have the profits during his life, unless he renounces his errors within the time limited by law. 2. We are next, but principally, to inquire how a man may alien or convey, which will lead us to consider the several modes of conveyance. In consequence of admission of property, or the giving a separate right by the law of society to those things which by the law of nature were in common, there was necessarily some means to be devised whereby that separate right or exclusive property should be originally acquired, which, we have more than once observed, was that of occupancy or first possession. But this possession, when once gained, was also necessarily to be continued, or else, upon one man's dereliction of the thing he had seized, it would again become common, and all those mischiefs and contentions would ensue, which property was introduced to prevent. For this purpose, therefore, of continuing the possession, the municipal law has established descents and alienations. The former, to continue the possession in the heirs of the proprietor after his involuntary dereliction of it by his death; the latter, to continue it in those persons to whom the proprietor, by his own voluntary act, shall choose to relinquish it in his lifetime. A translation or transfer of property being thus admitted by law, it became necessary that this transfer should be properly evidenced, in order to prevent disputes, either about the fact, as whether there was any transfer at all, or concerning the persons by whom and to whom it was transferred, or, with regard to the subject matter, as what the thing transferred consisted of, or, lastly, with relation to the mode and quality of the transfer, as for what period of time, or, in other words, for what estate and interest the conveyance was made. The legal evidences of this translation of property are called the common assurances of the kingdom, whereby every man's estate is assured to him, and all controversies, doubts, and difficulties are either prevented or removed. These common assurances are of four kinds. 1. By matter, in pais, or deed, which is an assurance transacted between two or more private persons in pais, in the country, that is, according to the old common law, upon the very spot to be transferred. 2. By matter of record, or an assurance transacted only in the king's public courts of record. 3. By special custom, obtaining in some peculiar places, and relating only to some peculiar species of property, which three are such as take effect during the life of the party conveying or assuring. 4. The fourth takes no effect till after his death, and that is by device contained in his last will and testament. We shall treat each in its order. End of chapter 19. Chapter 20, Part 1 of the Commentaries on the Laws of England, Book 2, by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Of Alienation by Deed, Part 1. In treating of deeds, I shall consider first their general nature, and, next, their several sorts or kinds of deeds with their respective incidents. And in explaining the former, I shall examine first what a deed is, Secondly, its requisites, and thirdly, how it may be avoided. 1. First, then, a deed is a writing sealed and delivered by the parties. It is sometimes called a charter, carta, from its materials. But most usually, when applied to the transactions of private subjects, it is called a deed, in Latin factum, because it is the most solemn and authentic act a man can possibly perform with relation to the disposal of his property, and therefore a man shall always be estopped by his own deed, or not permitted to aver or prove anything in contradiction to what he has once so solemnly and deliberately avowed. If a deed be made by more parties than one, there ought to be regularly as many copies of it as there are parties, and each should be cut or indented, formerly in acute angles interdentium, but at present in a waving line, on the top or side, to tally or correspond with the other, which deed so made is called an indenture. Formerly, when deeds were more concise than at present, it was usual to write both parts on the same piece of parchment, with some word or letters of the alphabet written between them, through which the parchment was cut, either in a straight or indented line, in such a manner as to leave half the word on one part and half on the other. Deeds thus made were denominated syngrapha by the canonists, and with us chirographa, or handwritings, the word sirographum, or sirographum, being usually that which was divided in making the indenture, and this custom is still preserved in the making out the indentures of a fine, whereof hereafter. But at length indenting has only come into use without cutting through the letters at all, and it seems at present to serve for little other purpose than to give name to the species of the deed. When the several parts of an indenture are interchangeably executed by the several parties, that part or copy which is executed by the grantor is usually called the original, and the rest are counterparts, though of late it is most frequent for all parties to execute every part, which renders them all originals. A deed made by one party only is not indented, but polled or shaved quite even, and is therefore called a deed poll, or single deed. 2. We are in the next place to consider the requisites of a deed, the first of which, that there be persons able to contract and contracted with, for the purposes intended by the deed, and also a thing, a subject matter to be contracted for, all of which must be expressed by sufficient names. So as in every grant there must be a grantor, a grantee, and a thing granted. In every lease, a lessor, a lessee, and a thing demised. Secondly, the deed must be founded on good and sufficient consideration, not upon an usurious contract, or upon fraud or collusion, either to deceive purchasers bona fide, or just and lawful creditors, any of which bad considerations will vacate the deed. A deed also, or other grant, made without any consideration is, as it were, of no effect, for it is construed to inure or be effectual only to the use of the grantor himself. The consideration may be either a good or a valuable one. A good consideration is such as that of blood, or of natural love and affection, when a man grants an estate to a near relation, being founded in motives of generosity, prudence, and natural duty. A valuable consideration, such as money, marriage, or the like, which the law esteems an equivalent given for the grant, and is therefore founded in motives of justice. Deeds made upon good consideration only are considered as merely voluntary, and are frequently set aside in favor of creditors and bona fide purchasers. Thirdly, a deed must be written, or, I presume, printed, for it may be in any character or in any language, but it must be upon paper or parchment. For if it be written on stone, board, linen, leather, or the like, it is no deed. Wood or stone may be more durable, and linen less liable to erasures, but writing on paper or parchment unites in itself, more perfectly than any other way, both those desirable qualities. For there is nothing else so durable, and at the same time so little liable to alteration, nothing so secure from alteration that is at the same time so durable. It must also have the regular stamps imposed on it by the several statutes for the increase of the public revenue, else it cannot be given in evidence. Formerly many conveyances were made by parole, or word of mouth only, without writing. But this giving a handle to a variety of frauds, the statute 29 Charles II C3 enacts that no lease or estate in lands, tenements, or hereditaments, except leases not exceeding 3 years from the making, and whereon the reserved rent is at least two-thirds of the real value, shall be looked upon as of greater force than a lease or estate at will, unless put in writing and signed by the party granting, or his agent lawfully authorized in writing. Fourthly, the matter written must be legally and orderly set forth. That is, there must be words sufficient to specify the agreement and bind the parties, which sufficiency must be left to the courts of law to determine. For it is not absolutely necessary in law to have all the formal parts that are usually drawn out in deeds, so as there be sufficient words to declare clearly and legally the parties' meaning. But as these formal and orderly parts are calculated to convey that meaning in the clearest, distinctest, and most effectual manner, and have been well considered and settled by the wisdom of successive ages, it is prudent not to depart from them without good reason or urgent necessity, and therefore I will here mention them in their usual order. 1. The premises may be used to set forth the number and names of the parties with their additions and titles. They also contain the recital, if any, of such deeds, agreements, or matters of fact as are necessary to explain the reasons upon which the present transaction is founded, and herein also is set down the consideration upon which the deed is made. And then follows the certainty of the grantor, grantee, and the thing granted. 2, 3. Next come the habendum and tenendum. The office of the habendum is properly to determine what estate or interest is granted by the deed, though this may be performed, and sometimes is performed, in the premises. In which case the habendum may lessen, enlarge, explain, or qualify, but not totally contradict or be repugnant to, the estate granted in the premises. As if a grant be to A and the heirs of his body, in the premises, habendum to him and his heirs forever, or vice versa, here A has an estate tail and a fee simple expectant thereon. But had it been in the premises to him and his heirs, habendum to him for life, the habendum would have been utterly void, for an estate of inheritance is vested in him before the habendum comes, and shall not afterwards be taken away or divested by it. The tenendum, and to hold, is now of very little use, and is only kept in by custom. It was sometimes formerly used to signify the tenure by which the estate was granted to be holden, viz. tenendum per servitum militare, in burgagio, in libero socagio, etc. But all these being now reduced to free and common socage, the tenure is never specified. Before the statute of Quia Emptores, 18 Edward I, it was also sometimes used to denote the lord of whom the land should be holden, but that statute directing all future purchasers to hold, not of his immediate grantor, but of the chief lord of the fee, this use of the tenendum hath been also antiquated, though, for a long time after, we find it mentioned in ancient charters that the tenements shall be holden de capitalibus dominus feodi. But as this expressed nothing more than the statute had already provided for, it gradually grew out of use. 4. Next follow the terms or stipulations, if any, upon which the grant is made, the first of which is the reddendum, or reservation, whereby the grantor doth create or reserve some new thing to himself out of what he had before granted, as rendering thereby the yearly sum of 10 shillings, or a peppercorn, or 2 days' ploughing, or the like. This render, reditus, return, or rent, under the pure feudal system consisted in chivalry, principally of military service, in villanage, of the most slavish offices, and in socage it usually consists of money, though it may consist of services still, or of any other certain profit. To make a reddendum good, if it be of anything newly created by the deed, the reservation must be to the grantors, or some, or one of them, and not to any stranger to the deed. But if it be of ancient services or the like, annexed to the land, then the reservation may be to the lord of the fee. 5. Another of the terms upon which a grant may be made is a condition, which is a clause of contingency, on the happening of which the estate granted may be defeated, as provided always that if the mortgagor shall pay the mortgagee £500, upon such a day the whole estate granted shall determine, and the like. 6. Next may follow the clause of warranty, whereby the grantor doth, for himself and his heirs, warrant and secure to the grantee the estate so granted. By the feudal constitution, if a vassal's title to enjoy the feud was disputed, he might vouch or call the lord or donor to warrant or insure his gift, which if he failed to do, and the vassal was evicted, the lord was bound to give him another feud of equal value in recompense. And so, by our ancient law, if before the statute of quia emptores a man enfiefed another in fee by the feudal verb dede, to hold of himself and his heirs by certain services, the law annexed a warranty to this grant, which bound the feefor and his heirs, to whom the services, which were the consideration and equivalent for the gift, were originally stipulated to be rendered. Or, if a man and his ancestors had immemorially holden land of another and his ancestors by the service of homage, which was called homage ancestral, this also bound the lord to warranty, the homage being an evidence of such a feudal grant. And, upon a similar principle, in case after a partition or exchange of lands of inheritance, either party or his heirs be evicted of his share, the other and his heirs are bound to warranty, because they enjoy the equivalent. And so, even at this day, upon a gift in tail or lease for life, rendering rent, the donor or lessor and his heirs, to whom the rent is payable, are bound to warrant the title. But in affiefment in fee by the verb dedi, since the statute of quia emptores, the feefor only is bound by the implied warranty and not his heirs, because it is a mere personal contract on the part of the feefor, the tenant, and of course the ancient services resulted back to the superior lord of the fee. And in other forms of alienation, gradually introduced since that statute, no warranty whatsoever is implied, they bearing no sort of analogy to the original feudal donation. And therefore, in such cases it became necessary to add an express clause of warranty, to bind the grantor and his heirs, which is a kind of covenant real, and can only be created by the verb warrantizo, or warrant. These express warranties were introduced even prior to the statute of quia emptores, in order to evade the strictness of the feudal doctrine of non-alienation without the consent of the heir. For though he, at the death of his ancestor might have entered on any tenements that were aliened without his concurrence, yet, if a clause of warranty was added to the ancestor's grant, this covenant descending upon the heir ensured the grantee, not so much by confirming his title, as obliging such heir to yield him a recompense in lands of equal value. The law, in favor of alienations, supposing that no ancestor would wantonly disinherit his next of blood, and therefore presuming that he had received a valuable consideration, either in land or in money which had purchased land, and that this equivalent descended to the heir together with the ancestor's warranty. So that when either an ancestor, being the rightful tenant of the freehold, conveyed the land to a stranger and his heirs, or released the right in fee simple to one who was already in possession, and superadded a warranty to his deed, it was held that such warranty not only bound the warrantor himself to protect and assure the title of warranty, but it also bound his heir, and this whether that warranty was lineal, collateral, or to the title of the land. Lineal warranty was where the heir derived, or might possibly have derived, his title to the land warranted either from or through the ancestor who made the warranty, as where a father or an elder son in the life of the father released to the decisor of either themselves or the grandfather, with warranty, this was lineal to the younger son. Collateral warranty was where the heir's title to the land neither was, nor could have been, derived from the warranting ancestor, as where a younger brother released to his father's decisor with warranty, this was collateral to the elder brother. But where the very conveyance to which the warranty was annexed immediately followed a disseisin, or operated itself as such, as where a father, tenant for years, with remainder to his son in fee, aliened in fee simple with warranty, this, being in its original manifestly founded on the tort or wrong of the warrantor himself, was called a warranty commencing by disseisin, and, being too palpably injurious to be supported, was not binding upon any heir of such tortuous warrantor. In both lineal and collateral warranty, the obligation of the heir, in case the warranty was evicted to yield him other lands in their stead, was only on condition that he had other sufficient lands by descent from the warranting ancestor. But though, without assets, he was not bound to inure the title of another, yet, in case of lineal warranty, whether assets descended or not, the heir was perpetually barred from claiming the land himself, for, if he could succeed in such claim, he would then gain assets by descent, if he had them not before, and must fulfill the warranty of his ancestor. And the same rule was with less justice adopted also in respect to collateral warranties, which likewise, though no assets descended, barred the heir of the warrantor from claiming the land by any collateral title, upon the presumption of law that he might hereafter have assets by descent either from or through the same ancestor. The inconvenience of this latter branch of the rule was felt very early, when tenants by the courtesy took upon them to alien their lands with warranty, which collateral warranty of the father descending upon his son, who was the heir of both his parents, barred him from claiming his maternal inheritance, to remedy which the Statute of Gloucester, 6 Edward I. c. 3 declared, that such warranty should be no bar to the son unless assets descended from the father. It was afterwards attempted in 50 Edward III. To make the same provision universal, by enacting that no collateral warranty should be a bar, unless where assets descended from the same ancestor, but then it proceeded not to effect. However, by the Statute 11 Henry VII. c. 20, notwithstanding any alienation with warranty by tenant and dower, the heir of the husband is not barred, though he be also heir to the wife. And by statute 4 and 5 and C16, all warranties by any tenant for life shall be void against those in remainder or reversion, and all collateral warranties by any ancestor who has no estate of inheritance in possession shall be void against his heir. By the wording of which last statute, it should seem that the legislature meant to allow that the collateral warranty of tenant entail, descending though without assets upon a remainder man or reversioner, should still bar the remainder or reversion. For though the judges, in expounding the statute de donis, held that, by analogy to the statute of Gloucester, a lineal warranty by the tenant in tail without assets should not bar the issue in tail, yet they held such warranty with assets to be a sufficient bar, which was therefore formerly mentioned as one of the ways whereby an estate tail might be destroyed, it being indeed nothing more in effect than exchanging the lands entailed for others of equal value. They also held that collateral warranty was not within the statute de donis, as that act was principally intended to prevent the tenant in tail from disinheriting his own issue, and therefore collateral warranty, though without assets, was allowed to be, as at common law, a sufficient bar of the estate tail and all remainders and reversions expectant thereon. And so it still continues to be, notwithstanding the statute of Queen Anne, if made by tenant in tail in possession, who therefore may now, without the forms of a fine or recovery, in some cases make a good conveyance in fee simple by superadding a warranty to his grant, which, if accompanied with assets, bars his own issue, and without them bars such of his heirs as may be in remainder or reversion. 7. After warranty usually follow covenants or conventions, which are clauses of agreement contained in a deed whereby either party may stipulate for the truth of certain facts or may bind himself to perform or give something to the other. Thus the grantor may covenant that he hath a right to convey, or for the grantee's quiet enjoyment, or the like, and the grantee may covenant to pay his rent, to repair the premises, etc. If the covenantor covenants for himself and his heirs, it is then a covenant real, and descends upon the heirs, who are bound to perform it, provided they have assets by descent, but not otherwise. If he covenants also for his executors and administrators, his personal assets as well as his real are likewise pledged for the performance of the covenant, which makes such covenant a better security than any warranty, and it has therefore in modern practice totally superseded the other. 8. Lastly comes the conclusion, which mentions the execution and date of the deed, or the time of its being given or executed, either expressly or by reference to some day and year before mentioned. Not but a deed is good, although it mention no date, or hath a false date, or even if it hath an impossible date, as the 30th of February, provided the real day of its being dated or given, that is, delivered, can be proved. End of Chapter 20, Part 1. Chapter 20, Part 2 of the Commentaries on the Laws of England, Book 2, by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines of Alienation by Deed, Part 2. I proceed now to the fifth requisite for making a good deed, the reading of it. This is necessary whenever any of the parties desire it, and if it not be done on his request, the deed is void as to him. If he can, he should read it himself. If he be blind or illiterate, another must read it to him. If it be read falsely, it will be void, at least for so much as is misrecited, unless it be agreed by collusion that the deed shall be read false, on purpose to make it void, for in such case it shall bind the fraudulent party. Sixthly, it is requisite that the party whose deed it is should seal, and in most cases, I apprehend, should sign it also. The use of seals as a mark of authenticity to letters and other instruments in writing is extremely ancient. We read of it among the Jews and Persians in the earliest and most sacred records of history. And in the book of Jeremiah there is a very remarkable instance, not only of an attestation by seal, but also of the other usual formalities attending a Jewish purchase. In the civil law also, seals were the evidence of truth, and were required, on the part of witnesses at least, at the attestation of every testament. But in the times of our Saxon ancestors, they were not much in use here. For though Sir Edward Coke relies on an instance of King Edwin making use of a seal about 100 years before the Conquest, yet it does not follow that this was the usage among the whole nation, and perhaps the charter he mentions may be of doubtful authority, from this very circumstance of being sealed, since we are assured by all of our ancient historians that sealing was not then in common use. The method of the Saxons was for such as could write to subscribe their names, and, whether they could not write, to affix the sign of the cross, which custom our illiterate vulgar do, for the most part, to this day keep up, by signing a cross for their mark when unable to write their names. And indeed, this inability to write, and therefore making a cross in its stead, is honestly avowed by Cadwalla, a Saxon king, at the end of one of his charters. In like manner, and for the same unsurmountable reason, the Normans, a brave but illiterate nation, at their first settlement in France, used the practice of sealing only, without writing their names, which custom continued when learning made its way among them, though the reason for doing it had ceased. And hence the charter of Edward the Confessor to Westminster Abbey, himself being brought up in Normandy, was witnessed only by his seal, and is generally thought to be the oldest sealed charter of any authenticity in England. At the Conquest, the Norman lords brought over into this kingdom their own fashions, and introduced waxen seals only, instead of the English method of writing their names and signing with the sign of the cross. The impressions of these seals were sometimes a knight on horseback, sometimes other devices, but coats of arms were not introduced into seals, nor indeed to any other use, till about the reign of Richard I, who brought them from the Crusade in the Holy Land, where they were first invented and painted on the shields of knights, to distinguish the variety of persons of every Christian nation who resorted thither, and who could not, when clad in complete steel, be otherwise known or ascertained. This neglect of signing, and resting only upon the authenticity of seals, remained very long among us, for it was held in all our books that sealing alone was sufficient to authenticate a deed, and so the common form of attesting deeds, sealed and delivered, continues to this day, notwithstanding the statute 29 Charles II c. before mentioned revives the Saxon custom and expressly directs the signing in all grants of lands and many other species of deeds, in which therefore signing seems to be now as necessary as sealing, though it hath been sometimes held that the one includes the other. A seventh requisite to a good deed is that it be delivered by the party himself or his certain attorney, which therefore also expressed in the attestation, sealed and delivered. A deed takes effect only from this tradition or delivery, for if the date be false or impossible, the delivery ascertains the time of it. And if another person seals the deed, yet if the party delivers it himself, he thereby adopts the sealing, and by a parity of reason, the signing also, and makes them both his own. A delivery may be either absolute, that is, to the party or grantee himself, or to a third person, to hold till some conditions be performed on the part of the grantee, in which last case it is not delivered as a deed, but as an escrow, that is, a scroll or writing, which is not to take effect as a deed till the conditions be performed, and then it is a deed to all intents and purposes. The last requisite to the validity of a deed is the attestation, or the execution of it in the presence of witnesses, though this is necessary rather for preserving the evidence than for constituting the essence of the deed. Our modern deeds are in reality nothing more than an improvement or amplification of the brevia testata mentioned by the feudal writers, which were written memorandums introduced to perpetuate the tenor of the conveyance and investiture when grants by parole only became the foundation of frequent dispute and uncertainty. To this end they registered in the deed the persons who attended as witnesses, which was formerly done without their signing their names, that not being always in their power, but they only heard the deed read, and then the clerk or scribe added their names in a sort of memorandum. Thus, eis testibus, Johann Moore, Jacob Smith, et aliis adanc rem convocatis. This, like all other solemn transactions, was originally done only coram paribus, and frequently when assembled in the court baron, hundred, or county court, which was then expressed in the attestation teste comitatu, andredo, etc. Afterwards, the attestation of other witnesses was allowed, the trial in case of dispute being still reserved to the pares, with whom the witnesses, if more than one, were associated, and joined in the verdict, till that also was abrogated by the Statute of York, 12 Edward II, ft. 1 c. 2. And in this manner, with some such clause of eis testibus, are all old deeds and charters, particularly Magna Carta, witnessed. And, in the time of Sir Edward Coke, creations of nobility were still witnessed in the same manner. But in the King's common charters, writs, or letters patent, the style is now altered, for at present the King is his own witness, and attests his letters patent thus: Teste me ipso, witness ourself, at Westminster, etc., a form which was introduced by Richard I, but not commonly used till about the beginning of the 15th century, nor the clause eis testibus entirely discontinued till the reign of Henry VIII, which was also the era of discontinuing it in the deeds of subjects, learning being then revived, and the faculty of writing more general, and therefore ever since that time the witnesses have subscribed their attestation either at the bottom or on the back of the deed. 3. We are next to consider how a deed may be avoided or rendered of no effect. And from what has been before laid down, it will follow that if a deed wants any of the essential requisites before mentioned, either 1. Proper parties and a proper subject matter, 2. A good and sufficient consideration, 3. Writing on paper or parchment duly stamped, 4. Sufficient and legal words properly disposed, 5. Reading, if desired, before the execution, 6. Sealing, and by statute in many cases signing also, or 7. Delivery. It is a void deed ab initio. It may also be avoided by matter ex post facto, as 1. By erasure, interlining, or other alteration in any material part, unless a memorandum be made thereof at the time of the execution and attestation. 2. By breaking off or defacing the seal. 3. By delivering it up to be cancelled, that is, to have lines drawn over it in the form of lattice work or cancilli, though the phrase is now used figuratively for any manner of obliteration or defacing it. 4. By disagreement of such whose concurrence is necessary in order for the deed to stand, as the husband where a femme covert is concerned, an infant or person under duress, when those difficulties are removed, and the like. 6. By the judgment or decree of a court of judicature. This was anciently the province of the Court of Star Chamber, and now the Chancery, when it appears that the deed was obtained by fraud, force, or other foul practice, or is proved to be an absolute forgery. In any of these cases the deed may be voided, either in part or totally, according as the cause of avoidance is more or less extensive. End of Chapter 20, Part 2. Chapter 20, Part 3 of the Commentaries on the Laws of England, Book 2, by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Of Alienation by Deed, Part 3. And, having thus explained the general nature of deeds, we are next to consider their several species together with their respective incidents. And herein I shall only examine the particulars of those which, from long practice and experience of their efficacy, are generally used in the alienation of real estates, for it would be tedious, nay, infinite, to descant upon all the several instruments made use of in personal concerns, but which fall under our general definition of a deed, that is, a writing sealed and delivered. The former being principally such as serve to convey the property of lands and tenements from man to man, are commonly denominated conveyances, which are either conveyances at common law, or such as receive their force and efficacy by virtue of the statute of uses. 1. Of conveyances by common law, some may be called original or primary conveyances, which are those by means whereof the benefit or estate is created or first arises. Others are derivative or secondary, whereby the benefit or estate originally created is enlarged, restrained, transferred, or extinguished. Original conveyances are the following: 1. Fiefment. 2. Gift. 3. Grant. 4. Lease. 5. Exchange. 6. Partition. Derivative are 7. Release. 8. Confirmation. 9. Surrender. 10. Assignment. 11. Deseasance. 1. A fiefment, veofamentum, is a substantive derived from the verb to infief, veofare, or infeudare, to give one a feud, and therefore fiefment is properly donatio feudi. It is the most ancient method of conveyance, the most solemn and public, and therefore the most easily remembered and proved. And it may properly be defined the gift of any corporeal hereditament to another. He that so gives or enfiefs is called a fiefore, and the person enfiefed is denominated the fiefee. This is plainly derived from, or is indeed itself the very mode of the ancient feudal donation. For, though it may be performed by the word enfief or grant, yet the aptest word of fiefment is do or dedi, and it is still directed and governed by the same feudal rules, insomuch that the principal rule relating to the extent and effect of a feudal grant, tenor est qui legem dat feudo, is, in other words, become the maxim of our law with relation to fiefments, modus legem dat donatione. And therefore, as in pure feudal donations the lord, from whom the feud moved, must expressly limit and declare the continuance or quantity of estate he meant to confer, ne quis place donasse praesumatur, quam in donatione expresserit. So, if one grants a fiefment, lands or tenements to another, and limits or expresses no estate, the grantee, due ceremonies of law being performed, hath barely an estate for life. For, as the personal abilities of the fiefee were originally presumed to be the immediate or principal inducements to the fiefment, the fiefee's estate ought to be continued to his person, and subsist only for his life, unless the feofor, by express provision in the creation and constitution of the estate, hath given it a longer continuance. These express provisions are indeed generally made, for this was for ages the only conveyance whereby our ancestors were wont to create an estate in fee simple, by giving land to the fiefee to hold him and his heirs for ever, though it serves equally well to convey any other estate of freehold. But by the mere words of the deed, the fiefment is by no means perfected. There remains a very material ceremony to be performed, called livery of season, without which the fiefee has but a mere estate at will. This livery of season is no other than the pure feudal investiture, or delivery of corporal possession of the land or tenement, which was held absolutely necessary to complete the donation. Nam feudum sine investitura nullo modum constitui potuit. And an estate was then only perfect when, as Fleda expresses it in our law, fit juris et caesina conjunctio. Investitures, in their original rise, were probably intended to demonstrate in conquered countries the actual possession of the lord, and that he did not grant a bare litigious right, which the soldier was ill qualified to prosecute, but a peaceable and firm possession. And, at a time when writing was seldom practiced, a mere oral gift, at the distance from the spot that was given, was not likely to be either long or accurately retained in the memory of bystanders who were very little interested in the grant. Afterwards, they were retained as a public and notorious act, that the country might take notice of and testify the transfer of the estate, and that such as claimed title by other means might know against whom to bring their actions. In all well-governed nations, some notoriety of this kind has been ever held requisite, in order to acquire and ascertain the property of lands. In the Roman law, plenum dominium was not said to subsist, unless where a man hath both the right and the corporal possession, which possession could not be acquired without both an actual intention to possess and an actual season or entry into the premises or part of them in the name of the whole. And even in ecclesiastical promotions, where the freehold passes to the person promoted, corporal possession is required at this day to vest the property completely in the new proprietor, who, according to the distinction of the canonists, acquires the jus ad rem, or inchoate and imperfect right, by nomination and institution, but not the jus in re, or complete and full right, unless by corporal possession. Therefore, in dignities, possession is given by installment, in rectories and vicarages by induction, without which no temporal rights accrue to the minister, though every ecclesiastical power is vested in him by institution. So also, even in descents of lands by our law, which are cast on the heir by act of the law itself, the heir has not plenum dominium, or full and complete ownership, till he has made an actual corporal entry into the lands. For if he dies before entry made, his heirs shall not be entitled to take the possession, but the heir of the person who was last actually seized. It is not therefore only a mere right to enter, but the actual entry, that makes a man complete owner, so as to transmit the inheritance to his own heirs. Non jus, sed caesina, facit estapitem. Yet, the corporal tradition of lands being sometimes inconvenient, a symbolical delivery of possession was in many cases anciently allowed. by transferring something near at hand in the presence of credible witnesses, which by agreement should serve to represent the very thing designed to be conveyed, and an occupancy of this sign or symbol was permitted as equivalent to occupancy of the land itself. Among the Jews we find evidence of a purchase thus defined in the book of Ruth. Now this was the manner in former time in Israel concerning redeeming and concerning changing, for to conform all things. A man plucked off his shoe and gave it to his neighbor, and this was a testimony in Israel. Among the ancient Goths and Swedes, contracts for the sale of lands were made in the presence of witnesses, who extended the cloak of the buyer, while the seller cast the clod of the land into it in order to give possession. And a staff or wand was also delivered from the vendor to the vendee, which passed through the hands of the witnesses. With our Saxon ancestors, the delivery of a turf was a necessary solemnity to establish the conveyance of lands. And, to this day, the conveyance of our copyhold estates is usually made from the seller to the lord or his steward by delivery of a rod or verge, and then from the lord to the purchaser by redelivery of the same in the presence of a jury of tenants. Conveyances in writing were the last and most refined improvement. The mere delivery of possession, either actual or symbolical, depending on the ocular testimony and remembrance of the witnesses, was liable to be forgotten or misrepresented, and became frequently incapable of proof. Besides, the new occasions and necessities introduced by the advancement of commerce required means to be devised of charging and encumbering estates, and of making them liable to a multitude of conditions and minute designations for the purposes of raising money without an absolute sale of the land. And sometimes the like proceedings were found useful in order to make a decent and competent provision for the numerous branches of a family and for other domestic views, none of which could be effected by a mere, simple, corporal transfer of the soil from one man to another, which was principally calculated for conveying an absolute, unlimited dominion. Written deeds were therefore introduced, in order to specify and perpetuate the peculiar purposes of the party who conveyed, yet still, for a very long series of years, they were never made use of, but in company with the more ancient and notorious method of transfer by delivery of corporal possession. Livery of season by the common law is necessary to be made upon every grant of an estate of freehold in hereditaments corporeal, whether of inheritance or for life only. In hereditaments incorporeal it is impossible to be made, for they are not the object of the senses, and in leases for years or other chattel interests it's not necessary. In leases for years, indeed, an actual entry is necessary to vest the estate in the lessee, for the bare lease gives him only a right to enter, which is called his interest in the term, or interesse termini, and when he enters in pursuance of that right, he is then and not before in possession of his term and complete tenant for years. This entry by the tenant himself serves the purpose of notoriety as well as livery of season from the grantor could have done, which it would have been improper to have given in this case, because that solemnity is appropriated to the conveyance of a freehold. And this is one reason why freeholds cannot be made to commence in futuro, because they cannot be made but by livery of season, which livery, being an actual manual tradition of the land, must take effect in presenti, or not at all. On the creation of a freehold remainder, at one and the same time with a particular estate for years, we have before seen that at the common law livery must be made to the particular tenant. But if such a remainder be created afterwards, expectant on a lease for years now in being, the livery must not be made to the lessee for years, for then it operates nothing. Nam cordessemum meum est, amplius meum esse non potest. But it must be made to the remainder man himself, by consent of the lessee for years, for without his consent no livery of the possession can be given, partly because such forcible livery would be an ejectment of the tenant from his term, and partly for the reason before given, for introducing the doctrine of attornments. Livery of season is either in deed or in law. Livery in deed is thus performed. The fee-for, lessor, or his attorney, together with the fee-fee, lessee, or his attorney, for this may as effectually be done by deputy or attorney, as by the principals themselves in person, come to the land or to the house, and there, in the presence of witnesses, declare the contents of the fiefment or lease on which livery is to be made. And then the fee-for, if it be of land, doth deliver to the fee-fee all other persons, being out of the ground a clod or turf, or a twig or bough there growing, with words to this effect: I deliver these to you in the name of season of all the lands and tenements contained in this deed. But if it be a house, the fee-for must take the ring or latch of the door, the house being quite empty, and deliver it to the fee-fee in the same form. And then the fee-fee must enter alone and shut the door, and then open it and let in the others. If the conveyance or fiefment be of diverse lands lying scattered in one and the same county, then in the fee-for's possession, livery of season of any parcel in the name of the rest sufficeth for all. But if they be in several counties, there must be as many liveries as there are counties. 4. If the title to these lands comes to be disputed, there must be as many trials as there are counties, and the jury of one county are no judges of the notoriety of fact in another. Besides, anciently this season was obliged to be delivered coram paribus de vicinetto, before the peers or freeholders of the neighborhood, who attested such delivery in the body or on the back of the deed. According to the rule of the feudal law, pares debent intereste investiture feudi et non alii, for which this reason is expressly given, because the peers or vassals of the lord, being bound by their oath of fealty, will take care that no fraud be committed to his prejudice, which strangers might be apt to connive at. And though afterwards the ocular attestation of the pares was held unnecessary, and livery might be made before any credible witness, yet the trial, in case it was disputed, like that of all other attestations, was still reserved to the pares or jury of the county. Also, if the lands be out on lease, though all lie in the same county, there must be as many liveries as there are tenants, because no livery can be made in this case but by the consent of the particular tenant, and the consent of one will not bind the rest. And in all these cases it is prudent and usual to endorse the livery of season on the back of the deed, specifying the manner, place, and time of making it, together with the names of the witnesses. And thus much for livery in deed. Livery in law is where the same is not made on the land, but in sight of it only, the fee-for saying to the fee-fee, I give you yonder land, enter and take possession. Here, if the fee-fee enters during the life of the fee-for, it is a good livery, but not otherwise, unless he dares not enter through fear of his life or bodily harm, and then his continual claim, made yearly in due form of law, as near as possible to the lands, will suffice without an entry. This livery in law cannot, however, be given or received by attorney, but only by the parties themselves. 2. The conveyance by gift, donatio, is properly applied to the creation of an estate tail, as fiefment is to that of an estate in fee, and lease to that of an estate for life or years. It differs in nothing from a fiefment, but in the nature of the estate passing by it. For the operative words of conveyance in this case are do or dedi, and gifts in tail are equally imperfect without livery of season as fiefments in fee simple. And this is the only distinction that Littleton seems to make when he says, it is to be understood that there is fee-for and fee-fee, donor and donee, lessor and lessee, viz. Fee-for is applied to a fiefment in fee simple, donor to a gift in tail, and lessor to a lease for life, or for years, or at will. In common acceptation, gifts are frequently confounded with the next species of deeds, which are 3. Grants, concessiones, the regular method by the common law of transferring the property of incorporeal hereditaments, or such things whereof no livery can be had. For which reason all corporeal hereditaments, as lands and houses, are said to lie in livery, and the others, as advowsons, commons, rents, reversions, etc., to lie in grant. And the reason is given by Blackstone: traditio, or livery, nihil aliud est quam re corporales, de persona in personam, de manu in manum, translation at in possessionem inductio, sed res in corporales, quae sunt ipsum jus re vel corpore inaerens, traditionem non patiuntur. These, therefore, pass merely by the delivery of the deed. And in seigniories or reversions of lands, such grant, together with the attornment of the tenant, while attornments were requisite, were held to be of equal notoriety with, and therefore equivalent to, a fiefment and livery of lands in immediate possession. It therefore differs but little from a fiefment, except in its subject matter, for the operative words therein commonly used are dede et concessi, have given and granted. End of chapter 20, part 3. Chapter 20, part 4 of the Commentaries on the Laws of England, Book 2, by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Of Alienation by Deed, Part 4. 4. A lease is properly a conveyance of any lands or tenements, usually in consideration of rent or other annual recompense, made for life, for years, or at will, but always for a less time than the lessor hath in the premises. For if it be for the whole interest, it is more properly an assignment than a lease. The usual words of operation in it are demise, grant, and to farm let, demisi, concessi, et ad firmam tradidi. Farm, or fiorme, is an old Saxon word signifying provisions, and it came to be used instead of rent or render, because anciently the greater part of rents were reserved in provisions, in corn, in poultry, and the like, till the use of money became more frequent. So that a farmer, firmarius, is one who held his lands upon payment of rent or fiorme, though at present, by a gradual departure from the original sense, the word farm is brought to signify the very estate or land so held upon farm or rent. By this conveyance an estate for life, for years, or at will, may be created, either in corporeal or incorporeal hereditaments, though livery of season is indeed incident and necessary to one species of leases, viz., leases for life of corporeal hereditaments, but to no other. Whatever restrictions by the severity of the feudal law might in times of very high antiquity be observed with regard to leases, yet by the common law, as it has stood for many centuries, all persons seized of any estate might let leases to endure for so long as their own interest lasted, but no longer. Therefore, tenant in fee simple might let leases of any duration, for he hath the whole interest. But tenant in tail, or tenant for life, could make no leases which should bind the issue in tail or reversioner, nor could a husband, seized jure uxoris, make a firm and valid lease for any longer than the term the joint lives of himself and his wife, for then his interest expired. Yet some tenants for life, where the fee simple was in abeyance, might, with the concurrence of such as have the guardianship of the fee, make leases of equal duration with those granted by tenants in fee simple, such as parsons and vicars with consent of the patron and ordinary. So also bishops and deans and such other sole ecclesiastical corporations as are seized of the fee simple of lands in their corporate right might, with the concurrence and confirmation of such persons as the law requires, have made leases for years or for life, estates in tail or in fee, without any limitation or control. And corporations aggregate might have made what estates they pleased, without the confirmation of any other person whatsoever. Whereas now, by several statutes, this power, where it was unreasonable and might be made an ill use of, is restrained, and where in other cases the restraint by the common law seemed too hard, it is in some measure removed. The former statutes are called the restraining, the latter the enabling statute. We will take a view of them all in order of time. And, first, the enabling statute, 32 Henry VIII, c. 28, empowers three manner of persons to make leases, to endure for 3 lives or 21 years, which could not do so before. As first, tenant in tail may by such leases bind his issue in tail, but not those in remainder or reversion. Secondly, a husband seized in right of his wife, in fee simple or fee tail, provided the wife joins in such lease, may bind her and her heirs thereby. Lastly, all persons seized of an estate of fee simple in the right of their churches, except parsons and vicars, may, without concurrence of any other person, bind their successors. But then there must be many requisites observed, which the statute specifies, otherwise such leases are not binding. 1. The lease must be by indenture, and not by deed poll or parole. 2. It must begin from the making or day of the making, and not at any greater distance of time. 3. If there be any old lease in being, it must be first absolutely surrendered, or be within a year of expiring. 4. It must be either for 21 years or 3 lives, and not both. 5. It must not exceed the term of 3 lives or 21 years, but may be for a shorter term. 6. It must be of corporeal hereditaments, and not of such things as lie merely in grant, for no rent can be reserved thereout by the common law, as the lessor cannot resort to them to distrain. 7. It must be of lands and tenements most commonly letten for 20 years past, so that if they have been let for above half the time, or 11 years out of 20, either for life, for years, at will, or by copy of court roll, it is sufficient. 8. The most usual and customary form or rent, for 20 years past, must be reserved yearly on such lease. 9. Such leases must not be made without impeachment of waste. These are the guards imposed by the statute, which was avowedly made for the security of farmers and the consequent improvement of tillage, to prevent unreasonable abuses in prejudice of the issue, the wife, or the successor, of the reasonable indulgences here given. Next follows, in order of time, the disabling or restraining statute 1 Elizabeth c. 19, made entirely for the benefit of the successor, which enacts that all grants by archbishops and bishops, which include even those confirmed by the dean and chapter, the which, however long and unreasonable, were good at common law, other than for a term of 21 years or 3 lives from the making, or without reserving the usual rent, shall be void. Concurrent leases, if confirmed by the dean and chapter, are held to be within the exception of this statute, and therefore valid, provided they do not exceed, together with the lease in being, the term permitted by the act. But, by a saving expressly made, This statute of 1 Elizabeth did not extend to grants made by any bishop to the crown, by which means Queen Elizabeth procured many fair possessions to be made over to her by the prelates, either for her own use, or with intent to be granted out again to her favorites, whom she thus gratified without any expense to herself. To prevent which for the future, the statute 1 Jacobin 1 C3 extends the prohibition to grants and leases made to the king, as well as to any of his subjects. Next comes the statute 13 Elizabeth C10, explained and enforced by the statutes 14 Elizabeth C11 and 14, 18 Elizabeth C11, and 43 Elizabeth C29, which extend the restrictions laid by the last mentioned statute on bishops to certain other inferior corporations, both sole and aggregate. From laying all of which together, we may collect that all colleges, cathedrals, and other ecclesiastical or eleemosynary corporations, and all parsons and vicars, are restrained from making any leases of their lands unless under the following regulations. 1. They must not exceed 21 years or 3 lives from the making. 2. The accustomed rent or more must be yearly reserved thereon. 3. Houses in corporations or market towns may be let for 40 years, provided they are not mansion houses of the lessors, nor have above 10 acres of ground belonging to them, and provided the lessee be bound to keep them in repair, and they may also be aliened in fee simple for lands of equal value in recompense. 4. Where there is an old lease in being, no concurrent lease shall be made, unless where the old one will expire within 3 years. 5. No lease, by the equity of the statute, shall be made without impeachment of waste. 6. All bonds and covenants tending to frustrate the provisions of the statutes 13 and 18 Elizabeth shall be void. Concerning these restrictive statutes, there are 2 observations to be made. First, that they do not, by any construction, enable any persons to make such leases as they were by common law disabled to make. Therefore, a parson or vicar, though he is restrained from making longer leases than for 21 years or 3 lives, even with the consent of the patron and ordinary, yet is not enabled to make any lease at all so as to bind his successor without obtaining such consent. Secondly, that though leases contrary to these acts are declared void, yet they are good against the lessor during his life, if he be a sole corporation, and also good against an aggregate corporation so long as the head of it lives, who is presumed to be the most concerned in interest. For the act was intended for the benefit of the successor only, and no man shall make an advantage of his own wrong. There is yet another restriction with regard to college leases by statute 18 Elizabeth C6, which directs that 1/3 of old rent then paid should be for the future reserved in wheat or malt, reserving 1/4 of wheat for each 6 shillings 8 pence, or 1/4 of malt for every 5 shillings, or that the lessees should pay for the same according to the price that wheat and malt should be sold for in the market next adjoining to the respective colleges on the market day before the rent becomes due. This is said to have been an invention of Lord Treasurer Burleigh and Sir Thomas Smith, then Principal Secretary of State, who, observing how greatly the value of money had sunk, and the price of all provisions risen, by the quantity of bullion imported from the New-Found Indies, which effects were likely to increase to a greater degree, devised this method for upholding the revenues of colleges. Their foresight and penetration has in this respect been very apparent, for though rent so reserved in corn was at first but 1/3 of the old rent, or half of what was still reserved in money, yet now the proportion is nearly inverted, and the money arising from the corn rents is communibus annus, almost double to the rents reserved in money. The leases of beneficed clergymen are further restrained, in case of their non-residence, by Statutes 13 Elizabeth C. 20, 14 Elizabeth C. 11, and 18 Elizabeth C. 11, which direct that if any beneficed clergyman be absent from his cure above fourscore days in any 1 year, he shall not only forfeit 1 year's profit of his benefice to be distributed among the poor of the parish, but that all leases made by him, the profits of such benefice, and all covenants and agreements of like nature shall cease and be void, except in the case of licensed pluralists who are allowed to demise the living, on which they are non-resident, to their curates only, provided such curates do not absent themselves above 40 days in any 1 year. And thus much for leases with their several enlargements and restrictions. 5. An exchange is a mutual grant of equal interests, the one in consideration of the other. The word exchange is so individually requisite and appropriated by law to this case that it cannot be supplied by any other word or expressed by any circumlocution. The estates exchanged must be equal in quantity, not of value, for that is immaterial, but of interest, as fee simple for fee simple, a lease for 20 years for a lease for 20 years, and the like. And the exchange may be of things that lie either in grant or in livery. But no livery of season, even in exchanges of freehold, is necessary to perfect the conveyance, for each party stands in the place of the other, and occupies his right, and each of them hath already had corporal possession of his own land. But entry must be made on both sides, for if either party die before entry, the exchange is void for want of sufficient notoriety. And so also, if two parsons, by consent of patron and ordinary, exchange their preferments, and the one is presented, instituted, and inducted, and the other is presented and instituted, but dies before induction, the former shall not keep his new benefice, because the exchange was not completed, and therefore he shall return back to his own. For if, after an exchange of lands or other hereditaments, either party be evicted of those which were taken by him in exchange, through defect of the other's title, he shall return back to the possession of his own, by virtue of the implied warranty contained in all exchanges. 6. A partition is when two or more joint tenants, coparceners, or tenants in common, agree to divide the land so held among them in severalty, each taking a distinct part. Here, as in some instances there is a unity of interest, and in all a unity of possession, it is necessary that they mutually convey and assure to each other by the several estates which they are to take and enjoy separately. By the common law, coparceners, being compellable to make partition, might have made it by parole only, but joint tenants and tenants in common must have done it by deed, and in both cases the conveyance must have been perfected by livery of season. And the statutes of 31 Henry VIII c. 1 and 32 Henry VIII c. 32 made no alteration in this point. But the statute of frauds, 29 Charles II c. 3, hath now abolished this distinction, and made a deed in all cases necessary. These are the several species of primary or original conveyances. Those which remain are of the secondary or derivative sort, which presuppose some other conveyance precedent, and only serve to enlarge, confirm, alter, restrain, restore, or transfer the interest granted by such original conveyance, as 7. Releases, which are a discharge or conveyance of a man's right in lands or tenements to another that hath some former estate in possession. The words generally used therein are remised, released, and forever quit claimed. And these releases may inure either 1. By enlarging an estate, or enlarger de estate, as if there be a tenant for life or years, remainder to another in fee, and he in remainder releases all his right to the particular tenant and his heirs, this gives him the estate in fee. But in this case, the releasee must be in possession of some estate for the release to work upon. For if there be a lessee for years, and, before he enters and is in possession, the lessor releases to him all his right in the reversion, such release is void for want of possession in the releasee. 2. By way of passing an estate, or mitur el estat, as when one of two coparceners releaseth all her right to the other, this passeth the fee simple to the whole. And in both these cases there must be a privity of estate between the relessor and relessee. That is, one of their estates must be so related to the other as to make but one and the same estate in law. 3. By way of passing a right, or mitur de le right. If a man be deceased, and releaseth to his deceaser all his right, hereby the deceaser acquires a new right, which changes the quality of his estate, and renders that lawful which before was tortuous. 4. By way of extinguishment, as if my tenant for life makes a lease to A for life, remainder to B and his heirs, and I release to A. This extinguishes my right to the reversion, and shall inure to the advantage of B's remainder as well as of A's particular estate. 5. By way of entry and fiefment, as if there be two joint deceasers, and the deceasee releases to one of them, he shall be sole seized, and shall keep out his former companion, which is the same in effect as if the deceasee had entered and thereby put an end to the deceasing, and afterwards had enfeoffed one of the deceasers in fee. And hereupon we may observe, that when a man has in himself the possession of lands, he must at the common law convey the freehold by fiefment and livery, which makes a notoriety in the country. But if a man has only a right or a future interest, he may convey that right or interest by a mere release to him that is in possession of the land, for the occupancy of the releasee is a matter of sufficient notoriety already. 8. Confirmation is of a nature nearly allied to release. Sir Edward Coke defines it to be a conveyance of an estate or right in esse, whereby voidable estate is made sure and unavoidable, or whereby a particular estate is increased. And the words of making it are these: have given, granted, ratified, approved, and confirmed. An instance of the first branch of the definition is, if tenant for life leaseth for 40 years, and die during that term, here the lease for years is voidable by him in reversion. Yet, if he hath confirmed the estate of the lessee for years before the death of the tenant for life, it is no longer voidable, but sure. The latter branch, or that which tends to the increase of a particular estate, is the same in all respects with that species of release which operates by way of enlargement. 9. A surrender, sur sum reddito, or rendering up, is of a nature directly opposite to a release. For, as that operates by the greater estates descending upon the less, a surrender is the falling of a less estate into a greater by deed. It is defined, a yielding up of an estate for life or years to him that hath the immediate reversion or remainder, wherein the particular estate may merge or drown by mutual agreement between them. It is done by these words, hath surrendered, granted, and yielded up. The surrenderer must be in possession, and the surrenderee must have a higher estate in which the estate surrendered may merge. Therefore, tenant for life cannot surrender to him in remainder for years. In a surrender there is no occasion for livery of season, for there is a privity of estate between the surrenderer and the surrenderee. The one's particular estate and the other's remainder are one and the same estate, and livery having been once made at the creation of it, there is no necessity for having it afterwards. And, for the same reason, no livery is required on a release or confirmation in fee to tenant for years or at will, though a freehold thereby passes, since the reversion of the relessor or confirmer and the particular estate of the relessee or confirmee are one and the same estate, and where there is already a possession derived from such a privity of estate, any farther delivery of possession would be vain and nugatory. 10. An assignment is properly a transfer or making over to another of the right one has in any estate, but it is usually applied to an estate for life or years. And it differs from a lease only in this, that by a lease one grants an interest less than his own, reserving to himself a reversion. In assignments he parts with the whole property, and the assignee stands to all intents and purposes in the place of the assignor. 11. A defeasance is a collateral deed made at the same time with the feoffment or other conveyance, containing certain conditions upon the performance of which the estate then created may be defeated or totally undone. And in this manner mortgages were in former times usually made, the mortgagor enfeoffing the mortgagee, and at the same time executing a deed of defeasance, whereby the feoffment was rendered void on repayment of the money borrowed at a certain day. And this, when executed at the same time with the original feoffment, was considered as part of it by the ancient law, and therefore only indulged, no subsequent secret revocation of a solemn conveyance, executed by livery of season, being allowed in those days of simplicity and truth, though, when uses were afterwards introduced, a revocation of such uses was permitted by the courts of equity. But things that were merely executory, or to be completed by matters subsequent, as rents of which no season could be had till the time of payment, and so also annuities, conditions, warranties, and the like, were always liable to be recalled by deseasances made subsequent to the time of their creation. End of Chapter 20, Part 4. Chapter 20, Part 5 of the Commentaries on the Laws of England, Book 2, by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines of Alienation by Deed, Part 5. 2. There yet remain to be spoken of some few conveyances which have their force and operation by virtue of the statute of uses. Uses and trusts are in their original of a nature very similar, or rather exactly the same, answering more to the fide commissum than the usus fructus of civil law, which latter was the temporary right of using a thing without having the ultimate property or full dominion of substance. But the fide commissum, which usually was created by will, was the disposal of an inheritance to one, in confidence that he should convey it or dispose of the profits at the will of another. And it was the business of a particular magistrate, the praetor fide commissaris, instituted by Augustus, to enforce the observance of this confidence, so that the right thereby given was looked upon as a vested right, and entitled to a remedy from the court of justice, which occasioned that known division of rights by the Roman law into jus legitimum, a legal right, which was remedied by the ordinary course of law, jus fiduciarum, a right in trust, for which there was a remedy in conscience, and jus precarium, a right in courtesy, for which the remedy was only by entreaty or request. In our law, a use might be ranked under the rights of the second kind, being a confidence reposed in another who was tenant of the land or terra tenent, that he should dispose of the land according to the intentions of cestue que use, or him to whose use it was granted, and suffer him to take the profits. As, if a feoffment was made to A and his heirs, to the use of, or in trust for, B and his heirs, here at the common law, A, the terra tenant, had the legal property and possession of the land, but B, the Chestway que use, was in conscience and equity to have the profits and disposal of it. This notion was transplanted into England from civil law about the close of the reign of Edward III by means of foreign ecclesiastics, who introduced it to evade the statutes of mortmain by obtaining grants of lands not to their religious houses directly, but to the use of the religious houses, which clerical chancellors of those times held to be fide commissa and binding in conscience, and therefore assumed the jurisdiction, which Augustus had vested in his praetor, of compelling the execution of such trusts in the court of chancery. And as it was most easy to obtain such grants from dying persons, a maxim was established that though by law the lands themselves were not divisible, yet if a testator had enfeoffed another to his own use, and so was possessed of the use only, such use was divisible by will. But we have seen how this evasion was crushed in its infancy by Statute 15 Richard II c. 5 with respect to religious houses. Yet, the idea being once introduced, however fraudulently, it afterwards continued to be often innocently, and sometimes very laudably, applied to a number of civil purposes, particularly as it removed the restraint of alienations by will, and permitted the owner of lands in his lifetime to make various designations of their profits as prudence or justice or family convenience might from time to time require. Till at length, during our long wars in France and the subsequent civil commotions between the houses of York and Lancaster, uses grew almost universal, through the desire that men had, when their lives were continually in hazard, of providing for their children by will, and of securing their estates from forfeitures, when each of the contending parties, as they became uppermost, alternately attainted the other. Wherefore, about the reign of Edward IV, before whose time Lord Bacon remarks there are not 6 cases to be found relating to the doctrine of uses, the courts of equity began to reduce them to something of a regular system. Originally it was held that the Chancery could give no relief but against the very person himself entrusted for Chestway que use, and not against his heir or alienee. This was altered in the reign of Henry VI with respect to the heir, and afterwards the same rule, by a parity of reason, was extended to such alienees as had purchased either without a valuable consideration or with an express notice of the use. But a purchaser for a valuable consideration without notice might hold the land discharged of any trust or confidence. And also it was held that neither the king or queen, on account of their dignity royal, nor any corporation aggregate, on account of its limited capacity, could be seized to any use but their own. That is, they might hold the lands, but were not compellable to execute the trust. And, if the fee to uses died without heir, or committed a forfeiture, or married, neither the lord who entered for his escheat or forfeiture, nor the husband who retained the possession as tenant by the courtesy, nor the wife who was assigned her dower, were liable to perform the use, because they were not parties to the trust, but came in by act of law, though doubtless their title in reason was no better than that of the heir. On the other hand, the use itself, or interest of Chestway que use, was learnedly refined upon, with many elaborate distinctions. And 1. It was held that nothing could be granted to a use, whereof the use is inseparable from the possession, as annuities, ways, commons, and authorities, qua ipso usu consumuntur, or whereof the season could not be instantly given. 2. A use could not be raised without a sufficient consideration. For where a man makes a fiefment to another without any consideration, equity presumes that he meant it to the use of himself, unless he expressly declares it to be the use of another, and then nothing shall be presumed contrary to his own expressions. But if either a good or valuable consideration appears, equity will immediately raise a use correspondent to such consideration. 3. Uses were descendable according to the rules of the common law in the case of inheritances in possession. For in this and many other aspects, equita sequitur legem, and cannot establish a different rule of property from that which the law has established. 4. Uses might be assigned by secret deeds between the parties, or be devised by last will and testament. For as the legal estate in the soil was not transferred by these transactions, no livery of season was necessary. And as the intention of the parties was the leading principle in this species of property, any instrument declaring that intention was allowed to be binding in equity. But Chestway que use could not at common law alien the legal interest of the lands without the concurrence of his fifi, to whom he was accounted by law to be only tenant at sufferance. 5. Uses were not liable to any of the feudal burdens, and particularly did not escheat for felony or other defect of the blood. For escheats, etc., are the consequence of tenure, and uses are held of nobody, but the land itself was liable to escheat whenever the blood of the fifi to uses was extinguished by crime or by defect, and the lord, as was before observed, might hold it discharged of the use. 6. No wife could be endowed, or husband have his courtesy of a use, for no trust was declared for their benefit at the original grant of the estate. And therefore it became customary, when most estates were put in use, to settle before marriage some joint estate to the use of the husband and wife for their lives, which was the original of modern jointures. 7. A use could not be extended by writ of elegit or other legal process for debts of chestui que use, for, being merely a creature of equity, the common law, which looked no farther than to the person actually seized of the land, could award no process against it. It is impracticable, upon our present plan, to pursue the doctrine of uses through all the refinements and niceties which the ingenuity of the times, abounding in subtle disquisitions, deduced from this child of the imagination, when once a departure was permitted from the plain simple rules of property established by ancient law. These principal outlines will be fully sufficient to show the ground of Lord Bacon's complaint that this course of proceeding was turned to deceive many of their just and reasonable rights. A man that had cause to sue for land knew not against whom to bring his action, or who was the owner of it. The wife was defrauded of her thirds, the husband of his courtesy, the lord of his wardship, relief, heriot, and escheat, the creditor to his extent for debt, and the poor tenant of his lease. To remedy these inconveniences, abundance of statutes were provided, which made the lands liable to be extended by the creditors of chestui que use, allowed actions for the freehold to be brought against him if in the actual permanency or enjoyment of the profits, made him liable to actions of waste, established his conveyances and leases made without the concurrence of his fee-fees, and gave the lord the wardship of his heir with certain other feudal perquisites. These provisions all tended to consider chestui que use as the real owner of the estate, and at length that idea was carried into full effect by the statute 27 Henry VIII c. 10, which is usually called the statute of uses, or, in conveyances and pleadings, the statute for transferring uses into possession. The hint seems to have been derived from what was done at the accession of King Richard III, who having, when Duke of Gloucester, been frequently made a fee to uses, would upon the assumption of the crown, as the law then understood, have been entitled to hold the lands discharged of the use. But to obviate so notorious an injustice, an act of Parliament was immediately passed, which ordained that, where he had been so in fief jointly with other persons, the land should vest in the other fee-fees, as if he had never been named, and that, where he stood solely enfeoffed, the estate itself should vest in cestuique use in like manner as he had the use. And so the statute of Henry VIII, after reciting the various inconveniences before mentioned and many others, enacts that when any person shall be seized of lands, etc., to the use, confidence, or trust, or any other person or body politic, the person or corporation entitled to the use in fee simple, fee tail, for life, or years, or otherwise, shall from thenceforth stand to be seized or possessed of the land, etc., of and in the like estates as they have in the use, trust, or confidence, and that the estate of the person so seized to uses shall be deemed to be in him or them that have the use in such quality, manner, form, and condition as they had before the use. The statute thus executes the use, as our lawyers term it. That is, it conveys the possession to the use, and transfers the use into possession, thereby making cestuique use complete owner of the lands and tenements, as well at law as in equity. The statute having thus not abolished the conveyance to uses, but only annihilated the intervening estate of the fee, and turning the interest of cestuique use into a legal instead of an equitable ownership, the courts of common law began to take cognizance of uses, instead of sending the party to seek his relief in chancery. And, considering them now as merely a mode of conveyance, very many of the rules before established in equity were adopted with improvements by the judges of the common law. The same persons only were held capable of being seized to a use, the same considerations were necessary for raising it, and it could only be raised of the same hereditaments as formerly. But as the statute, the instant it was raised, converted it into an actual possession of the land, a great number of these incidents that formerly attended it in its fiduciary state were now at an end. The land could not escheat or be forfeited by the act or defect of the fee, nor be alien to any purchaser discharged of the use, nor be liable to dower or courtesy on account of the season of such fee, because the legal estate never rests in him for a moment, but is instantaneously transferred to cestuique use as soon as the use is declared. And, as the use and the land were now convertible terms, they became liable to dower, courtesy, and escheat, in consequence of the season of cestuique use, who were now become the terra tenant also, and they likewise were no longer divisible by will. The various necessities of mankind induced also the judges very soon to depart from the rigor and simplicity of the rules of the common law, and to allow a more minute and complex construction upon conveyances to uses than upon others. Hence it was adjudged that the use need not always be executed the instant the conveyance is made, but if it cannot take effect at that time, the operation of the statute may wait till the use shall arise upon some future contingency, to happen within a reasonable period of time, and in the meanwhile the ancient use shall remain in the original grantor, as, when lands are conveyed to the use of A and B, after a marriage shall be had between them, or to the use of A and his heirs till B shall pay him a sum of money, and then to the use of B and his heirs. Which doctrine, when devices by will were again introduced, and considered as equivalent in point of construction to declarations of uses, was also adopted in favor of executory devices. But herein these, which are called contingent or springing uses, differ from an executory device, in that there must be a person seized to such uses at the time when the contingency happens, else they can never be executed by the statute, and therefore, if the estate of the fee to such use be destroyed by alienation or otherwise, before the contingency arises, the use is destroyed forever, whereas by executory device, the freehold itself is transferred to the future devotee. And, In both these cases, a fee may be limited to take effect after a fee, because, though it was forbidden by the common law in favor of the lord's escheat, yet, when the legal estate was not extended beyond one fee simple, such subsequent uses, after a use in fee, were before the statute permitted to be limited in equity, and then the statute executed the legal estate in the same manner as the use before subsisted. It was also held that a use, though executed, may change from one to another by circumstances, ex post facto, as, if A makes a fiefment to the use of his intended wife and her eldest son for their lives, upon the marriage the wife takes the whole use in severalty, and upon the birth of a son, the use is executed jointly in them both. This was sometimes called a secondary, sometimes a shifting use. And whenever the use limited by the deed expires or cannot vest, it returns back to him who raised it after such expiration or such impossibility, and is styled a resulting use. As, if a man makes a fiefment to the use of his intended wife for life, with remainder to the use of her firstborn son in tail, here, till he marries, the use results back to himself. After marriage, it is executed in the wife for life. If she dies without issue, the whole results back to him in fee. It was likewise held that uses originally declared may be revoked at any future time, and new uses be declared of the land, provided the grantor reserved to himself such a power at the creation of the estate. Whereas the utmost that the common law would allow was a deed of defeasance coeval with the grant itself, and therefore esteemed part of it, upon events specifically mentioned. And, in case of such a revocation, the old uses were instantly to cease, and the new ones to become executed in their stead. And this was permitted partly to indulge the convenience, and partly the caprice of mankind, who, as Lord Bacon observes, have always affected to have the disposition of their property revocable in their own time, and irrevocable ever afterwards. By this equitable train of decisions in the courts of law, the power of the court chancery over landed property was greatly curtailed and diminished. But one or two technical scruples, which the judges found it hard to get over, restored it with tenfold increase. They held in the first place that no use could be limited on a use, and that when a man bargains and sells his land for money, which raises a use by implication to the bargainee, the limitation of a farther use to another person is repugnant and therefore void. And therefore, on a fiefment to A and his heirs, to the use of B and his heirs, in trust for C and his heirs, they held that the statute executed only in the first use, and that the second was a mere nullity, not adverting that the instant the first use was executed in B, he became seized to the use of C, which second use the statute might as well be permitted to execute as it did the first. And so the legal estate might be instantaneously transmitted down through 100 uses upon uses, till finally executed in the last cesue que use. Again, as the statute mentions only such persons as were seized to the use of others, this was held not to extend to terms of years or other chattel interests, whereof the termor is not seized, but only possessed, and therefore, if a term of 1,000 years be limited to A, to the use of or in trust for B, the statute does not execute this use, but leaves it as at common law. And lastly, by more modern resolutions, where lands are given to one and his heirs, in trust to receive and pay over the profits to another, this use is not executed by the statute, for the land must remain in the trustee to enable him to perform the trust. End of Chapter 20, Part 5. Chapter 20, Part 6 of the Commentaries on the Laws of England, Book 2, by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Of Alienation by Deed, Part 6. Of the two more ancient distinctions the courts of equity quickly availed themselves. In the first case, it was evident that B was never intended by the parties to have any beneficial interest, and, in the second, the gestque que use of the term was expressly driven into the Court of Chancery to seek his remedy, and therefore the court determined that though these were not uses which the statute could execute, yet still they were trusts in equity, which in conscience ought to be performed. To this the reason of mankind assented, and the doctrine of uses was revived under the denomination of trusts. And thus, by this strict construction of the courts of law, a statute made upon great deliberation, and introduced in the most solemn manner, has had little other effect than to make a slight alteration in the formal words of a conveyance. However, the courts of equity, in the exercise of this new jurisdiction, have widely avoided in great degree those mischiefs which made uses intolerable. They now consider a trust estate, either when expressly declared or resulting by necessary implication, as equivalent to the legal ownership, governed by the same rules of property, and liable to every charge in equity which the other is subject to in law. And, by a long series of uniform determinations, for now near a century past, with some assistance from the legislature, they have raised a new system of rational jurisprudence, by which trusts are made to answer in general all the beneficial ends of uses without their inconvenience or frauds. The trustee is considered merely as the instrument of conveyance, and can in no shape affect the estate, unless by alienation for a valuable consideration to a purchaser without notice, which, as gestque que use is generally in possession of the land, is a thing that can rarely happen. The trust will descend, may be aliened, is liable to debts, to forfeiture, to leases and other encumbrances, nay, even to the courtesy of the husband, as if it were an estate at law. It has not yet indeed been subject to dower, more from a cautious adherence to some hasty precedents than from any well-grounded principle. It hath also been held not liable to escheat to the Lord, in consequence of attainder or want of heirs, because the trust could never be intended for his benefit. But let us now return to the statute of uses. The only service, as was before observed, to which this statute is now consigned, is in giving efficacy to certain new and secret species of conveyances, introduced in order to render transactions of this sort as private as possible, and to save the trouble of making livery of season, the only ancient conveyance of corporeal freeholds, the security and notoriety of which public investiture abundantly overpaid the labor of going to the land, or of sending an attorney in one's stead. But this now has given way to 12. A 12th species of conveyance, called a covenant to stand seized to uses, by which a man, seized of lands, covenants, in consideration of blood or marriage, that he will stand seized of the same to the use of his child, wife, or kinsman, for life, in tail, or in fee. Here the statute executes at once the estate, for the party intended to be benefited, having thus acquired the use, is thereby put at once into corporal possession of the land, without ever seeing it, by a kind of parliamentary magic. But this conveyance can only operate when made upon such weighty and interesting considerations as those of blood or marriage. 13. A 13th species of conveyance, introduced by this statute, is that of a bargain and sale of lands, which is a kind of a real contract, whereby the bargainor for some pecuniary consideration bargains and sells, that is, contracts to convey, the land to the bargainee, and becomes by such bargain a trustee for, or sees to the use of, the bargainee, and then the statute of uses completes the purchase, or, as it has been well expressed, the bargain first vests the use, and then the statute vests the possession. But as it was foreseen that conveyances, thus made, would want all those benefits of notoriety which the old common law assurances were calculated to give, to prevent, therefore, clandestine conveyances of freeholds, it was enacted in the same session of Parliament, by statute 27 Henry VIII. c. 16, that such bargains and sales should not inure to pass a freehold, unless the same is made by indenture and enrolled within 6 months in one of the courts of Westminster Hall, or with the custos rotulorum of the county. Clandestine bargains and sales of chattel interests, or lease for years, were thought not worthy of regarding, as such interests were very precarious till about 6 years before, which also occasioned them to be overlooked in framing this statute of uses, and therefore such bargains and sales were not directed to be enrolled. But how impossible it is to foresee and provide against all the consequences of innovations. This omission has given rise to 14. A 14th species of conveyance, viz., by lease and release, first invented by Sergeant Moore soon after the statute of uses, and now the most common of any, and therefore not to be shaken, though very great lawyers, as particularly Mr. Noy, have formerly doubted its validity. It is thus contrived. A lease, or rather a bargain and sale, upon some pecuniary consideration, for 1 year, is made by the tenant of the freehold to the lessee or bargainee. Now this, without any enrollment, makes the bargainer stand seized to the use of the bargainee, and vests in the bargainee the use of the term for a year, and then the statute immediately annexes the possession. He therefore, being thus in possession, is capable of receiving a release of the freehold and reversion, which, we have seen before, must be made to a tenant in possession, and accordingly the next day a release is granted to him. This is held to supply the place of livery of season, and so a conveyance by lease and release is said to amount to a fiefment. 15. To these may be added deeds to lead or declare the uses of other more direct conveyances, as fiefments, fines, and recoveries, of which we shall speak in the next chapter, and 16. Deeds of revocation of uses, hinted at in a former page and founded in a previous power, reserved at the raising of the uses, to revoke such as were then declared, and to appoint others in their stead, which is incident to the power of revocation. And this may suffice for a specimen of conveyances founded upon the statute of uses, and will finish our observations upon such deeds as serve to transfer real property. Before we conclude, it will not be improper to subjoin a few remarks upon such deeds as are used not to convey, but to charge or encumber lands and discharge them again, of which nature are obligations or bonds, recognizances, and defeasances upon them both. 1. An obligation or bond is a deed, whereby the obliger obliges himself, his heirs, executors, and administrators to pay a certain sum of money to another at a day appointed. If this be all, the bond is called a single one, simplex obligatio. But there is generally a condition added, that if the obliger does some particular act, the obligation shall be void, or else shall remain in full force, as payment of rent, performance of covenants in a deed, or repayment of a principal sum of money borrowed of the obligee, with interest, which principal sum is usually 1/2 of the penal sum specified in the bond. In case this condition is not performed, the bond becomes forfeited or absolute at law, and charges the obliger while living, and after his death the obligation descends upon his heir, who, on defect of personal assets, is bound to discharge it, provided he has real assets by descent as a recompense, so that it may be called, though not a direct, yet a collateral charge upon the lands. How it affects the personal property of the obliger will be more properly considered hereafter. If the condition of a bond be impossible at the time of making it, or be to do a thing contrary to some rule of law that is merely positive, or be uncertain or insensible, the condition alone is void, and the bond shall stand single and unconditional. For it is the folly of the obliger to enter into such an obligation from which he can never be released. If it be to do a thing that is malum in se, the obligation itself is void, for the whole is an unlawful contract, and the obligee shall take no advantage from such a transaction. And if the condition be possible at the time of making it, and afterwards becomes impossible by the act of God, the act of law, or the act of the obligee himself, there the penalty of the obligation is saved, for no prudence or foresight of the obliger could guard against such a contingency. On the forfeiture of a bond, or its becoming single, the whole penalty was recoverable at law. But here the courts of equity interposed, and would not permit a man to take more than in conscience he ought, viz., his principal, interest, and expenses, in case the forfeiture accrued by non-payment of money borrowed, the damages sustained upon non-performance of covenants, and the like. And the statute 4 and 5 and c. 16 hath also enacted in the same spirit of equity, that in case of a bond conditioned for the payment of money, the payment or tender of the principal sum due, with interest and costs, even though the bond be forfeited, and a suit commenced thereon, shall be a full satisfaction and discharge. 2. A recognizance is an obligation of record, which a man enters into before some court of record or magistrate duly authorized, with condition to do some particular act, as to appear at the assizes, to keep the peace, to pay a debt, or the like. It is in most respects like another bond, the difference being chiefly this, that the bond is the creation of a fresh debt or obligation de novo. The recognizance is an acknowledgment of a former debt upon record. The form whereof is that A.B. doth acknowledge to owe to our lord the king, to the plaintiff, to C.D. or the like, the sum of £10, with condition to be void on performance of the things stipulated, in which case the king, the plaintiff, C.D., etc., is called the cognizee, is a qui cognoscitur, as he that enters into the recognizance is called the cognizer, is qui cognoscit. This being either certified to or taken by the officer of some court, is witnessed only by the record of that court, and not by the party's seal, so that it is not in strict propriety a deed, though the effects of it are greater than the common obligation, being allowed a priority in point of payment, and binding the lands of the cognizer from the time of enrollment on record. There are also other recognizances of a private kind, in nature of a statute of staple, by virtue of the statute 23 Henry VIII c. 6, which have already been explained, and shown to be a charge upon real property. 3. A defeasance on a bond or recognizance, or judgment recovered, is a condition which, when performed, defeats or undoes it, in the same manner as a defeasance of an estate before mentioned. It differs only from the common condition of a bond, in that the one is always inserted in the deed or bond itself. The other is made by the same parties by a separate and frequently subsequent deed. This, like the condition of a bond when performed, discharges and disencumbers the estate of the obliger. These are the principal species of deeds or matter en pais by which estates may be either conveyed or at least affected. among which the conveyances to uses are by much the most frequent of any, though in these there is certainly one palpable defect, the want of sufficient notoriety, so that purchasers or creditors cannot know with any absolute certainty what the estate and the title to it in reality are, upon which they are to lay out or lend their money. In the ancient feudal method of conveyance, by giving corporal seizin of the lands, this notoriety was in some measure answered, but all the advantages resulting from thence are now totally defeated by the introduction of death-bed devices and secret conveyances, and there has never been yet any sufficient guard provided against fraudulent charges and encumbrances since the disuse of the old Saxon custom of transacting all conveyances at the county court, and entering a memorial of them in the charterly or ledger book of some ancient monastery, and in the failure of the general register established by King Richard I, the mortgages made to Jews in the Capitula de Judaeus, of which Hoveden has a preserved copy. How far the establishment of like general register for deeds and wills and other acts affecting real property would remedy this inconvenience deserves to be well considered. In Scotland, every act and event regarding the transmission of property is regularly entered upon record, and some of our own provisional divisions, particularly the extended county of York and the populous county of Middlesex, have prevailed with the legislatures to create such registers in their several districts. But, however plausible these provisions may appear in theory, it hath been doubted by very competent judges whether more disputes have not arisen in those counties by the inattention and omissions of the parties than prevented by the use of registers. End of Chapter 20, Part 6. Chapter 21, Part 1 of the Commentaries on the Laws of England, Book 2, by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Of Alienation by Matter of Record, Part 1. Assurances by matter of record are such as do not entirely depend on the act or consent of the parties themselves, but the sanction of a court of record is called in, to substantiate, preserve, and be the perpetual testimony of the transfer of property from one man to another, or of its establishment when already transferred. Of this nature are 1. Private acts of Parliament, 2. The King's grants, 3. Fines, 4. Common recoveries. 1. Private acts of Parliament are, especially of late years, become a very common mode of assurance. For it may sometimes happen that by the ingenuity of some, and the blunders of other practitioners, an estate is most grievously entangled by a multitude of contingent remainders, resulting trusts, springing uses, executory devices, and the like artificial contrivances, a confusion unknown to the simple conveyances of the common law, so that it is out of the power of either the courts of law or equity to relieve the owner. Or it may sometimes happen that, by the strictness or omissions of family settlements, the tenant of the estate is abridged of some reasonable power, as letting leases, making a jointure for a wife, or the like, which power cannot be given him by the ordinary judges either in common law or equity. Or it may be necessary, in settling an estate, to secure it against the claims of infants or other persons under legal disabilities, who are not bound by any judgments or decrees of the ordinary courts of justice. In these or other cases of the like kind, the transcendent power of Parliament is called in to cut the Gordian knot, and by a particular law, enacted for this very purpose, to unfetter an estate, to give its tenant reasonable powers, or to assure it to a purchaser, against the remote or latent claims of infants or disabled persons, by settling a proper equivalent in proportion to the interest so barred. This practice was carried to great length in the years succeeding the Restoration, by setting aside many conveyances alleged to have been made by constraint or in order to screen the estates from being forfeited during the usurpation. And at last it proceeded so far that, as the noble historian expressed it, every man had raised an equity in his own imagination that he thought ought to prevail against any descent, testament, or act of law, and to find relief in Parliament, which occasioned the king at the close of the session to remark that the good old rules of law were the best security, and to wish that men might not have too much cause to fear that the settlements which they make of their estates shall be too easily unsettled when they are dead by the power of Parliament. Acts of this kind are, however, at present carried on in both houses with great deliberation and caution. Particularly in the House of Lords, they are usually referred to two judges to examine and report the facts alleged, and to settle all technical forms. Nothing also is done without the consent expressly given of all parties in being incapable of consent that have the remotest interest in the matter, unless such consent shall appear to be perversely and without any reason withheld. And, as was before hinted, an equivalent in money or other estate is usually settled upon infants, or persons not in esse, or not in capacity to act for themselves, who are to be concluded by this act. And the general saving is constantly added at the close of the bill, of the right and interest of all persons whatsoever, except those whose consent is so given or purchased, and who are therein particularly named. A law thus made, though it binds all parties to the bill, is yet looked upon rather as a private conveyance than a solemn act of the legislature. It is not therefore allowed to be public, but a mere private statute. It is not printed or published among the other laws of the session. It hath been relieved against, when obtained upon fraudulent suggestions, and no judge or jury is bound to take notice of it, unless the same is specially set forth and pleaded to them. It remains, however, enrolled among the public records of the nation, to be forever preserved as a perpetual testimony of the conveyance or assurance so made or established. 2. The king's grants are also a matter of public record. For, as Saint Germain says, the king's excellency is so high in the law that no freehold may be given to the king, nor derived from him, but by matter of record. And to this end a variety of offices are erected, communicating in a regular subordination one with another, through which all the king's grants must pass, and be transcribed and enrolled, that the same may be narrowly inspected by his officers, who will inform him if anything contained therein is improper or unlawful to be granted. These grants, whether of lands, honors, liberties, franchises, or aught besides, are contained in charters or letters patent, that is, open letters, litterae patentes, so called because they are not sealed up, but exposed to open view with great seal pendant at the bottom, and are usually directed or addressed by the king to all his subjects at large. And therein they differ from certain other letters of the king, sealed also with his great seal, but directed to particular persons and for particular purposes, which therefore, not being proper for public inspection, are closed up and sealed on the outside, and thereupon called writs close, literae closae, and are recorded in the close rolls, in the same manner as the others are in the patent rolls. Grants or letters patent must first pass by bill, which is prepared by the Attorney and Solicitor General in consequence of a warrant from the Crown, and is then signed, that is, superscribed at the top with the King's own sign manuel, and sealed with his privy signet, which is always in the custody of the principal Secretary of State, and then sometimes it immediately passes under the Great Seal, in which case the patent is subscribed in these words, per ipsum regem, by the king himself. Otherwise, the course is to carry an extract of the bill to the keeper of the privy seal, who makes out a writ or warrant thereupon to the chancery, so that the signed manual is the warrant to the privy seal, and the privy seal is the warrant to the great seal, and in this last case the patent is subscribed per breve de privato sigillo, by writ of privy seal. But there are some grants which only pass through certain offices, as the Admiralty or Treasury, in consequence of a signed manual, without the confirmation of either the signet, the great, or the privy seal. The manner of granting by the king does not more differ from that by a subject than the construction of his grants when made. 1. A grant made by the king, at the suit of the grantee, shall be taken most beneficially for the king and against the party, whereas the grant of a subject is construed most strongly against the grantor. Wherefore, it is usual to insert in the king's grants that they are made not by the suit of the grantee, but ex speciali Graecia, certa scientia, et mero motu regis, and then they have a more liberal construction. 2. A subject's grant shall be construed to include many things besides what are expressed, if necessary for the operation of the grant. Therefore, if a private grant of the profits of the land for 1 year, free ingress, egress, and regress to cut and carry away those profits are also inclusively granted, and if a fiefment of land be made to a lord to his villain, this operated as a manumission, for he was otherwise unable to hold it. But the king's grant shall not inure to any other intent than that which is precisely expressed in the grant. As, if he grants land to an alien, it operates nothing, for such grant shall not also inure to make him a denizen, that so he may be capable of taking by grant. 3. When it appears from the face of the grant that the king is mistaken or deceived, either in matter of fact or matter of law, as in case of false suggestion, misinformation, or misrecital of former grants, or if his own title to the thing granted be different from what he supposes, or if the grant be informal, or if he grants an estate contrary to the rules of law, in any of these cases the grant is absolutely void. For instance, if the king grants lands to one of his heirs male, this is merely void, for it shall not be an estate tale, because there want words of procreation, to ascertain the body out of which the heir shall issue. Neither is it a fee simple, as in common grants it would be, because it may be reasonably supposed that the king meant to give no more than an estate tale. The grantee is therefore, if anything, nothing more than tenant at will. And, to prevent deceits of the king, with regard to the value of the estate granted, it is particularly provided by the statute 1 Henry IV. c. 6, that no grant of his shall be good, unless, in the grantee's petition for them, express mention be made of the real value of the lands. 3. We are next to consider a very usual species of assurance, which is also of record, viz., a fine of lands and tenements, in which it will be necessary to explain 1. The nature of a fine, 2. Its several kinds, and 3. Its force and effect. 1. A fine is sometimes said to be a fiefment of record, though it might with more accuracy be called an acknowledgment of a fiefment on record, by which it is to be understood that it has at least the same force and effect with a fiefment in the conveying and assuring of lands, though it is one of those methods of transferring estates of freehold by the common law, in which livery of season is not necessary to be actually given, the supposition and acknowledgment thereof in a court of record, however fictitious, inducing an equal notoriety. But more particularly, a fine may be described to be an amicable composition or agreement of a suit, either actual or fictitious, by leave of the king or his justices, whereby the lands in question become, or are acknowledged to be, the right of one of the parties. In its original, it was founded on an actual suit, commenced at law for recovery of the possession of land, and the possession thus gained by such composition was found to be so sure and effectual that fictitious actions were, and continue to be, every day commenced for the sake of obtaining the same security. A fine is so called because it puts an end not only to the suit thus commenced, but also to all other suits and controversies concerning the same matter. Or, as it is expressed in an ancient record of Parliament, 18 Edward I, non in regni Angliae providetur, vel est aliqua securitas major vel selenior, per quam aliqua statium certiorem abere possit, nesque ad statum sum verificandum aliquid solenius testimonium producere, quam finem in curia domani legislavatum, qui quidem finis sic vocator, eo quod finis et consummatio omnium placitorum esse debet, ed hac de causa providebator. Fines indeed are of equal antiquity with the first rudiments of the law itself, are spoken by Glanville and Bracton in the reigns of Henry II and Henry III, as things then well known and long established, and instances have been produced of them even before the Norman invasion. So that the statute 18 Edward I, called Modus Lavandi Fines, did not give them original, but only declared and regulated the manner in which they should be levied or carried on. And that is as follows. 1. The party to whom the land is to be conveyed or assured commences an action or suit at law against the other, generally an action of covenant, by suing out a writ or praecipi, called a writ of covenant, the foundation of which is a supposed agreement or covenant, that one shall convey the lands to the other, on the breach of which agreement the action is brought. On this writ there is due the king, by ancient prerogative, a premier fine, or a noble for every 5 marks of land sued for, that is, 1/10 of the annual value. The suit being thus commenced, then follows 2. The licentia cordandi, or leave to agree the suit. For as soon as the action is brought, the defendant, knowing himself to be in the wrong, is supposed to make overtures of peace and accommodation to the plaintiff, who, accepting them, but having, upon suing out the writ, given pledges to prosecute his suit, which he endangers if he now deserts it without license, he therefore applies to the court for leave to make the matter up. This leave is readily granted, but for it there is also another fine due to the king by his prerogative, which is an ancient revenue of the crown, and is called the king's silver, or sometimes the post fine, with respect to the premier fine before mentioned. And it is as much as the premier fine, and half as much more, or 10 shillings for every 5 marks of land, that is, 3/20ths of the supposed annual value. 3. Next comes the concord or agreement itself, after leave obtained from the court, which is usually an acknowledgment from the deforcients, or those who keep the other out of possession, that the lands in question are the right of the complainant. And from this acknowledgment or recognition of right, the party levying the fine is called the cognizor, and he to whom it is levied the cognizee. This acknowledgment must be made either openly in the Court of Common Pleas, or before one of the judges of that court, or else before commissioners in the country, empowered by a special authority called a writ of dedimus potestatem, which judges and commissioners are bound by statute 18 Edward I, ft. 4, to take care that cognizers be of full age, sound memory, and out of prison. If there be any femme covert among the cognizers, she is privately examined whether she does it willingly and freely, or by compulsion of her husband. By these acts all the essential parts of a fine are completed, and, if the cognizer dies the next moment after the fine is acknowledged, provided it be subsequent to the day on which the writ is made returnable, still the fine shall be carried on in all its remaining parts, of which the next is 4. The note of the fine, which is only an abstract of the writ of covenant and the concord, naming the parties, the parcels of land, and the agreement. This must be enrolled of record in the proper office by direction of statute 5 Henry V. c. 14. 5. The fifth part is the foot of the fine, or conclusion of it, which includes the whole matter, reciting the parties, day, year, and place before whom it was acknowledged or levied. Of this there are indentures made or engrossed at the chirographer's office, and delivered to the cognizor and the cognizee, usually beginning thus: Haec est finalis concordia. This is the final agreement, and then reciting the whole proceeding at length, and thus the fine is completely levied at common law. By several statutes still more solemnities are superadded, in order to render the fine more universally public and less liable to be levied by fraud or covin. And, first, by 27 Edward I. c. 1, the note of the fine shall be openly read in the Court of Common Pleas, at 2 several days in 1 week, and during such reading all pleas shall cease. By 5 Henry IV. c. 14, and 23 Elizabeth c. 3, all the proceedings on fines, either at the time of acknowledgment or previous or subsequent thereto, shall be enrolled of record in the Common Court of Pleas. By 1 Richard III. c. 7, confirmed and enforced by 4 Henry VII. c. 24, the fine, after engrossment, shall be openly read and proclaimed in court 16 times, viz., 4 times in the term in which it was made, and 4 times in each of the 3 succeeding terms, during which time all pleas shall cease. But this is reduced to once in each term by 31 Elizabeth c. 2, and these proclamations are endorsed on the back of the record. It is also enacted by 23 Elizabeth c. 3 that the chirographer of fines shall every term write out a table of the fines levied in each county in that term, and shall affix them in some open part of the Court of Common Pleas all the next term, and shall also deliver the contents of such table to the sheriff of every county, who shall at the next affix the same in some open place in the court for the more public notoriety of the fine. Fines thus levied are of 4 kinds. What in our French law is called a fine sur cognizance des droits commerciaux qu'il a descendant, or a fine upon acknowledgment of the right of the cognizee as that which he hath of the gift by the cognizor. This is the best and surest kind of fine, for thereby the deforcient, in order to keep his covenant with the plaintiff, of conveying to him the lands in question, and at the same time to avoid the formality of an actual fiefment and livery, acknowledges in court a form of fiefment, or gift in possession, to have been made by him to the plaintiff. This fine is therefore said to be a fiefment of record, the livery thus acknowledged in court being equivalent to an actual livery, so that this assurance is rather a confession of a former conveyance than a conveyance now originally made, for the deforcient or cognizor acknowledges cognoscit, the right to be in the plaintiff or cognizee as that which he hath descendant of the proper gift of himself, the cognizor. 2. A fine sur cognizance de droit tantun, or upon acknowledgment of the right merely, not with the circumstance of a preceding gift from the cognizor. This is commonly used to pass a reversionary interest which is in the cognizor. For such reversions there can be no fiefment or donation with livery supposed, as the possession during the particular estate belongs to a third person. It is worded in this manner: that the cognizor acknowledges the right to be in the cognizee, and grants for himself and his heirs that the reversion, after the particular estate determines, shall go to the cognizee. 3. A fine for concessit is where the cognizor, in order to make an end of disputes, though he acknowledges no precedent right, yet grants to the cognizee an estate de novo, usually for life or years, by way of supposed composition. And this may be done reserving a rent or the like, for it operates as a new grant. 4. A fine sur dun grante render is a double fine, comprehending the fine sur cognizance de droit comme eo, etc., and the fine sur concessit, and may be used to create particular limitations of estate, whereas the fine sur cognizance de droit comme eo, etc., conveys nothing but an absolute estate, either of inheritance or at least of freehold. In this last species of fine, the cognizee, after the right is acknowledged to be in him, grants back again, or renders to the cognizor, or perhaps to a stranger, some other estate in the premises. But in general, the first species of fine, sur cognizance de droit comme eo, etc., is the most used, as it conveys a clean and absolute freehold, and gives the cognizee a season in law without any actual livery, and is therefore called a fine executed, whereas the others are but executory. End of chapter 21, part 1.